The Spirit of Laws. Montesquieu. Book 11. Of the laws which establish political liberty, with regard to the Constitution. 1. A general idea. I make a distinction between the laws that establish political liberty, as it relates to the Constitution, and those by which it is established, as it relates to the citizen. The former shall be the subject of this book, the latter I shall examine in the next. 2. Different significations of the word liberty. There is no word that admits of more various significations, and has made more varied impressions on the human mind, than that of liberty. Some have taken it as a means of deposing a person on whom they had conferred a tyrannical authority, others for the power of choosing a superior whom they are obliged to obey, others for the right of bearing arms, and of being thereby enabled to use violence, others, in fine, for the privilege of being governed by a native of their own country, or by their own laws. A certain nation for a long time thought liberty consisted in the privilege of wearing a long beard. Some have annexed this name to one form of government exclusive of others. Those who had a republican taste applied it to this species of polity, those who liked a monarchical state gave it to monarchy. Thus they have all applied the name of liberty to the government most suitable to their own customs and inclinations, and as in republics the people have not so constant and so present a view of the causes of their misery, and as the magistrates seem to act only in conformity to the laws, hence liberty is generally said to reside in republics, and to be banished from monarchies. In fine, as in democracies the people seem to act almost as they please, this sort of government has been deemed the most free, and the power of the people has been confounded with their liberty. 3. In what liberty consists? It is true that in democracies the people seem to act as they please, but political liberty does not consist in an unlimited freedom. In governments, that is, in societies directed by laws, liberty can consist only in the power of doing what we ought to will, and in not being constrained to do what we ought not to will. We must have continually present to our minds the difference between independence and liberty. Liberty is a right of doing whatever the laws permit, and if a citizen could do what they forbid he would be no longer possessed of liberty, because all his fellow citizens would have the same power. 4. The same subject continued. Democratic and aristocratic states are not in their own nature free. Political liberty is to be found only in moderate governments, and even in these it is not always found. It is there only when there is no abuse of power. But constant experience shows us that every man invested with power is apt to abuse it, and to carry his authority as far as it will go. Is it not strange, though true, to say that virtue itself has need of limits? To prevent this abuse, it is necessary from the very nature of things that power should be a check to power. A government may be so constituted, as no man shall be compelled to do things to which the law does not oblige him, nor forced to abstain from things which the law permits. 5. Of the end or view of different governments. Though all governments have the same general end, which is that of preservation, yet each has another particular object. Increase of dominion was the object of Rome, war, that of Sparta, religion, that of the Jewish laws. Commerce, that of Marseilles, public tranquility, that of the laws of China, navigation, that of the laws of Rhodes, natural liberty, that of the policy of the savages, in general, the pleasures of the prince, that of despotic states, that of monarchies, the princes and the kingdom's glory, the independence of individuals is the end aimed at by the laws of Poland, thence results the oppression of the whole. One nation there is also in the world that has for the direct end of its constitution political liberty. We shall presently examine the principles on which this liberty is founded. If they are sound, liberty will appear in its highest perfection. To discover political liberty in a constitution, no great labor is requisite. If we are capable of seeing it where it exists, it is soon found, and we need not go far in search of it. 6. Of the Constitution of England. In every government there are three sorts of power: the legislative, the executive in respect to things dependent on the law of nations, and the executive in regard to matters that depend on the civil law. By virtue of the first, the prince or magistrate enacts temporary or perpetual laws and amends or abrogates those that have been already enacted. By the second, he makes peace or war, sends or receives embassies, establishes the public security, and provides against invasions. By the third, he punishes criminals, or determines the disputes that arise between individuals. The latter we shall call the judiciary power, and the other simply the executive power of the state. The political liberty of the subject is a tranquility of mind arising from the opinion each person has of his safety. In order to have this liberty, it is requisite the government be so constituted as one man need not be afraid of another. When the legislative and executive powers are united in the same person, or in the same body of magistrates, there can be no liberty, because apprehensions may arise, lest the same monarch or senate should enact tyrannical laws, to execute them in a tyrannical manner. Again, there is no liberty, if the judiciary power be not separated from the legislative and executive. Were it joined with the legislative, the life and liberty of the subject would be exposed to arbitrary control, for the judge would be then the legislator. Were it joined to the executive power, the judge might behave with violence and oppression. There would be an end of everything, were the same man or the same body, whether of the nobles or of the people, to exercise those three powers, that of enacting laws, that of executing the public resolutions, and of trying the causes of individuals. Most kingdoms in Europe enjoy a moderate government because the prince who is invested with the two first powers leaves the third to his subjects. In Turkey, where these three powers are united in the sultan's person, the subjects groan under the most dreadful oppression. In the republics of Italy, where these three powers are united, there is less liberty than in our monarchies. Hence their government is obliged to have recourse to as violent methods for its support as even that of the Turks, witness the state inquisitors, and the lion's mouth into which every informer may at all hours throw his written accusations. In what a situation must the poor subject be in those republics? The same body of magistrates are possessed, as executors of the laws, of the whole power they have given themselves in quality of legislators. They may plunder the state by their general determinations, and as they have likewise the judiciary power in their hands, every private citizen may be ruined by their particular decisions. The whole power is here united in one body, and though there is no external pomp that indicates a despotic sway, yet the people feel the effects of it every moment. Hence it is that many of the princes of Europe, whose aim has been leveled at arbitrary power, have constantly set out with uniting in their own persons all the branches of magistracy, and all the great offices of state. I allow indeed that the mere hereditary aristocracy of the Italian republics does not exactly answer to the despotic power of the Eastern princes. The number of magistrates sometimes moderates the power of the magistracy, the whole body of the nobles do not always concur in the same design, and different tribunals are erected, that temper each other. Thus at Venice the legislative power is in the council, the executive in the pregati, and the judiciary in the quarantia. But the mischief is, that these different tribunals are composed of magistrates all belonging to the same body, which constitutes almost one and the same power. The judiciary power ought not to be given to a standing senate, it should be exercised by persons taken from the body of the people at certain times of the year, and consistently with a form and manner prescribed by law, in order to erect a tribunal that should last only so long as necessity requires. By this method the judicial power, so terrible to mankind, not being annexed to any particular state or profession, becomes, as it were, invisible. People have not then the judges continually present to their view, they fear the office, but not the magistrate. In accusations of a deep and criminal nature, it is proper the person accused should have the privilege of choosing, in some measure, his judges, in concurrence with the law, or at least he should have a right to accept against so great a number that the remaining part may be deemed his own choice. The other two powers may be given rather to magistrates or permanent bodies, because they are not exercised on any private subject, one being no more than the general will of the state, and the other the execution of that general will. But though the tribunals ought not to be fixed, the judgments ought, and to such a degree as to be ever conformable to the letter of the law. Were they to be the private opinion of the judge, people would then live in society, without exactly knowing the nature of their obligations. The judges ought likewise to be of the same rank as the accused, or, in other words, his peers, to the end that he may not imagine he is fallen into the hands of persons inclined to treat him with rigor. If the legislature leaves the executive power in possession of a right to imprison those subjects who can give security for their good behavior, there is an end of liberty, unless they are taken up, in order to answer without delay to a capital crime, in which case they are really free, being subject only to the power of the law. But should the legislature think itself in danger by some secret conspiracy against the state, or by a correspondence with a foreign enemy, it might authorize the executive power, for a short and limited time, to imprison suspected persons, who in that case would lose their liberty only for a while, to preserve it forever. And this is the only reasonable method that can be substituted to the tyrannical magistracy of the Ephori, and to the state inquisitors of Venice, who are also despotic. As in a country of liberty, every man who is supposed a free agent ought to be his own governor, the legislative power should reside in the whole body of the people. But since this is impossible in large states, and in small ones is subject to many inconveniences, it is fit the people should transact by their representatives what they cannot transact by themselves. The inhabitants of a particular town are much better acquainted with its wants and interests than with those of other places, and are better judges of the capacity of their neighbors than of that of the rest of their countrymen. The members, therefore, of the legislature should not be chosen from the general body of the nation, but it is proper that in every considerable place a representative should be elected by the inhabitants. The great advantage of representatives is their capacity of discussing public affairs. For this the people collectively are extremely unfit, which is one of the chief inconveniences of a democracy. It is not at all necessary that the representatives who have received a general instruction from their constituents should wait to be directed on each particular affair, as is practiced in the Diets of Germany. True it is that by this way of proceeding the speeches of the deputies might with greater propriety be called the voice of the nation, but, on the other hand, this would occasion infinite delays, would give each deputy a power of controlling the assembly, and, on the most urgent and pressing occasions the wheels of government might be stopped by the caprice of a single person. When the deputies, as Mr. Sidney well observes, represent a body of people, as in Holland, they ought to be accountable to their constituents, but it is a different thing in England, where they are deputed by boroughs. All the inhabitants of the several districts ought to have a right of voting at the election of a representative, except such as are in so mean a situation as to be deemed to have no will of their own. One great fault there was in most of the ancient republics, that the people had a right to active resolutions, such as require some execution, a thing of which they are absolutely incapable. They ought to have no share in the government but for the choosing of representatives, which is within their reach. For though few can tell the exact degree of men's capacities, yet there are none but are capable of knowing in general whether the person they choose is better qualified than most of his neighbors. Neither ought the representative body to be chosen for the executive part of government, for which it is not so fit, but for the enacting of laws, or to see whether the laws in being are duly executed, a thing suited to their abilities, and which none indeed but themselves can properly perform. In such a state there are always persons distinguished by their birth, riches, or honors, but were they to be confounded with the common people, and to have only the weight of a single vote like the rest, the common liberty would be their slavery, and they would have no interest in supporting it, as most of the popular resolutions would be against them. The share they have, therefore, in the legislature ought to be proportioned to their other advantages in the state, which happens only when they form a body that has a right to check the licentiousness of the people, as the people have a right to oppose any encroachment of theirs. The legislative power is therefore committed to the body of the nobles, and to that which represents the people, each having their assemblies and deliberations apart, each their separate views and interests. Of the three powers above mentioned, the judiciary is in some measure next to nothing. There remain, therefore, only two, and as these have need of a regulating power to moderate them, the part of the legislative body composed of the nobility is extremely proper for this purpose. The body of the nobility ought to be hereditary. In the first place it is so in its own nature, and in the next there must be a considerable interest to preserve its privileges that in themselves are obnoxious to popular envy, and of course in a free state are always in danger. But as a hereditary power might be tempted to pursue its own particular interests, and forget those of the people, it is proper that where a singular advantage may be gained by corrupting the nobility, as in the laws relating to the supplies, they should have no other share in the legislation than the power of rejecting, and not that of resolving. By the power of resolving I mean the right of ordaining by their own authority, or of amending what has been ordained by others. By the power of rejecting I would be understood to mean the right of annulling a resolution taken by another, which was the power of tribunes at Rome. And though the person possessed of the privilege of rejecting may likewise have the right of approving, yet this approbation passes for no more than a declaration that he intends to make no use of his privilege of rejecting, and is derived from that very privilege. The executive power ought to be in the hands of a monarch, because this branch of government, having need of dispatch, is better administered by one than by many. On the other hand, whatever depends on the legislative power is oftentimes better regulated by many than by a single person. But if there were no monarch, and the executive power should be committed to a certain number of persons selected from the legislative body, there would be an end then of liberty, by reason the two powers would be united, as the same persons would sometimes possess, and would be always able to possess, a share in both. Were the legislative body to be a considerable time without meeting, this would likewise put an end to liberty. For of two things one would naturally follow, either that there would be no longer any legislative resolutions, and then the state would fall into anarchy, or that these resolutions would be taken by the executive power, which would render it absolute. It would be needless for the legislative body to continue always assembled. This would be troublesome to the representatives, and, moreover, would cut out too much work for the executive power, so as to take off its attention to its office, and oblige it to think only of defending its own prerogatives, and the right it has to execute. Again, were the legislative body to be always assembled, it might happen to be kept up only by filling the places of the deceased members with new representatives, and in that case, if the legislative body were once corrupted, the evil would be past all remedy. When different legislative bodies succeed one another, the people who have a bad opinion of that which is actually sitting may reasonably entertain some hopes of the next, but were it to be always the same body, the people upon seeing it once corrupted would no longer expect any good from its laws, and of course they would either become desperate or fall into a state of indolence. The legislative body should not meet of itself. For a body is supposed to have no will but when it is met, and besides, were it not to meet unanimously, it would be impossible to determine which was really the legislative body, the part assembled, or the other. And if it had a right to prorogue itself, it might happen never to be prorogued, which would be extremely dangerous, in case it should ever attempt to encroach on the executive power. Besides, there are seasons, some more proper than others, for assembling the legislative body. It is fit, therefore, that the executive power should regulate the time of meeting, as well as the duration of those assemblies, according to the circumstances and exigencies of a state known to itself. Were the executive power not to have a right of restraining the encroachments of legislative body, the latter would become despotic, for as it might arrogate to itself what authority it pleased, it would soon destroy all the other powers. But it is not proper, on the other hand, that the legislative power should have a right to stay the executive. For as the execution has its natural limits, it is useless to confine it. Besides, the executive power is generally employed in momentary operations. The power therefore, oft Roman tribunes was faulty, as it put a stop not only to the legislation, but likewise to the executive part of government, which was attended with infinite mischief. But if the legislative power in a free state has no right to stay the executive, it has a right and ought to have the means of examining in what manner its laws have been executed, an advantage which this government has over that of Crete and Sparta, where the Cosmi and the Ephori gave no account of their administration. But whatever may be the issue oft at examination, the legislative body ought not to have a power of arraigning the person, nor, of course, the conduct, of him who is entrusted with the executive power. His person should be sacred, because as it is necessary for the good of the state to prevent the legislative body from rendering themselves arbitrary, the moment he is accused or tried there is an end of liberty. In this case the state would be no longer a monarchy, but a kind of republic, though not a free government. But as the person entrusted with the executive power cannot abuse it without bad counselors, and such as have the laws as ministers, though the laws protect them as subjects, these men may be examined and punished, an advantage which this government has over that of Nidus, where the law allowed of no such thing as calling the Amimones to an account, even after their administration, and therefore the people could never obtain any satisfaction for the injuries done them. Though, in general, the judiciary power ought not to be united with any part of the legislative, yet this is liable to 3 exceptions, founded on the particular interest of the party accused. The great are always obnoxious to popular envy, and were they to be judged by the people, they might be in danger from their judges, and would, moreover, be deprived of the privilege which the meanest subject is possessed of in a free state, of being tried by his peers. The nobility, for this reason, ought not to be cited before the ordinary courts of judicature, but before that part of the legislature which is composed of their own body. It is possible that the law, which is clear-sighted in one sense, and blind in another, might, in some cases, be too severe. But as we have already observed, the national judges are no more than the mouth that pronounces the words of the law, mere passive beings, incapable of moderating either its force or rigor. That part, therefore, of the legislative body, which we have just now observed to be a necessary tribunal on another occasion, is also a necessary tribunal in this: it belongs to its supreme authority to moderate the law in favor of the law itself, by mitigating the sentence. It might also happen that a subject entrusted with the administration of public affairs may infringe the rights of the people, and be guilty of crimes which the ordinary magistrates either could not or would not punish. But, in general, the legislative power cannot try causes, and much less can it try this particular case, where it represents the party aggrieved, which is the people. It can only, therefore, impeach. But before what court shall it bring its impeachment? Must it go and demean itself before the ordinary tribunals, which are its inferiors, and, being composed, moreover, of men who are chosen from the people as well as itself, will naturally be swayed by the authority of so powerful an accuser? No, in order to preserve the dignity of the people, and the security of the subject, the legislative part which represents the people must bring in its charge before the legislative part which represents the nobility, who have neither the same interests nor the same passions. Here is an advantage which this government has over most of the ancient republics, where this abuse prevailed, that the people were at the same time both judge and accuser. The executive power, pursuant of what has been already said, ought to have a share in the legislature by the power of rejecting, otherwise it would soon be stripped of its prerogative. But should the legislative power usurp a share of the executive, the latter would be equally undone. If the prince were to have a part in the legislature by the power of resolving, liberty would be lost. But as it is necessary he should have a share in the legislature for the support of his own prerogative, this share must consist in the power of rejecting. The change of government at Rome was owing to this, that neither the Senate, who had one part of the executive power, nor the magistrates, who were entrusted with the other, had the right of rejecting, which was entirely lodged in the people. Here then is the fundamental constitution of the government we are treating of. The legislative body being composed of 2 parts, they check one another by the mutual privilege of rejecting. They are both restrained by the executive power, as the executive is by the legislative. These 3 powers should naturally form a state of repose or inaction. But as there is a necessity for movement in the course of human affairs, they are forced to move, but still in concert. As the executive power has no other part in the legislative than the privilege of rejecting, it can have no share in the public debates. It is not even necessary that it should propose, because as it may always disapprove of the resolutions that shall be taken, it may likewise reject the decisions on those proposals which were made against its will. In some ancient commonwealths, where public debates were carried on by the people in a body, it was natural for the executive power to propose and debate in conjunction with the people, otherwise their resolutions must have been attended with a strange confusion. Were the executive power to determine the raising of public money, otherwise than by giving its consent, liberty would be at an end, because it would become legislative in the most important point of legislation. If the legislative power was to settle the subsidies, not from year to year, but forever, it would run the risk of losing its liberty, because the executive power would be no longer dependent, and when once it was possessed of such a perpetual right, it would be a matter of indifference whether it held it of itself or of another. The same may be said if it should come to a resolution of entrusting, not an annual, but a perpetual command of the fleets and armies to the executive power. To prevent the executive power from being able to oppress, it is requisite that the armies with which it is entrusted should consist of the people, and have the same spirit as the people, as was the case at Rome till the time of Marius. To obtain this end, there are only two ways: either that the persons employed in the army should have sufficient property to answer for their conduct to their fellow subjects, and be enlisted only for a year, as was customary at Rome, or if there should be a standing army, composed chiefly oft most despicable part of the nation, the legislative power should have a right to disband them as soon as it pleased, the soldiers should live in common with the rest of the people, and no separate camp, barracks, or fortress should be suffered. When once an army is established, it ought not to depend immediately on the legislative, but on the executive power, and this from the very nature of the thing, its business consisting more in action than in deliberation. It is natural for mankind to set a higher value upon courage than timidity, on activity than prudence, on strength than counsel. Hence the army will ever despise a senate, and respect their own officers. They will naturally slight the orders sent them by a body of men whom they look upon as cowards, and therefore unworthy to command them. So that as soon as the troops depend entirely on the legislative body, it becomes a military government, and if the contrary has ever happened, it has been owing to some extraordinary circumstances. It is because the army was always kept divided, it is because it was composed of several bodies that depended each on a particular province, it is because the capital towns were strong places, defended by their natural situation, and not garrisoned with regular troops. Holland, for instance, is still safer than Venice. She might drown or starve the revolted troops, for as they are not quartered in towns capable of furnishing them with necessary subsistence, this subsistence is of course precarious. In perusing the admirable treatise of Tacitus on the manners of the Germans, we find it is from that nation the English have borrowed the idea of their political government. This beautiful system was invented first in the woods. As all human things have an end, the state we are speaking of will lose its liberty, will perish. Have not Rome, Sparta, and Carthage perished? It will perish when the legislative power shall be more corrupt than the executive. It is not my business to examine whether the English actually enjoy this liberty or not. Sufficient it is for my purpose to observe that it is established by their laws, and I inquire no further. Neither do I pretend by this to undervalue other governments, nor to say that this extreme political liberty ought to give uneasiness to those who have only a moderate share of it. How should I have any such design, I who think that even the highest refinement of reason is not always desirable, and that mankind generally find their account better in mediums than in extremes? Harrington, in his Oceana, has also inquired into the utmost degree of liberty to which the constitution of a state may be carried. But of him indeed it may be said that for want of knowing the nature of real liberty he busied himself in pursuit of an imaginary one, and that he built a Chalcedon, though he had a Byzantium before his eyes. 7. Of the monarchies we are acquainted with. The monarchies we are acquainted with have not, like that we have been speaking of, liberty for their direct view. The only aim is the glory of the subject, of the state, and of the sovereign. But hence there results a spirit of liberty, which in those states is capable of achieving as great things, and of contributing as much perhaps to happiness as liberty itself. Here the three powers are not distributed and founded on the model of the constitution above mentioned, they have each a particular distribution, according to which they border more or less on political liberty, and if they did not border upon it, monarchy would degenerate into despotic government. 8. Why the ancients had not a clear idea of monarchy. The ancients had no notion of a government founded on a body of nobles, and much less on a legislative body composed of the representatives of the people. The republics of Greece and Italy were cities that had each their own form of government, and convened their subjects within their walls. Before Rome had swallowed up all the other republics, there was scarcely anywhere a king to be found, no, not in Italy, Gaul, Spain, or Germany, they were all petty states or republics. Even Africa itself was subject to a great commonwealth, and Asia Minor was occupied by Greek colonies. There was, therefore, no instance of deputies of towns or assemblies of the states. One must have gone as far as Persia to find a monarchy. I am not ignorant that there were confederate republics, in which several towns sent deputies to an assembly. But I affirm there was no monarchy on that model. The first plan, therefore, of the monarchies we are acquainted with was thus formed. The German nations that conquered the Roman Empire were certainly a free people. Of this we may be convinced only by reading Tacitus on the manners of the Germans. The conquerors spread themselves over all the country, living mostly in the fields, and very little in towns. When they were in Germany, the whole nation was able to assemble. This they could no longer do when dispersed through the conquered provinces. And yet as it was necessary that the nation should deliberate on public affairs, pursuant to their usual method before the conquest, they had recourse to representatives. Such is the origin of the Gothic government amongst us. At first it was mixed with aristocracy and monarchy, a mixture attended with this inconvenience, that the common people were bondmen. The custom afterwards succeeded of granting letters of enfranchisement, and was soon followed by so perfect a harmony between the civil liberty of the people, the privileges of the nobility and clergy, and the prince's prerogative, that I really think there never was in the world a government so well tempered as that of each part of Europe, so long as it lasted. Surprising that the corruption of the government of a conquering nation should have given birth to the best species of constitution that could possibly be imagined by man. 9. Aristotle's manner of thinking. Aristotle is greatly puzzled in treating of monarchy. He makes 5 species, and he does not distinguish them by the form of constitution, but by things merely accidental, as the virtues and vices of the prince, or by things extrinsic, such as tyranny usurped or inherited. Among the number of monarchies he ranks the Persian Empire and the Kingdom of Sparta. But is it not evident that the one was a despotic state and the other a republic? The ancients, who were strangers to the distribution of the 3 powers in the government of a single person, could never form a just idea of monarchy. 10. What other politicians thought. To temper monarchy, Arabas, king of Epirus, found no other remedy than a republic. The Molossi, not knowing how to limit the same power, made 2 kings, by which means the state was weakened more than the prerogative. They wanted rivals, and they created enemies. 2 kings were tolerable nowhere but at Sparta. Here they did not form, but were only a part of the constitution. 11. Of the kings of the heroic times of Greece. In the heroic times of Greece, a kind of monarchy arose that was not of long duration. Those who had been inventors of arts, who had fought in their country's cause, who had established societies, or distributed lands among the people, obtained the regal power, and transmitted it to their children. They were kings, priests, and judges. This was one of the 5 species of monarchy mentioned by Aristotle, and the only one that can give us any idea of the monarchical constitution. But the plan of this constitution is opposite to that of our modern monarchies. The 3 powers were there distributed in such a manner that the people were the legislature, and the king had the executive together with the judiciary power, whereas in modern monarchies the prince is invested with the executive and legislative powers, or at least with part of legislative, but does not act in a judiciary capacity. In the government of the kings of the heroic times, the 3 powers were ill distributed. Hence those monarchies could not long subsist. For as soon as the people got the legislative power into their hands, they might, as they everywhere did, upon the very least caprice, subvert the regal authority. Among a free people possessed of the legislative power, and enclosed within walls, where everything tending towards oppression appears still more odious, it is the masterpiece of legislation to know where to place properly the judiciary power. But it could not be in worse hands than in those of the person to whom the executive power had been already committed. From that very instant the monarch became terrible. But at the same time as he had no share in the legislature, he could make no defense against it, thus his power was in one sense too great, in another too little. They had not as yet discovered that the true function of a prince was to appoint judges, and not to sit as judge himself. The opposite policy rendered the government of a single person insupportable. Hence all these kings were banished. The Greeks had no notion of the proper distribution of the three powers in the government of one person, they could see it only in that of many, and this kind of constitution they distinguished by the name of polity. 12. Of the government of the kings of Rome and in what manner the three powers were there distributed. The government of the kings of Rome had some relation to that of the kings of the heroic times of Greece. Its subversion, like the latter's, was owing to its general defect, though in its own particular nature it was exceedingly good. In order to give an adequate idea of this government, I shall distinguish that of the first 5 kings, that of Servius Tullius, and that of Tarquin. The crown was elective, and under the first 5 kings the Senate had the greatest share in the election. Upon the king's decease the Senate examined whether they should continue the established form of government. If they thought proper to continue it, they named a magistrate taken from their own body, who chose a king, the Senate were to approve of the election, the people to confirm it, and the augurs to declare the approbation of the gods. If any of these 3 conditions was wanting, they were obliged to proceed to another election. The constitution was a mixture of monarchy, aristocracy, and democracy, and such was the harmony of power that there was no instance of jealousy or dispute in the first reigns. The king commanded the armies, and had the direction of sacrifices, he had the power of determining civil and criminal causes, he called the Senate together, convened the people, laid some affairs before the latter, and regulated the rest with the Senate. The authority of the Senate was very great. The kings oftentimes pitched upon senators with whom they sat in judgment, and they never laid any affair before the people till it had been previously debated in that august assembly. The people had the right of choosing magistrates, of consenting to the new laws, and, with the king's permission, of making war and peace, but they had not the judicial power. When Tullius Hostilius referred the trial of Horatius to the people, he had his particular reasons, which may be seen in Dionysius Halicarnassus. The constitution altered under Servius Tullius. The Senate had no share in his election, he caused himself to be proclaimed by the people, he resigned the power of hearing civil causes, reserving none to himself but those of a criminal nature, he laid all affairs directly before the people, eased them of the taxes, and imposed the whole burden on the patricians. Hence in proportion as he weakened the regal together with the senatorial power, he augmented that of the plebeians. Tarquin would neither be chosen by the Senate nor by the people, he considered Servius Tullius as a usurper, and seized the crown as his hereditary right. He destroyed most of the senators, those who remained he never consulted, nor did he even so much as summon them to assist at his decisions. Thus his power increased, but the odium of that power received a new addition, by usurping also the authority of the people, against whose consent he enacted several laws. The 3 powers were by these means reunited in his person, but the people at a critical minute recollected that they were legislators, and there was an end of Tarquin. 13. General reflections on the state of Rome after the expulsion of its kings. It is impossible to be tired of so agreeable a subject as ancient Rome, thus strangers at present leave the modern palaces of that celebrated capital to visit the ruins, and thus the eye, after recreating itself with the view of flowery meads, is pleased with the wild prospect of rocks and mountains. The patrician families were at all times possessed of great privileges. These distinctions, which were considerable under the kings, became much more important after their expulsion. Hence arose the jealousy of the plebeians, who wanted to reduce them. The contest struck at the constitution, without weakening the government, for it was very indifferent as to what family were. The magistrates, provided the magistracy preserved its authority. An elective monarchy, like that of Rome, necessarily supposes a powerful aristocratic body to support it, without which it changes immediately into tyranny or into a popular state. But a popular state has no need of this distinction of families to maintain itself. To this it was owing that the patricians, who were a necessary part of the constitution under the regal government, became a superfluous branch under the consuls. The people could suppress them without hurting themselves, and change the constitution without corrupting it. After Servius Tullius had reduced the patricians, it was natural that Rome should fall from the regal hands into those of the people. But the people had no occasion to be afraid of relapsing under a regal power by reducing the patricians. A state may alter in two different ways, either by the amendment or by the corruption of the constitution. If it has preserved its principles and the constitution changes, this is owing to its amendment. If upon changing the constitution its principles are lost, this is because it has been corrupted. The government of Rome, after the expulsion of the kings, should naturally have been a democracy. The people had already the legislative power in their hands. It was their unanimous consent that had expelled the Tarquins, and if they had not continued steady to those principles, the Tarquins might easily have been restored. To pretend that their design in expelling them was to render themselves slaves to a few families is quite absurd. The situation therefore of things required that Rome should have formed a democracy, and yet this did not happen. There was a necessity that the power of the principal families should be tempered, and that laws should have a bias to democracy. The prosperity of states is frequently greater in the insensible transition from one constitution to another than in either of those constitutions. Then it is that all the springs of government are upon the stretch, that the citizens assert their claims, that friendships or enmities are formed amongst jarring parties, and that there is a noble emulation between those who defend the ancient and those who are strenuous in promoting the new constitution. 14. In what manner the distribution of the three powers began to change after the expulsion of the kings. There were four things that greatly prejudiced the liberty of Rome. The patricians had engrossed to themselves all public employments whatever, an exorbitant power was annexed to the consulate, the people were often insulted, and, in fine, they had scarcely any influence at all left in the public suffrages. These four abuses were redressed by the people. First, it was regulated that the plebeians might aspire to some magistracies, and by degrees they were rendered capable of them all, except that of inter rex. Second, the consulate was dissolved into several other magistracies. Praetors were created, on whom the power was conferred of trying private causes. Quaestors were nominated for determining those of a criminal nature, aediles were established for the civil administration, treasurers were made for the management of the public money, and, in fine, by the creation of censors the consuls were divested of that part of the legislative power which regulates the morals of the citizens and the transient polity of the different bodies of the state. The chief privileges left them were to preside in the great meetings of the people, to assemble the Senate, and to command the armies. Third, the sacred laws appointed tribunes, who had a power of checking the encroachments of the patricians, and prevented not only private but likewise public injuries. In fine, the plebeians increased their influence in the general assemblies. The people of Rome were divided in three different manners: by centuries, by curiae, and by tribes, and whenever they gave their votes, they were convened in one of those three ways. In the first, the patricians, the leading men, the rich and the Senate, which was very nearly the same thing, had almost the whole authority. In the second they had less, and less still in the third. The division into centuries was a division rather of estates and fortunes than of persons. The whole people were distributed into 193 centuries, which had each a single vote. The patricians and leading men composed the first 98 centuries, and the other 95 consisted of the remainder of the citizens. In this division therefore the patricians were masters of the suffrages. In the division into curiae, the patricians had not the same advantages. Some, however, they had, for it was necessary to consult the augurs, who were under the direction of patricians, and no proposal could be made there to the people unless it had been previously laid before the Senate, and approved of by a senatus consultum. But, in the division into tribes they had nothing to do either with the augurs or with the decrees of the Senate, and the patricians were excluded. Now the people endeavored constantly to have those meetings by curiae which had been customary by centuries, and by tribes, those they used to have before by curiae, by which means the direction of public affairs soon devolved from the patricians to the plebeians. Thus when the plebeians obtained the power of trying the patricians, a power which commenced in the affair of Coriolanus, they insisted upon assembling by tribes, and not by centuries, and when the new magistracies of tribunes and aediles were established in favor of the people, the latter obtained that they should meet by curiae in order to nominate them, and after their power was quite settled, they gained so far their point as to assemble by tribes to proceed to this nomination. 15. In what manner Rome, in the flourishing state of that republic, suddenly lost its liberty. In the heat oft contests between the patricians and the plebeians, the latter insisted upon having fixed laws, to the end that the public judgments should no longer be the effect of capricious will or arbitrary power. The Senate, after a great deal of resistance, acquiesced, and decemvirs were nominated to compose those laws. It was thought proper to grant them an extraordinary power, because they were to give laws to parties whose views and interest it was almost impossible to unite. The nomination of all magistrates was suspended, and the decemvirs were chosen in the comitia sole administrators of the republic. Thus they found themselves invested with the consular and the tribunician power. By one they had the privilege of assembling the Senate, by the other that of convening the people, but they assembled neither Senate nor people. 10 men only of the republic had the whole legislative, the whole executive, and the whole judiciary power. Rome saw herself enslaved by as cruel a tyranny as that of Tarquin. When Tarquin trampled on the liberty of that city, she was seized with indignation at the power he had usurped. When the decemvirs exercised every act of oppression, she was astonished at the extraordinary power she had granted. What a strange system of tyranny, a tyranny carried on by men who had obtained the political and military power, merely from their knowledge in civil affairs, and who at that very juncture stood in need of the courage of those citizens to protect them abroad who so tamely submitted to domestic oppression. The spectacle of Virginia's death, whom her father immolated to chastity and liberty, put an end to the power of the decemvirs. Every man became free, because every man had been injured. Each showed himself a citizen because each had a tie of the parent. The Senate and the people resumed a liberty which had been committed to ridiculous tyrants. No people were so easily moved by public spectacles as the Romans. That of the empurpled body of Lucretia put an end to the regal government. The debtor who appeared in the forum covered with wounds caused an alteration in the republic. The decemvirs owed their expulsion to the tragedy of Virginia. To condemn Manlius, it was necessary to keep the people from seeing the Capitol. Caesar's bloody garment flung Rome again into slavery. 16. Of the legislative power in the Roman Republic. There were no rights to contest under the decemvirs, but upon the restoration of liberty, jealousies revived, and so long as the patricians had any privileges left, they were sure to be stripped of them by the plebeians. The mischief would not have been so great had the plebeians been satisfied with this success, but they also injured the patricians as citizens. When the people assembled by curiae or centuries, they were composed of senators, patricians, and plebeians. In their disputes the plebeians gained this point, that they alone without patricians or senate should enact the laws called plebiscita, and the assemblies in which they were made had the name of comitia by tribes. Thus there were cases in which the patricians had no share in the legislative power, but were subject to the legislation of another body of the state. This was the extravagance of liberty. The people, to establish a democracy, acted against the very principles of that government. One would have imagined that so exorbitant a power must have destroyed the authority of the Senate. But Rome had admirable institutions. Two of these were especially remarkable, one by which the legislative power of the people was established, and the other by which it was limited. The censors, and before them the consuls, modeled and created, as it were, every 5 years the body of the people. They exercised the legislation on the very part that was possessed of the legislative power. Tiberius Gracchus, says Cicero, caused the freedmen to be admitted into the tribes, not by the force of his eloquence, but by a word, by a gesture, which had he not effected, the Republic, whose drooping head we are at present scarcely able to uphold, would not even exist. On the other hand, the Senate had the power of rescuing, as it were, the Republic out of the hands of the people, by creating a dictator, before whom the sovereign bowed his head, and the most popular laws were silent. 17. Of the executive power in the same Republic. Jealous as the people were of their legislative power, they had no great uneasiness about the executive. This they left almost entirely to the Senate and to the consuls, reserving scarcely anything more to themselves than the right of choosing the magistrates, and of confirming the acts of the Senate and of the generals. Rome, whose passion was to command, whose ambition was to conquer, whose commencement and progress were one continued usurpation, had constantly affairs of the greatest weight upon her hands. Her enemies were ever conspiring against her, or she against her enemies. As she was obliged to behave on the one hand with heroic courage, and on the other with consummate prudence, it was requisite, of course, that the management of affairs should be committed to the Senate. Thus the people disputed every branch of the legislative power with the Senate, because they were jealous of their liberty, but they had no disputes about the executive, because they were animated with the love of glory. So great was the share the Senate took in the executive power, that, as Polybius informs us, foreign nations imagined that Rome was an aristocracy. The Senate disposed oft public money, and farmed out tea revenue. They were arbiters of the affairs of their allies, they determined war or peace, and directed in this respect the consuls. They fixed the number of the Roman and of the allied troops, disposed of the provinces and armies to the consuls or praetors, and upon the expiration of the year of command had the power of appointing successors. They decreed triumphs, received and sent embassies, they nominated, rewarded, punished, and were judges of kings, declared them allies of the Roman people, or stripped them of that title. The consuls levied the troops which they were to carry into the field, had the command of the forces by sea and by land, disposed of the forces of the allies, were invested with the whole power of the Republic in the provinces, gave peace to the vanquished nations, imposed conditions on them, or referred them to the Senate. In the earliest times, when the people had some share in the affairs relating to war or peace, they exercised rather their legislative than their executive power. They scarcely did anything else but confirm the acts of the kings, and after their expulsion those of the consuls or Senate. So far were they from being the arbiters of war that we have instances of its having been often declared, notwithstanding the opposition of the tribunes. But growing wanton in their prosperity, they increased their executive power. Thus they created the military tribunes, the nomination of whom till then had belonged to the generals, and some time before the First Punic War, they decreed that only their own body should have the right of declaring war. 18. Of the judiciary power in the Roman government. The judiciary power was given to the people, to the Senate, to the magistrates, and to particular judges. We must see in what manner it was distributed, beginning with their civil affairs. The consuls had the judiciary power after the expulsion of the kings, as the praetors were judges after the consuls. Servius Tullius had divested himself of the power of determining civil causes, which was not resumed by the consuls, except in some very rare cases, for that reason called extraordinary. They were satisfied with naming the judges, and establishing the several tribunals. By a discourse of Appius Claudius, in Dionysius Halicarnassus, it appears that as early as the 259th year of Rome this was looked upon as a settled custom among the Romans, and it is not tracing it very high to refer it to Servius Tullius. Every year the praetor made a list of such as he chose for the office of judges during his magistracy. A sufficient number was pitched upon for each cause, a custom very nearly the same as that now practiced in England. And what was extremely favourable to liberty was the praetors fixing the judges with the consent of the parties. The great number of exceptions that can be made in England amounts pretty nearly to this very custom. The judges decided only the questions relating to matter of fact, for example whether a sum of money had been paid or not, whether an act had been committed or not. But as to questions of law, as these required a certain capacity, they were always carried before the tribunal of the centumvirs. The kings reserved to themselves the judgment of criminal affairs, and in this were succeeded by the consuls. It was in consequence of this authority that Brutus put his children and all those who were concerned in the Tarquinian conspiracy to death. This was an exorbitant power. The consuls already invested with the military command extended the exercise of it even to civil affairs, and their procedures, being stripped of all forms of justice, were rather exertions of violence than legal judgments. This gave rise to the Valerian law, by which it was made lawful to appeal to the people from every decision of the consuls that endangered the life of a citizen. The consuls had no longer the power of pronouncing sentence in capital cases against a Roman citizen, without the consent of the people. We see in the first conspiracy for the restoration of the Tarquins that the criminals were tried by Brutus the consul, in the second the Senate and Comitia were assembled to try them. The laws distinguished by the name of sacred allowed the plebeians the privilege of choosing tribunes, whence was formed a body whose pretensions at first were immense. It is hard to determine which was greater, the insolence of the plebeians in demanding, or the condescension of the Senate in granting. The Valerian law allowed appeals to the people, that is, to the people composed of senators, patricians, and plebeians. The plebeians made a law that appeals should be brought before their own body. A question was soon after started, whether the plebeians had a right to try a patrician. This was the subject of a dispute to which the impeachment of Coriolanus gave rise, and which ended with that affair. When Coriolanus was accused by the tribunes before the people, he insisted, contrary to the spirit of the Valerian law, that as he was a patrician, none but the consuls had the power to try him. On the other hand, the plebeians, also contrary to the spirit of that same law, pretended that none but their body were empowered to be his judges, and accordingly they pronounced sentence upon him. This was moderated by the law of the 12 Tables, whereby it was ordained that none but the great assemblies of the people should try a citizen in capital cases. Hence the body of the plebeians, or, which amounts to the very same, the comitia by tribes, had no longer any power of hearing criminal causes, except such as were punished with fines. To inflict a capital punishment a law was requisite, but to condemn to a pecuniary mulct, there was occasion only for a plebiscitum. This regulation of the law of the 12 Tables was extremely prudent. It produced an admirable balance between the body of the plebeians and the Senate. For as the full judiciary power of both depended on the greatness of the punishment and the nature of the crime, it was necessary they should both agree. The Valerian law abolished all the remains of the Roman government in any way relating to that of the kings of the heroic times of Greece. The consuls were divested of the power to punish crimes. Though all crimes are public, yet we must distinguish between those which more nearly concern the mutual intercourse of the citizens and those which more immediately interest the state in the relation it bears to its subjects. The first are called private, the second public. The latter were tried by the people, and in regard to the former, they named by particular commission a quaestor for the prosecution of each crime. The person chosen by the people was frequently one of the magistrates, sometimes a private man. He was called the quaestor of parricide, and is mentioned in the law of the 12 Tables. The quaestor nominated the judge of the question, who drew lots for the judges, and regulated the tribunal in which he presided. Here it is proper to observe what share the Senate had in the nomination of the quaestor, that we may see how far the two powers were balanced. Sometimes the Senate caused a dictator to be chosen, in order to exercise the office of quaestor. At other times they ordained that the people should be convened by a tribune, with the view of proceeding to the nomination of a quaestor and, in fine, the people frequently appointed a magistrate to make his report to the Senate concerning a particular crime, and to desire them to name a quaestor, as may be seen in the judgment upon Lucius Scipio and Livy. In the year of Rome 604, some of these commissions were rendered permanent. All criminal causes were gradually divided into different parts, to which they gave the name of perpetual questions. Different praetors were created, to each of whom some of those questions were assigned. They had a power conferred upon them for the term of a year, of trying such criminal causes as bore any relation to those questions, and then they were sent to govern their province. At Carthage the Senate of the 100 was composed of judges who enjoyed that dignity for life. But at Rome the praetors were annual, and the judges were not even for so long a term, but were nominated for each cause. We have already shown in the 6th chapter of this book how favorable this regulation was to liberty in particular governments. The judges were chosen from the order of senators tilth time oft Gracchi. Tiberius Gracchus caused a law to pass that they should be taken from the equestrian order, a change so very considerable that the tribune boasted of having cut, by one rogation only, the sinews of the senatorial dignity. It is necessary to observe that the three powers may be very well distributed. In regard to the liberty of the constitution, though not so well in respect to the liberty of the subject. At Rome the people had the greatest share of the legislative, a part of the executive, and part of the judiciary power, by which means they had so great a weight in the government as required some other power to balance it. The Senate indeed had part of the executive power, and some share of the legislative, but this was not sufficient to counterbalance the weight of the people. It was necessary that they should partake of the judiciary power, and accordingly they had a share when the judges were chosen from among the senators. But when the Gracchi deprived the senators of the judicial power, the Senate were no longer able to withstand the people. To favor, therefore, the liberty of the subject, they struck at that of the constitution, but the former perished with the latter. Infinite were the mischiefs that thence arose. The constitution was changed at a time when the fire of civil discord had scarcely left any such thing as a constitution. The knights ceased to be that middle order which united the people to the Senate, and the chain of the constitution was broken. There were even particular reasons against transferring the judiciary power to the equestrian order. The Constitution of Rome was founded on this principle: that none should be enlisted as soldiers but such as were men of sufficient property to answer for their conduct to the Republic. The knights, as persons of the greatest property, formed the cavalry of the legions. But when their dignity increased, they refused to serve any longer in that capacity, and another kind of cavalry was obliged to be raised. Thus Marius enlisted all sorts of people into his army, and soon after the Republic was lost. Besides, the knights were the farmers of the revenue, men whose great rapaciousness increased the public calamities. Instead of giving to such as those the judicial power, they ought to have been constantly under the eye of the judges. This we must say in commendation of the ancient French laws, that they have acted towards the officers of the revenue with as great a diffidence as would be observed between enemies. When the judiciary power at Rome was transferred to the publicans, there was then an end of all virtue, polity, laws, and government. Of this we find a very ingenious description in some fragments of Diodorus Siculus and Dio. Mutius Scaevola, says Diodorus, wanted to revive the ancient manners, and the laudable custom of sober and frugal living. For his predecessors having entered into a contract with the farmers of the revenue, who at that time were possessed of the judiciary power at Rome, had infected the province with all manner of corruption. But Scaevola made an example of the publicans, and imprisoned those by whom others had been confined. Dio informs us that Publius Rutilius, his lieutenant, was equally obnoxious to the equestrian order, and that upon his return they accused him of having received some presents, and condemned him to a fine, upon which he instantly made a cession of his goods. His innocence appeared in this, that he was found to be worth a great deal less than what he was charged with having extorted, and he showed a just title to what he possessed, but he would not live any longer in the same city with such profligate wretches. The Italians, says Diodorus again, bought up whole droves of slaves in Sicily, to till their lands and to take care of their cattle, but refused them a necessary subsistence. These wretches were then forced to go and rob on the highways, armed with lances and clubs, covered with beasts' skins, and followed by large mastiffs. Thus the whole province was laid waste, and the inhabitants could not call anything their own but what was secured by fortresses. There was neither proconsul nor praetor that could or would oppose this disorder, or that presumed to punish these slaves, because they belonged to the knights, who at Rome were possessed of the judiciary power. And yet this was one of the causes of the war of the slaves. But I shall add only one word more. A profession deaf and inexorable, that can have no other view than lucre, that was always asking and never granting, that impoverished the rich and increased even the misery of the poor. Such a profession, I say, should never have been entrusted with the judiciary power at Rome. 19. Of the government of the Roman provinces. Such was the distribution of 3 powers in Rome. But they were far from being thus distributed in the provinces. Liberty prevailed in the center and tyranny in the extreme parts. While Rome extended her dominions no farther than Italy, the people were governed as confederates, and the laws of each republic were preserved. But when she enlarged her conquests, and the Senate had no longer an immediate inspection over the provinces, nor the magistrates residing at Rome were any longer capable of governing the empire, they were obliged to send praetors and proconsuls. Then it was that the harmony of the 3 powers was lost. The persons appointed to that office were entrusted with a power which comprehended that of all the Roman magistracies, nay, even that of the people. They were despotic magistrates, extremely well adapted to the distance of the places to which they were destined. They exercised the 3 powers, and were, if I may presume to use the expression, the bashaws of the republic. We have elsewhere observed that in a commonwealth the same magistrate ought to be possessed of the executive power, as well civil as military. Hence a conquering republic can hardly communicate her government, and rule the conquered state according to her own constitution. And indeed as the magistrate she sends to govern is invested with the executive power, both civil and military, he must also have the legislative, for who is it that could make laws without him? It is necessary, therefore, that the governor she sends be entrusted with the 3 powers, as was practiced in the Roman provinces. It is more easy for a monarchy to communicate its government, because the officers it sends have, some the civil executive, and others the military executive power, which does not necessarily imply a despotic authority. It was a privilege of the utmost consequence to a Roman citizen to have none but the people for his judge. Were it not for this, he would have been subject in the provinces to the arbitrary power of a proconsul or of a propraetor. The city never felt the tyranny which was exercised only on conquered nations. Thus, in the Roman world, as at Sparta, the freemen enjoyed the highest degree of liberty, while those who were slaves labored under the extremity of servitude. While the citizens paid taxes they were raised with great justice and equality. The regulation of Servius Tullius was observed, who had distributed the people into 6 classes, according to their difference of property, and fixed the several shares of the public imposts in proportion to that which each person had in the government. Hence they bore with the greatness of the tax because of their proportionable greatness of credit, and consoled themselves for the smallness of their credit because of the smallness of the tax. There was also another thing worthy of admiration, which is, that as Servius Tullius's division into classes was in some measure the fundamental principle of the constitution, it thence followed that an equal levying of the taxes was so connected with this fundamental principle that the one could not be abolished without the other. But while the city paid the taxes as she pleased, or paid none at all, the provinces were plundered by the knights, who were the farmers of the public revenue. We have already made mention of their oppressive extortions, with which all history abounds. All Asia, says Mithridates, expects me as her deliverer, so great is the hatred which the rapaciousness of the proconsuls, the confiscations made by the officers of the revenue, and the quirks and cavils of judicial proceedings, have excited against the Romans. Hence it was that the strength of the provinces did not increase, but rather weakened, the strength of the republic. Hence it was that the provinces looked upon the loss of the liberty of Rome as the epoch of their own freedom. 20. The end of this book. I should be glad to inquire into the distribution of the 3 powers, in all the moderate governments we are acquainted with, in order to calculate the degrees of liberty which each may enjoy. But we must not always exhaust a subject, so as to leave no work at all for the reader. My business is not to make people read, but to make them think. Book 12. Of the laws that form political liberty, in relation to the subject. 1. Idea of this book. It is not sufficient to have treated of political liberty in relation to the Constitution, we must examine it likewise in the relation it bears to the subject. We have observed that in the former case it arises from a certain distribution of the 3 powers, but in the latter, we must consider it in another light. It consists in security, or in the opinion people have of their security. The constitution may happen to be free, and the subject not. The subject may be free, and not the constitution. In those cases, the constitution will be free by right, and not in fact, the subject will be free in fact, and not by right. It is the disposition only of the laws, and even of the fundamental laws, that constitutes liberty in relation to the constitution. But as it regards the subject, manners, customs, or received examples may give rise to it, and particular civil laws may encourage it, as we shall presently observe. Further, as in most states liberty is more checked or depressed than their constitution requires, it is proper to treat of the particular laws that in each constitution are apt to assist or check the principle of liberty which each state is capable of receiving. 2. Of the liberty of the subject. Philosophic liberty consists in the free exercise of the will, or at least, if we must speak agreeably to all systems, in an opinion that we have the free exercise of our will. Political liberty consists in security, or, at least, in the opinion that we enjoy security. This security is never more dangerously attacked than in public or private accusations. It is, therefore, on the goodness of criminal laws that the liberty of the subject principally depends. Criminal laws did not receive their full perfection all at once. Even in places where liberty has been most sought after, it has not been always found. Aristotle informs us that at Cumae the parents of the accuser might be witnesses. So imperfect was the law under the kings of Rome that Servius Tullius pronounced sentence against the children of Ancus Marcius, who were charged with having assassinated the king, his father-in-law. Under the first kings of France, Claude Arius made a law that nobody should be condemned without being heard, which shows that a contrary custom had prevailed in some particular case or among some barbarous people. It was Charondas that first established penalties against false witnesses. When the subject has no fence to secure his innocence, he has none for his liberty. The knowledge already acquired in some countries, or that may be hereafter attained in others, concerning the surest rules to be observed in criminal judgments, is more interesting to mankind than any other thing in the world. Liberty can be founded on the practice of this knowledge only, and supposing a state to have the best laws imaginable in this respect, a person tried under that state, and condemned to be hanged the next day, would have much more liberty than a pasha enjoys in Turkey. 3. The same subject continued. Those laws which condemn a man to death on the deposition of a single witness are fatal to liberty. In reason there should be two, because a witness who affirms, and the accused who denies, make an equal balance, and a third must incline the scale. The Greeks and Romans required one voice more to condemn, but our French laws insist upon two. The Greeks pretend that their custom was established by the gods, but this more justly may be said of ours. 4. That liberty is favored by the nature and proportion of punishment. Liberty is in perfection when criminal laws derive each punishment from the particular nature of the crime. There are then no arbitrary decisions, the punishment does not flow from the capriciousness of legislator, but from the very nature of the thing, and man uses no violence to man. There are 4 sorts of crimes. Those of the first species are prejudicial to religion, the second to morals, the third to the public tranquility, and the fourth to the security of the subject. The punishments inflicted for these crimes ought to proceed from the nature of each of these species. In the class of crimes that concern religion, I rank only those which attack it directly, such as all simple sacrileges. For as to crimes that disturb the exercise of it, they are of the nature of those which prejudice the tranquility or security of the subject, and ought to be referred to those classes. In order to derive the punishment of simple sacrileges from the nature of the thing, it should consist in depriving people of the advantages conferred by religion, in expelling them out of the temples, in a temporary or perpetual exclusion from the society of the faithful, in shunning their presence, in execrations, comminations, and conjurations. In things that prejudice the tranquility or security of the state, secret actions are subject to human jurisdiction. But in those which offend the deity, where there is no public act, there can be no criminal matter, the whole passes between man and God, who knows the measure and time of his vengeance. Now if magistrates, confounding things, should inquire also into hidden sacrileges, this inquisition would be directed to a kind of action that does not at all require it. The liberty of the subject would be subverted by arming the zeal of timorous as well as of presumptuous consciences against him. The mischief arises from a notion which some people have entertained of revenging the cause of the deity. But we must honor the deity and leave him to avenge his own cause. And, indeed, were we to be directed by such a notion, where would be the end of punishments? If human laws are to avenge the cause of an infinite being, they will be directed by his infinity, and not by the weakness, ignorance, and caprice of man. An historian of Provence relates a fact which furnishes us with an excellent description of the consequences that may arise in weak capacities from the notion of avenging the deity's cause. A Jew was accused of having blasphemed against the Virgin Mary, and upon conviction was condemned to be flayed alive. A strange spectacle was then exhibited. Gentlemen masked, with knives in their hands, mounted the scaffold, and drove away the executioner, in order to be the avengers themselves of the honor of the Blessed Virgin. I do not here choose to anticipate the reflections of the reader. The second class consists of those crimes which are prejudicial to morals. Such is the violation of public or private continence, that is, of the police directing the manner in which the pleasure annexed to the conjunction of the sexes is to be enjoyed. The punishment of those crimes ought to be also derived from the nature of the thing, the privation of such advantages as society has attached to the purity of morals, fines, shame, necessity of concealment, public infamy, expulsion from home and society, and, in fine, all such punishments as belong to a corrective jurisdiction, are sufficient to repress the temerity of the two sexes. In effect, these things are less founded on malice than on carelessness and self-neglect. We speak here of none but crimes which relate merely to morals, for as to those that are also prejudicial to the public security, such as rapes, they belong to the fourth species. The crimes of the third class are those which disturb the public tranquility. The punishments ought therefore to be derived from the nature of the thing, and to be in relation to this tranquility, such as imprisonment, exile, and other like chastisements proper for reclaiming turbulent spirits, and obliging them to conform to the established order. I confine those crimes that injure the public tranquility to things which imply a bare offense against the police, for as to those which by disturbing the public peace attack at the same time the security of the subject, they ought to be ranked in the fourth class. The punishments inflicted upon the latter crimes are such as are properly distinguished by that name. They are a kind of retaliation, by which the society refuses security to a member who has actually or intentionally deprived another of his security. These punishments are derived from the nature of the thing, founded on reason, and drawn from the very source of good and evil. A man deserves death when he has violated the security of the subject so far as to deprive, or attempt to deprive, another man of his life. This punishment of death is the remedy, as it were, of a sick society. When there is a breach of security with regard to property, there may be some reasons for inflicting a capital punishment, but it would be much better, and perhaps more natural, that crimes committed against the security of property should be punished with the loss of property, and this ought, indeed, to be the case if men's fortunes were common or equal. But as those who have no property of their own are generally the readiest to attack that of others, it has been found necessary, instead of a pecuniary, to substitute a corporal punishment. All that I have here advanced is founded in nature, and extremely favorable to the liberty of the subject. 5. Of certain accusations that require particular moderation and prudence. It is an important maxim, that we ought to be very circumspect in the prosecution of witchcraft and heresy. The accusation of these two crimes may be vastly injurious to liberty, and productive of infinite oppression, if the legislator knows not how to set bounds to it. For as it does not directly point at a person's actions, but at his character, it grows dangerous in proportion to the ignorance of the people, and then a man is sure to be always in danger, because the most exceptional conduct, the purest morals, and the constant practice of every duty in life are not a sufficient security against the suspicion of his being guilty of the like crimes. Under Manuel Comnès, the protestator was accused of having conspired against the emperor, and of having employed for that purpose some secrets that render men invisible. It is mentioned in the life of this emperor that Aaron was detected, as he was poring over a book of Solomon's, the reading of which was sufficient to conjure up whole legions of devils. Now, by supposing a power in witchcraft to rouse the infernal spirits to arms, people look upon a man whom they call a sorcerer as the person in the world most likely to disturb and subvert society, and of course they are disposed to punish him with the utmost severity. But their indignation increases when witchcraft is supposed to have the power of subverting religion. The history of Constantinople informs us that in consequence of a revelation made to a bishop of a miracle having ceased because of the magic practices of a certain person, both that person and his son were put to death. On how many surprising things did not this single crime depend? That revelations should not be uncommon, that the bishop should be favored with one, that it was real, that there had been a miracle in the case, that this miracle had ceased, that there was a magic art, that magic could subvert religion, that this particular person was a magician, and, in fine, that he had committed that magic act. The Emperor Theodorus Lascaris attributed his illness to witchcraft. Those who were accused of this crime had no other resource left than to handle a red-hot iron without being hurt. Thus among the Greeks a person ought to have been a sorcerer to be able to clear himself of the imputation of witchcraft. Such was the excess of their stupidity that to the most dubious crime in the world they joined the most dubious proofs of innocence. Under the reign of Philip the Long the Jews were expelled from France, being accused of having poisoned the springs with their lepers. So absurd an accusation ought to make us doubt all those that are founded on public hatred. I have not here asserted that heresy ought not to be punished, I said only that we ought to be extremely circumspect in punishing it. 6. Of the crime against nature. God forbid that I should have the least inclination to diminish the public horror against a crime which religion, morality, and civil government equally condemn. It ought to be proscribed, were it only for its communicating to one sex the weaknesses of the other, and for leading people by a scandalous prostitution of their youth to an ignominious old age. What I shall say concerning it will in no way diminish its infamy, being levelled only against the tyranny that may abuse the very horror we ought to have against the vice. As a natural circumstance of this crime is secrecy, there are frequent instances of its having been punished by legislators upon the deposition of a child. This was opening a very wide door to calumny. Justinian, says Procopius, published a law against this crime. He ordered an inquiry to be made not only against those who were guilty of it, after the enacting of that law, but even before. The deposition of a single witness, sometimes of a child, sometimes of a slave, was sufficient, especially against such as were rich, and against those of the green faction. It is very odd that these three crimes, witchcraft, heresy, and that against nature, of which the first might easily be proved not to exist, the second to be susceptible of an infinite number of distinctions, interpretations, and limitations, the third to be often obscure and uncertain. It is very odd, I say, that these three crimes should amongst us be punished with fire. I may venture to affirm that the crime against nature will never make any great progress in society, unless people are prompted to it by some particular custom, as among the Greeks, where the youths of that country performed all their exercises naked, as amongst us, where domestic education is disused, as amongst the Asiatics, where particular persons have a great number of women whom they despise, while others can have none at all. Let there be no customs preparatory to this crime, let it, like every other violation of morals, be severely proscribed by the civil magistrate, and nature will soon defend or resume her rights. Nature, that fond, that indulgent parent, has strewn her pleasures with a bounteous hand, and while she fills us with delights, she prepares us, by means of our issue, in whom we see ourselves, as it were, reproduced. She prepares us, I say, for future satisfactions of a more exquisite kind than those very delights. 7. Of the crime of high treason. It is determined by the laws of China that whosoever shows any disrespect to the emperor is to be punished with death. As they do not mention in what this disrespect consists, everything may furnish a pretext to take away a man's life, and to exterminate any family whatsoever. 2 persons of that country who were employed to write the court gazette, having inserted some circumstances relating to a certain fact that was not true, it was pretended that to tell a lie in the court gazette was a disrespect shown to the court, in consequence of which they were put to death. A prince of the blood having inadvertently made some mark on a memorial signed with the red pencil by the emperor, it was determined that he had behaved disrespectfully to the sovereign, which occasioned one of the most terrible persecutions against that family that ever was recorded in history. If the crime of high treason be indeterminate, this alone is sufficient to make the government degenerate into arbitrary power. I shall descant more largely on this subject when I come to treat of the composition of laws. 8. Of the misapplication of the terms sacrilege and high treason. It is likewise a shocking abuse to give the appellation of high treason to an action that does not deserve it. By an imperial law it was decreed that those who called in question the prince's judgment, or doubted the merit of such as he had chosen for a public office, should be prosecuted as guilty of sacrilege. Surely it was the cabinet council and the prince's favorites who invented that crime. By another law, it was determined that whosoever made any attempt to injure the ministers and officers belonging to the sovereign should be deemed guilty of high treason, as if he had attempted to injure the sovereign himself. This law is owing to 2 princes remarkable for their weakness, princes who were led by their ministers as flocks by shepherds, princes who were slaves in the palace, children in the council, strangers to the army, princes, in fine, who preserved their authority only by giving it away every day. Some of those favorites conspired against their sovereigns. Nay, they did more, they conspired against the empire they called in barbarous nations, and when the emperors wanted to stop their progress the state was so enfeebled as to be under a necessity of infringing the law, and of exposing itself to the crime of high treason in order to punish those favorites. And yet this is the very law which the judge of Monsieur de Cinq-Mars built upon when endeavouring to prove that the latter was guilty of the crime of high treason for attempting to remove Cardinal Richelieu from the ministry. He says, crimes that aim at the persons of ministers are deemed by the imperial constitutions of equal consequence with those which are levelled against the emperor's own person. A minister discharges his duty to his prince and to his country; to attempt, therefore, to remove him, is endeavouring to deprive the former one of his arms and the latter of part of its power. It is impossible for the meanest tools of power to express themselves in more servile language. By another law of Valentinian, Theodosius, and Arcadius, false coiners are declared guilty of high treason. But is not this confounding the ideas of things? Is not the very horror of high treason diminished by giving that name to another crime? 9. The same subject continued. Paulinus having written to the Emperor Alexander that he was preparing to prosecute for high treason a judge who had decided contrary to his edict, the Emperor answered, that under his reign there was no such thing as indirect high treason. Faustinian wrote to the same emperor that as he had sworn by the prince's life never to pardon his slave, he found himself thereby obliged to perpetuate his wrath, lest he should incur the guilt of lesa majestas. Upon which the emperor made answer, your fears are groundless, and you are a stranger to my principles. It was determined by a senatus consultum that whosoever melted down any of the emperor's statues which happened to be rejected should not be deemed guilty of high treason. The emperors Severus and Antoninus wrote to Pontius that those who sold unconsecrated statues oft emperor should not be charged with high treason. The same princes wrote to Julius Cassianus that if a person in flinging a stone should by chance strike one of the emperor's statues he should not be liable to a prosecution for high treason. The Julian law requires this sort of limitations, for in virtue of this law the crime of high treason was charged not only upon those who melted down the emperor's statues, but likewise on those who committed any such like action, which made it an arbitrary crime. When a number of crimes of lesa majestas had been established, they were obliged to distinguish the several sorts. Hence Ulpian, the civilian, after saying that the accusation of lesa majestas did not die with the criminal, adds that this does not relate to all the treasonable acts established by the Julian law but only to that which implies an attempt against the empire, or against the emperor's life. 10. The same subject continued. There was a law passed in England under Henry VIII, by which whoever predicted the king's death was declared guilty of high treason. This law was extremely vague. The terror of despotic power is so great that it recoils upon those who exercise it. In this king's last illness, the physicians would not venture to say he was in danger, and surely they acted very right. 11. Of thoughts. Marsyas dreamed that he had cut Dionysius's throat. Dionysius put him to death, pretending that he would never have dreamed of such a thing by night if he had not thought of it by day. This was a most tyrannical action, for though it had been the subject of his thoughts, yet he had made no attempt towards it. The laws do not take upon them to punish any other than overt acts. 12. Of indiscreet speeches. Nothing renders the crime of high treason more arbitrary than declaring people guilty of it for indiscreet speeches. Speech is so subject to interpretation, there is so great a difference between indiscretion and malice, and frequently so little is there of the latter in the freedom of expression, that the law can hardly subject people to a capital punishment for words unless it expressly declares what words they are. Words do not constitute an overt act, they remain only in idea. When considered by themselves, they have generally no determinate signification, for this depends on the tone in which they are uttered. It often happens that in repeating the same words they have not the same meaning. This depends on their connection with other things, and sometimes more is signified by silence than by any expression whatever. Since there can be nothing so equivocal and ambiguous as all this, how is it possible to convert it into a crime of high treason? Wherever this law is established, there is an end not only of liberty, but even of its very shadow. In the manifesto of the late Tsarina against the family of the Dolgorukies, one of these princes is condemned to death for having uttered some indecent words concerning her person, another, for having maliciously interpreted her imperial laws, and for having offended her sacred person by disrespectful expressions. Not that I pretend to diminish the just indignation of the public against those who presume to stain the glory of their sovereign. What I mean is that, if despotic princes are willing to moderate their power, a milder chastisement would be more proper on those occasions than the charge of high treason, a thing always terrible even to innocence itself. Overt acts do not happen every day, they are exposed to the eye of the public, and a false charge with regard to matters of fact may be easily detected. Words carried into action assume the nature of that action. Thus a man who goes into a public marketplace to incite the subject to revolt incurs the guilt of high treason, because the words are joined to the action, and partake of its nature. It is not the words that are punished, but an action in which words are employed. They do not become criminal, but when they are annexed to a criminal action, everything is confounded if words are construed into a capital crime, instead of considering them only as a mark of that crime. The emperors Theodosius, Arcadius, and Honorius wrote thus to Rufinus, who was praefectus praetorio: though a man should happen to speak amiss of our person or government, we do not intend to punish him. If he has spoken through levity, we must despise him; if through folly, we must pity him; and if he wrongs us, we must forgive him. Therefore, leaving things as they are, you are to inform us accordingly, that we may be able to judge of words by persons, and that we may duly consider whether we ought to punish or overlook them. 13. Of writings. In writings there is something more permanent than in words, but when they are in no way preparative to high treason they cannot amount to that charge. And yet Augustus and Tiberius subjected satirical writers to the same punishment as for having violated the law of Maestas. Augustus, because of some libels that had been written against persons of the first quality; Tiberius, because of those which he suspected to have been written against himself. Nothing was more fatal to Roman liberty. Cremutius Cordus was accused of having called Cassius in his annals the last of the Romans. Satirical writings are hardly known in despotic governments, where dejection of mind on the one hand, and ignorance on the other, afford neither abilities nor will to write. In democracies they are not hindered, for the very same reason which causes them to be prohibited in monarchies, being generally leveled against men of power and authority, they flatter the malignancy of the people, who are the governing party. In monarchies they are forbidden, but rather as a subject of civil animadversion than as a capital crime. They may amuse the general malevolence, please the malcontents, diminish the envy against public employments, give the people patience to suffer, and make them laugh at their sufferings. But no government is so averse to satirical writings as the aristocratic. There the magistrates are petty sovereigns, but not great enough to despise affronts. If in a monarchy a satirical stroke is designed against the prince, he is placed on such an eminence that it does not reach him, but an aristocratic lord is pierced to the very heart. Hence the decemvirs, who formed an aristocracy, punished satirical writings with death. 14. Breach of modesty in punishing crimes. There are rules of modesty observed by almost every nation in the world. Now it would be very absurd to infringe these rules in the punishment of crimes, the principal view of which ought always to be the establishment of order. Was it the intent of those Oriental nations who exposed women to elephants trained up for an abominable kind of punishment? Was it, I say, their intent to establish one law by the breach of another? By an ancient custom of the Romans it was not permitted to put girls to death till they were ripe for marriage. Tiberius found an expedient of having them debauched by the executioner before they were brought to the place of punishment. That bloody and subtle tyrant destroyed the morals of the people to preserve their customs. When the magistrates of Japan caused women to be exposed naked in the marketplaces, and obliged them to go upon all fours like beasts, modesty was shocked. But when they wanted to compel a mother, when they wanted to force a son, I cannot proceed, even nature herself is struck with horror. 15. Of the enfranchisement of slaves in order to accuse their master. Augustus made a law that the slaves of those who conspired against his person should be sold to the public, that they might depose against their master. Nothing ought to be neglected which may contribute to the discovery of a heinous crime. It is natural, therefore, that in a government where there are slaves they should be allowed to inform, but they ought not to be admitted as witnesses. Vindex discovered the conspiracy that had been formed in favor of Tarquin, but he was not admitted a witness against the children of Brutus. It was right to give liberty to a person who had rendered so great a service to his country, but it was not given him with a view of enabling him to render this service. Hence the Emperor Tacitus ordained that slaves should not be admitted as witnesses against their masters, even in the case of high treason, a law which was not inserted in Justinian's compilation. 16. Of calumny with regard to the crime of high treason. To do justice to the Caesars, they were not the first devisers of the horrid laws which they enacted. It was Sulla that taught them that calumniators ought not to be punished, but the abuse was soon carried to such excess as to reward them. 17. Of the revealing of conspiracies. If thy brother, the son of thy mother, or thy son, or thy daughter, or the wife of thy bosom, or thy friend, which is as thine own soul, entice thee secretly, saying, Let us go and serve other gods, thou shalt surely kill him, thou shalt stone him. This law of Deuteronomy cannot be a civil law among most of the nations known to us, because it would pave the way for all manner of wickedness. No less severe is the law of several countries which commands the subjects, on pain of death, to disclose conspiracies in which they are not even so much as concerned. When such a law is established in a monarchical government, it is very proper it should be under some restrictions. It ought not to be applied in its full severity save to the strongest cases of high treason. In those countries it is of the utmost importance not to confound the different degrees of this crime. In Japan, where the laws subvert every idea of human reason, the crime of concealment is applied even to the most ordinary cases. A certain relation makes mention of two young ladies who were shut up for life in a box thick set with pointed nails, one for having had a love intrigue, and the other for not disclosing it. 18. How dangerous it is in republics to be too severe in punishing the crime of high treason. As soon as a republic has compassed the destruction of those who wanted to subvert it, there should be an end of terrors, punishments, and even of rewards. Great punishments, and consequently great changes, cannot take place without investing some citizens with an exorbitant power. It is, therefore, more advisable in this case to exceed in lenity than in severity, to banish but few, rather than many, and to leave them their estates, instead of making a vast number of confiscations. Under pretense of avenging the Republic's cause, the avengers would establish tyranny. The business is not to destroy the rebel, but the rebellion. They ought to return as quickly as possible into the usual track of government, in which every one is protected by the laws, and no one injured. The Greeks set no bounds to the vengeance they took upon tyrants, or of those they suspected of tyranny. They put their children to death, nay, sometimes 5 of their nearest relatives, and they proscribed an infinite number of families. By such means their republics suffered the most violent shocks. Exiles, or the return of the exiled, were always epochs that indicated a change of the constitution. The Romans had more sense. When Cassius was put to death for having aimed at tyranny, the question was proposed whether his children should undergo the same fate, but they were preserved. They, says Dionysius Halicarnassus, who wanted to change this law at the end of the Marsian and Civil Wars, and to exclude from public offices the children of those who had been proscribed by Sulla, are very much to blame. We find in the wars of Marius and Sulla to what excess the Romans had gradually carried their barbarity. Such scenes of cruelty it was hoped would never be revived. But under the triumvirs they committed greater acts of oppression, though with some appearance of lenity, and it is provoking to see what sophisms they made use of to cover their inhumanity. Appian has given us the formula of the proscriptions. One would imagine they had no other aim than the good of the Republic. With such calmness do they express themselves, such advantages do they point out to the state, such expediency do they show in the means they adopt, such security do they promise to the opulent, such tranquility to the poor, so apprehensive do they seem of endangering the lives of the citizens, so desirous of appeasing the soldiers, such felicity, in fine, do they presage to the commonwealth. Rome was drenched in blood when Lepidus triumphed over Spain, yet, by an unparalleled absurdity, he ordered public rejoicings in that city, upon pain of proscription. 19. In what manner the use of liberty is suspended in a republic. In countries where liberty is most esteemed, there are laws by which a single person is deprived of it, in order to preserve it for the whole community. Such are in England what they call Bills of Attainder. These are in relation to those Athenian laws by which a private person was condemned provided they were made by the unanimous suffrage of 6,000 citizens. They are in relation also to those laws which were made at Rome against private citizens, and were called privileges. These were never passed except in the great meetings of the people. But in what manner soever they were enacted, Cicero was for having them abolished, because the force of a law consists in its being made for the whole community. I must own, notwithstanding, that the practice of the freest nation that ever existed induces me to think that there are cases in which a veil should be drawn for a while over liberty, as it was customary to cover the statues of the gods. 20. Of laws favorable to the liberty of the subject in a republic. In popular governments it often happens that accusations are carried on in public, and every man is allowed to accuse whomsoever he pleases. This rendered it necessary to establish proper laws, in order to protect the innocence of the subject. At Athens, if an accuser had not the 5th part of the votes on his side, he was obliged to pay a fine of 1,000 drams. Aeschines, who accused Ctesiphon, was condemned to pay this fine. At Rome, a false accuser was branded with infamy by marking the letter K on his forehead. Guards were also appointed to watch the accuser, in order to prevent his corrupting either the judges or the witnesses. I have already taken notice of that Athenian and Roman law by which the party accused was allowed to withdraw before judgment was pronounced. 21. Of the cruelty of laws in respect to debtors in a republic. Great is the superiority which one fellow subject has already over another, by lending him money, which the latter borrows in order to spend, and, of course, has no longer in his possession. What must be the consequence if the laws of a republic make a further addition to this servitude and subjection? At Athens and Rome it was at first permitted to sell such debtors as were insolvent. Solon redressed this abuse at Athens by ordaining that no man's body should answer for his civil debts. But the Decemvirs did not reform the same custom at Rome, and though they had Solon's regulation before their eyes, yet they did not choose to follow it. This is not the only passage of the Law of the 12 Tables in which the Decemvirs show their design of checking the spirit of democracy. Often did those cruel laws against debtors throw the Roman Republic into danger. A man covered with wounds made his escape from his creditor's house and appeared in the forum. The people were moved with this spectacle, and other citizens whom their creditors durst no longer confine broke loose from their dungeons. They had promises made them, which were all broken. The people upon this, having withdrawn to the sacred mount, obtained, not an abrogation of those laws, but a magistrate to defend them. Thus they quitted a state of anarchy, but were soon in danger of falling into tyranny. Manlius, to render himself popular, was going to set those citizens at liberty who by their inhuman creditors had been reduced to slavery. Manlius's designs were prevented, but without remedying the evil. Particular laws facilitated to debtors the means of paying, and in the year of Rome 428 the consuls proposed a law which deprived creditors of the power of confining their debtors in their own houses. A usurer, by name Papirius, attempted to corrupt the chastity of a young man named Publius, whom he kept in irons. Sextus's crime gave to Rome its political liberty, that of Papirius gave it also the civil. Such was the fate of this city, that new crimes confirmed the liberty which those of a more ancient date had procured it. Appius's attempt upon Virginia flung the people again into that horror against tyrants with which the misfortune of Lucretia had first inspired them. 37 years after the crime of the infamous Papirius, an action of the like criminal nature was the cause of the people's retiring to the Ianiculum, and of giving new vigor to the law made for the safety of debtors. Since that time creditors were oftener prosecuted by debtors for having violated the laws against usury than the latter were sued for refusing to pay them. 22. Of things that strike at liberty in monarchies. Liberty often has been weakened in monarchies by a thing of the least use in the world to the prince. This is the naming of commissioners to try a private person. The prince himself derives so very little advantage from those commissioners that it is not worth while to change for their sake the common course of things. He is morally sure that he has more of the spirit of probity and justice than his commissioners, who think themselves sufficiently justified by his nomination and orders, by a vague interest of state, and even by their very apprehensions. Upon the arraigning of a peer under Henry VIII it was customary to try him by a committee of the House of Lords, by which means he put to death as many peers as he pleased. 23. Of spies in monarchies. Should I be asked whether there is any necessity for spies in monarchies, my answer would be that the usual practice of good princes is not to employ them. When a man obeys the laws, he has discharged his duty to his prince. He ought at least to have his own house for an asylum, and the rest of his conduct should be exempt from inquiry. The trade of a spy might perhaps be tolerable, were it practiced by honest men, but the necessary infamy of the person is sufficient to make us judge of the infamy of the thing. A prince ought to act towards his subjects with candor, frankness, and confidence. He that has so much disquiet, suspicion, and fear is an actor embarrassed in playing his part. When he finds that the laws are generally observed and respected, he may judge himself safe. The behavior of the public answers for that of every individual. Let him not be afraid, he cannot imagine how natural it is for his people to love him. And how should they do otherwise than love him, since he is the source of almost all bounties and favors, punishments being generally charged to the account of the laws. He never shows himself to his people but with a serene countenance. They have even a share of his glory, and they are protected by his power. A proof of his being beloved is that his subjects have confidence in him. What the minister refuses, they imagine the prince would have granted. Even under public calamities they do not accuse his person, they are apt to complain of his being misinformed, or beset by corrupt men. Did the prince but know, say the people, these words are a kind of invocation, and a proof of the confidence they have in his person. 24. Of anonymous letters. The Tartars are obliged to put their names to their arrows, that the arm may be known which shoots them. When Philip of Macedon was wounded at the siege of a certain town, These words were found on the javelin. Astur has given this mortal wound to Philip. If they who accuse a person did it merely to serve the public, they would not carry their complaint to the prince, who may be easily prejudiced, but to the magistrates, who have rules that are formidable only to calumniators. But if they are unwilling to leave the laws open between them and the accused, it is a presumption they have reason to be afraid of them, and the least punishment they ought to suffer is not to be credited. No notice, therefore, should ever be taken of those letters, except in cases that admit not of the delays of the ordinary course of justice, and in which the prince's welfare is concerned. Then it may be imagined that the accuser has made an effort, which has untied his tongue. But in other cases one ought to say, with the Emperor Constantius we cannot suspect a person who has wanted an accuser, whilst he did not want an enemy. 25. Of the manner of governing in monarchies. The royal authority is a spring that ought to move with the greatest freedom and ease. The Chinese boast of one of their emperors who governed, they say, like the heavens, that is, by his example. There are some cases in which a sovereign ought to exert the full extent of his power, and others in which he should reduce it within narrower limits. The sublimity of administration consists in knowing the proper degree of power which should be exerted on different occasions. The whole felicity of monarchies consists in the opinion which the subjects entertain of the lenity of the government. A weak minister is ever ready to remind us of our slavery. But granting, even, that we are slaves, he should endeavor to conceal our misery from us. All he can say or write is that the prince is uneasy, that he is surprised, and that he will redress all grievances. There is a certain ease in commanding, the prince ought only to encourage, and let the laws menace. 26. That in a monarchy the prince ought to be of easy access. The utility of this maxim will appear from the inconvenience attending the contrary practice. The Tsar Peter I, says the Sieur Perry has published a new edict, by which he forbids any of his subjects to offer him a petition till after having presented it to 2 of his officers. In case of refusal of justice they may present him a 3rd, but upon pain of death if they are in the wrong. After this no one ever presumed to offer a petition to the Tsar. 27. Of the manners of a monarch. The manners of a prince contribute as much as the laws themselves to liberty. Like these he may transform men into brutes, and brutes into men. If he prefers free and generous spirits, he will have subjects; if he likes base, dastardly souls, he will have slaves. Would he know the great art of ruling, let him call honor and virtue to attend his person, and let him encourage personal merit. He may even sometimes cast an eye on talents and abilities. Let him not be afraid of those rivals who are called men of merit, he is their equal when once he loves them. Let him gain the hearts of his people, without subduing their spirits. Let him render himself popular, he ought to be pleased with the affections of the lowest of his subjects, for they too are men. The common people require so very little condescension, that it is fit they should be humoured. The infinite distance between the sovereign and them will surely prevent them from giving him any uneasiness. Let him be exorable to supplication, and resolute against demands. Let him be sensible, in fine, that his people have his refusals, while his courtiers enjoy his favours. 28. Of the regard which monarchs owe to their subjects. Princes ought to be extremely circumspect with regard to raillery. It pleases with moderation, because it is an introduction to familiarity, but a satirical raillery is less excusable in them than in the meanest of their subjects, for it is they alone that give a mortal wound. Much less should they offer a public affront to any of their subjects. Kings were instituted to pardon and to punish, but never to insult. When they affront their subjects, their treatment is more cruel than that of the Turk or the Muscovite. The insults of these are a humiliation, not a disgrace, but both must follow from the insolent behavior of monarchs. Such is the prejudice of the Eastern nations that they look upon an affront from the prince as the effect of paternal goodness, and such, on the contrary, is our way of thinking that besides the cruel vexation of being affronted, we despair of ever being able to wipe off the disgrace. Princes ought to be overjoyed to have subjects to whom honor is dearer than life, an incitement to fidelity as well as to courage. They should remember the misfortunes that have happened to sovereigns for insulting their subjects, the revenge of Cheria, of the eunuch Narses, of Count Julian, and, in fine, of the Duchess of Montpensier, who, being enraged against Henry III for having published some of her private failings, tormented him during her whole life. 29. Of the civil laws proper for mixing some portion of liberty in a despotic government. Though despotic governments are of their own nature everywhere the same, yet from circumstances, from a religious opinion, from prejudice, from received examples, from a particular turn of mind, from manners or morals, it is possible they may admit of a considerable difference. It is useful that some particular notions should be established in those governments. Thus in China the prince is considered as the father of his people, and at the commencement of the empire of the Arabs, the prince was their preacher. It is proper there should be some sacred book to serve for a rule, as the Quran among the Arabs, the books of Zoroaster among the Persians, the Veda among the Indians, and the classic books among the Chinese. The religious code supplies the civil and fixes the extent of arbitrary sway. It is not at all amiss that in dubious cases the judges should consult the ministers of religion. Thus, in Turkey, the cadis consult the mullahs. But if it is a capital crime, it may be proper for the particular judge, if such there be, to take the governor's advice, to the end that the civil and ecclesiastical power may be tempered also by the political authority. 30. The same subject continued. Nothing but the very excess and rage of despotic power ordained that the father's disgrace should drag after it that of his wife and children. They are wretched enough already without being criminals. Besides, the prince ought to leave suppliants or mediators between himself and the accused, to assuage his wrath or to inform his justice. It is an excellent custom of the Maldivians that when a lord is disgraced he goes every day to pay his court to the king till he is taken again into favor. His presence disarms the prince's indignation. In some despotic governments they have a notion that it is trespassing against the respect due to their prince to speak to him in favor of a person in disgrace. These princes seem to use all their endeavors to deprive themselves of the virtue of clemency. Arcadius and Honorius, by a law on which we have already descanted, positively declare that they will show no favor to those who shall presume to petition them in behalf of the guilty. This was a very bad law indeed, since it is bad even under a despotic government. The custom of Persia, which permits every man that pleases to leave the kingdom, is excellent, and though the contrary practice derives its origin from despotic power, which has ever considered the subjects as slaves and those who quit the country as fugitives, yet the Persian practice is useful even to a despotic government, because the apprehension of people's withdrawing for debt restrains or moderates the oppressions of pashas and extortioners. Book 13. Of the relation which the levying of taxes and the greatness of the public revenues bear to liberty. 1. Of the public revenues. The public revenues are a portion that each subject gives of his property, in order to secure or enjoy the remainder. To fix these revenues in a proper manner, regard should be had both to the necessities of the state and to those of the subject. The real wants of the people ought never to give way to the imaginary wants of the state. Imaginary wants are those which flow from the passions and the weakness of the governors, from the vain conceit of some extraordinary project, from the inordinate desire of glory, and from a certain impotence of mind incapable of withstanding the impulse of fancy. Often have ministers of a restless disposition imagined that the wants of their own mean and ignoble souls were those of the state. Nothing requires more wisdom and prudence than the regulation of that portion of which the subject is deprived, and that which he is suffered to retain. The public revenues should not be measured by the people's abilities to give, but by what they ought to give, and if they are measured by their abilities to give, it should be considered what they are able to give for a constancy. 2. That it is bad reasoning to say that the greatness of taxes is good in its own nature. There have been instances in particular monarchies of petty states exempt from taxes that have been as miserable as the circumjacent places which groaned under the weight of exactions. The chief reason of this is, that the petty state can hardly have any such thing as industry, arts, or manufactures, because of its being subject to 1,000 restraints from the great state by which it is environed. The great state is blessed with industry, manufactures, and arts, and establishes laws by which those several advantages are procured. The petty state becomes, therefore, necessarily poor, let it pay never so few taxes. And yet some have concluded from the poverty of those petty states that in order to render the people industrious they should be loaded with taxes. But it would be a juster inference, that they ought to pay no taxes at all. None live here but wretches who retire from the neighboring parts to avoid working, wretches who, disheartened by labor, make their whole felicity consist in idleness. The effect of wealth in a country is to inspire every heart with ambition, that of poverty is to give birth to despair. The former is excited by labor, the latter is soothed by indolence. Nature is just to all mankind, and repays them for their industry. She renders them industrious by annexing rewards in proportion to their labor. But if an arbitrary prince should attempt to deprive the people of nature's bounty, they would fall into a disrelish of industry, and then indolence and inaction must be their only happiness. 3. Of taxes in countries where part of the people are villains or bondmen. The state of villanage is sometimes established after a conquest. In that case, the bondman or villain that tills the land ought to have a kind of partnership with his master. Nothing but a communication of loss or profit can reconcile those who are doomed to labor to such as are blessed with a state of affluence. 4. Of a republic in the like case. When a republic has reduced a nation to the drudgery of cultivating her lands, she ought never to suffer the free subject to have the power of increasing the tribute of the bondman. This was not permitted at Sparta. Those brave people thought the helots would be more industrious in cultivating their lands, and knowing that their servitude was not to increase, they imagined, likewise, that the masters would be better citizens, when they desired no more than what they were accustomed to enjoy. 5. Of a monarchy in the like case. When the nobles of a monarchical state cause the lands to be cultivated for their own use by a conquered people, they ought never to have the power of increasing the service or tribute. Besides, it is right the prince should be satisfied with his own domain and the military service. But if he wants to raise taxes on the vassals of his nobility, the lords of the several districts ought to be answerable for the tax, and be obliged to pay it for the vassals, by whom they may be afterwards reimbursed. If this rule be not followed, the lord and the collectors of the public taxes will harass the poor vassal by turns till he perishes with misery or flies into the woods. 6. Of a despotic government in the like case. The foregoing rule is still more indispensably necessary in a despotic government. The lord who is every moment liable to be stripped of his lands and his vassals is not so eager to preserve them. When Peter I thought proper to follow the custom of Germany, and to demand his taxes in money, he made a very prudent regulation, which is still followed in Russia. The gentleman levies the tax on the peasant, and pays it to the Tsar. If the number of peasants diminishes, he pays all the same; if it increases, he pays no more, so that it is his interest not to worry or oppress his vassals. 7. Of taxes in countries where villanage is not established. When the inhabitants of a state are all free subjects, and each man enjoys his property with as much right as the prince his sovereignty, taxes may then be laid either on persons, on lands, on merchandise, on two of these, or on all three together. In the taxing of persons, it would be an unjust proportion to conform exactly to that of property. At Athens the people were divided into 4 classes. Those who drew 500 measures of liquid or dried fruit from their estates paid a talent to the public, those who drew 300 measures paid half a talent, those who had 200 measures paid 10 minae, those of 4th class paid nothing at all. The tax was fair, though it was not proportionable. If it did not follow the measure of people's property, it followed that of their wants. It was judged that every man had an equal share of what was necessary for nature, that whatsoever was necessary for nature ought not to be taxed, that to this succeeded the useful, which ought to be taxed, but less than the superfluous, and that the largeness of the taxes on what was superfluous prevented superfluity. In the taxing of lands it is customary to make lists or registers, in which the different classes of estates are ranged. But it is very difficult to know these differences, and still more so to find people that are not interested in mistaking them. Here, therefore, are two sorts of injustice, that of the man and that of the thing. But if in general the tax be not exorbitant, and the people continue to have plenty of necessaries, these particular acts of injustice will do no harm. On the contrary, if the people are permitted to enjoy only just what is necessary for subsistence, the least disproportion will be of the greatest consequence. If some subjects do not pay enough, the mischief is not so great, their convenience and ease turn always to the public advantage. If some private people pay too much, their ruin redounds to the public detriment. If the government proportions its fortune to that of individuals, the ease and convenience of the latter will soon make its fortune rise. The whole depends upon a critical moment: shall the state begin with impoverishing the subjects to enrich itself? Or had it better wait to be enriched by its subjects? Is it more advisable for it to have the former or the latter advantage? Which shall it choose to begin or to end with opulence? The duties felt least by the people are those on merchandise, because they are not demanded of them in form. They may be so prudently managed that the people themselves shall hardly know they pay them. For this purpose it is of the utmost consequence that the person who sells the merchandise should pay the duty. He is very sensible that he does not pay it for himself, and the consumer, who pays it in the main, confounds it with the price. Some authors have observed that Nero had abolished the duty of the 25th part arising from the sale of slaves, and yet he had only ordained that it should be paid by the seller instead of the purchaser. This regulation, which left the impost entire, seemed nevertheless to suppress it. There are two states in Europe where the imposts are very heavy upon liquors. In one the brewer alone pays the duty, in the other it is levied indiscriminately upon all the consumers. In the first nobody feels the rigor of the impost, in the second it is looked upon as a grievance. In the former the subject is sensible only of the liberty he has of not paying, in the latter he feels only the necessity that compels him to pay. Further, the obliging the consumers to pay requires a perpetual rummaging and searching into their houses. Now nothing is more contrary than this to liberty, and those who establish these sorts of duties have not surely been so happy as to hit upon the best method of collecting the revenue. 8. In what manner the deception is preserved. In order to make the purchaser confound the price of the commodity with the impost, there must be some proportion between the impost and the value of the commodity, for which reason there ought not to be an excessive duty upon merchandise of little value. There are countries in which the duty exceeds 17 or 18 times the value of the commodity. In this case the prince removes the disguise, his subjects plainly see they are dealt with in an unreasonable manner, which renders them most exquisitely sensible of their servile condition. Besides, the prince, to be able to levy a duty so disproportioned to the value of the commodity, must be himself the vendor, and the people must not have it in their power to purchase it elsewhere, a practice subject to 1,000 inconveniences. Smuggling being in this case extremely lucrative, the natural and most reasonable penalty, namely, the confiscation of the merchandise, becomes incapable of putting a stop to it, especially as this very merchandise is intrinsically of inconsiderable value. Recourse must therefore be had to extravagant punishments, such as those inflicted for capital crimes. All proportion then of penalties is at an end. Persons that cannot really be considered as vicious are punished like the most infamous criminals, which of all things in the world is the most contrary to the spirit of a moderate government. Again, in proportion as people are tempted to cheat the farmer of the revenues, the more the latter is enriched, and the former impoverished. To put a stop to smuggling, the farmer must be invested with extraordinary means of oppressing, and then the country is ruined. 9. Of a bad kind of impost. We shall here, by the way, take notice of an impost laid in particular countries on the different articles of civil contracts. As these are things subject to very nice disquisitions, a vast deal of knowledge is necessary to make any tolerable defense against the farmer of the revenues, who interprets, in that case, the regulations of the prince, and exercises an arbitrary power over people's fortunes. Experience has demonstrated that a duty on the paper on which the deeds are drawn would be of far greater service. 10. That the greatness of taxes depends on the nature of the government. Taxes ought to be very light in despotic governments, otherwise who would be at the trouble of tilling the land? Besides, How is it possible to pay heavy duties in a government that makes no manner of return to the different contributions of the subject? The exorbitant power of the prince, and the extreme depression of the people, require that there should not be even a possibility of the least mistake between them. The taxes ought to be so easy to collect, and so clearly settled, as to leave no opportunity for the collectors to increase or diminish them. A portion of the fruits of the earth, a capitation, a duty of so much % on merchandise, are the only taxes suitable to that government. Merchants in despotic countries ought to have a personal safeguard, to which all due respect should be paid. Without this they would be too weak to dispute with the custom house officers. 11. Of confiscations. With respect to confiscations, there is one thing very particular that, contrary to the general custom, they are more severe in Europe than in Asia. In Europe not only the merchandise, but even sometimes the ships and carriages, are confiscated, which is never practiced in Asia. This is because in Europe the merchant can have recourse to magistrates, who are able to shelter him from oppression. In Asia the magistrates themselves would be the greatest oppressors. What remedy could a merchant have against a pasha who was determined to confiscate his goods? The prince, therefore, checks his own power, finding himself under the necessity of acting with some kind of lenity. In Turkey they raise only a single duty for the importation of goods, and afterwards the whole country is open to the merchant. Smuggling is not attended with confiscation or increase of duty. In China they never look into the baggage of those who are not merchants. Defrauding the customs in the territory of the Mughal is not punished with confiscation, but with doubling the duty. The princes of Tartary, who reside in towns, impose scarcely any duty at all on the goods that pass through their country. In Japan, it is true, to cheat the customs is a capital crime, but this is because they have particular reasons for prohibiting all communication with foreigners, hence the fraud is rather a contravention of the laws made for the security of the government than of those of commerce. 12. Relation between the weight of taxes and liberty. It is a general rule that taxes may be heavier in proportion to the liberty of the subject, and that there is a necessity for reducing them in proportion to the increase of slavery. This has always been and always will be the case. It is a rule derived from nature that never varies. We find it in all parts in England, in Holland, and in every state where liberty gradually declines, till we come to Turkey. Switzerland seems to be an exception to this rule, because they pay no taxes, but the particular reason for that exemption is well known, and even confirms what I have advanced. In those barren mountains provisions are so dear, and the country is so populous, that a Swiss pays 4 times more to nature than a Turk does to the Sultan. A conquering people, such as were formerly the Athenians and the Romans, may rid themselves of all taxes as they reign over vanquished nations. Then indeed they do not pay in proportion to their liberty, because in this respect they are no longer a people, but a monarch. But the general rule still holds good. In moderate governments there is an indemnity for the weight of the taxes, which is liberty. In despotic countries there is an equivalent for liberty, which is the lightness of the taxes. In some monarchies in Europe there are particular provinces which from the very nature of their civil government are in a more flourishing condition than the rest. It is pretended that these provinces are not sufficiently taxed, because through the goodness of their government they are able to be taxed higher, hence the ministers seem constantly to aim at depriving them of this very government, whence a diffusive blessing is derived, which redounds even to the prince's advantage. 13. In what government taxes are capable of increase? Taxes may be increased in most republics, because the citizen, who thinks he is paying himself, cheerfully submits to them, and moreover is generally able to bear their weight, from the nature of the government. In a monarchy taxes may be increased, because the moderation of the government is capable of procuring opulence. It is a recompense, as it were, granted to the prince for the respect he shows to the laws. In despotic governments they cannot be increased, because there can be no increase of the extremity of slavery. 14. That the nature of the taxes is in relation to the government. A capitation is more natural to slavery, a duty on merchandise is more natural to liberty, by reason it has not so direct a relation to the person. It is natural in a despotic government for the prince not to give money to his soldiers, or to those belonging to his court, but to distribute lands amongst them, and of course that there should be very few taxes. But if the prince gives money, the most natural tax he can raise is a capitation, which can never be considerable. For as it is impossible to make different classes of the contributors, because of the abuses that might arise thence, considering the injustice and violence of the government, they are under an absolute necessity of regulating themselves by the rate of what even the poorest and most wretched are able to contribute. The natural tax of moderate governments is the duty laid on merchandise. As this is really paid by the consumer, though advanced by the merchant, it is a loan which the latter has already made to the former. Hence the merchant must be considered on the one side as the general debtor of the state, and on the other as the creditor of every individual. He advances to the state the duty which the consumer will sometime or other refund, and he has paid for the consumer the duty which he has advanced for the merchandise. It is therefore obvious that in proportion to the moderation of the government, to the prevalence of the spirit of liberty, and to the security of private fortunes, a merchant has it in his power to advance money to the state, and to pay considerable duties for individuals. In England a merchant lends really to the government 50 or 60 pounds sterling for every ton of wine he imports. Where is the merchant that would dare do any such thing in a country like Turkey? And were he so presumptuous, how could he do it with a crazy or shattered fortune? 15. Abuse of liberty. To these great advantages of liberty it is owing that liberty itself has been abused. Because a moderate government has been productive of admirable effects, this moderation has been laid aside. Because great taxes have been raised, they wanted to carry them to excess, and ungrateful to the hand of liberty, of whom they received this present, they addressed themselves to slavery, who never grants the least favor. Liberty produces excessive taxes, the effect of excessive taxes is slavery, and slavery produces a diminution of tribute. Most of the edicts of the Eastern monarchs are to exempt every year some province of their empire from paying tribute. The manifestations of their wills are favors. But in Europe the edicts of princes are disagreeable even before they are seen, because they always make mention of their own wants, but not a word of ours. From an unpardonable indolence in the ministers of those countries, owing to the nature of the government, and frequently to the climate, the people derive this advantage, that they are not incessantly plagued with new demands. The public expense does not increase, because the ministers do not form new projects, and if some by chance are formed, they are such as are soon executed. The governors oft state do not perpetually torment the people, for they do not perpetually torment themselves. But it is impossible there should be any fixed rule in our finances, since we always know that we shall have something or other to execute, without ever knowing what it is. It is no longer customary with us to give the appellation of a great minister to a wise dispenser of the public revenues, but to a person of dexterity and cunning, who is clever at finding out what we call the ways and means. 16. Of the conquests of the Mahometans. It was this excess of taxes that occasioned the prodigious facility with which the Mahometans carried on their conquests. Instead of a continual series of extortions devised by the subtle avarice of the Greek emperors, the people were subjected to a simple tribute which was paid and collected with ease. Thus they were far happier in obeying a barbarous nation than a corrupt government, in which they suffered every inconvenience of lost liberty, with all the horror of present slavery. 17. Of the augmentation of troops. A new distemper has spread itself over Europe, infecting our princes, and inducing them to keep up an exorbitant number of troops. It has its redoublings, and of necessity becomes contagious. For as soon as one prince augments his forces, the rest of course do the same, so that nothing is gained thereby but the public ruin. Each monarch keeps as many armies on foot as if his people were in danger of being exterminated, and they give the name of peace to this general effort of all against all. Thus is Europe ruined to such a degree that were private people to be in the same situation as the three most opulent powers of this part of the globe, they would not have necessary subsistence. We are poor with the riches and commerce of the whole world, and soon, by thus augmenting our troops, we shall be all soldiers, and be reduced to the very same situation as the Tartars. Great princes, not satisfied with hiring or buying troops of petty states, make it their business on all sides to pay subsidies for alliances, that is, generally to throw away their money. The consequence of such a situation is the perpetual augmentation of taxes, and the mischief which prevents all future remedy is that they reckon no more upon their revenues, but in waging war against their whole capital. It is no unusual thing to see governments mortgage their funds even in time of peace, and to employ what they call extraordinary means to ruin themselves, means so extraordinary indeed, that such are hardly thought of by the most extravagant young spendthrift. 18. Of an exemption from taxes. The maxim of the great Eastern empires, of exempting such provinces as have very much suffered from taxes, ought to be extended to monarchical states. There are some, indeed, where this practice is established, yet the country is more oppressed than if no such rule took place, because as the prince levies still neither more nor less, the state becomes bound for the whole. In order to ease a village that pays badly, they load another that pays better, the former is not relieved, and the latter is ruined. The people grow desperate, between the necessity of paying for fear of exactions, and the danger of paying for fear of new burdens. A well-regulated government ought to set aside, for the first article of its expense, a determinate sum to answer contingent cases. It is with the public as with individuals, who are ruined when they live up exactly to their income. With regard to an obligation for the whole amongst the inhabitants of the same village, some pretend that it is but reasonable, because there is a possibility of a fraudulent combination on their side, but was it ever heard that, upon mere supposition, we are to establish a thing in itself unjust and ruinous to the state? 19. Which is more suitable to the prince and to the people, the farming the revenues, or managing them by commission? The managing of the revenues by commission is like the conduct of a good father of a family, who collects his own rents himself with economy and order. By this management of the revenues the prince is at liberty to press or to retard the levy of the taxes, either according to his own wants or to those of his people. By this he saves to the state the immense profits of the farmers, who impoverish it in 1,000 ways. By this he prevents the people from being mortified with the sight of sudden fortunes. By this the public money passes through few hands, goes directly to the treasury, and consequently makes a quicker return to the people. By this the prince avoids an infinite number of bad laws extorted from him by the importunate avarice of the farmers, who pretend to offer a present advantage for regulations pernicious to posterity. As the moneyed man is always the most powerful, the farmer renders himself arbitrary even over the prince himself. He is not the legislator, but he obliges the legislator to give laws. I acknowledge that it is sometimes of use to farm out a new duty, for there is an art in preventing frauds, which motives of interest suggest to the farmers, but commissioners never think of. Now the manner of levying it being once established by the farmer, it may afterwards be safely entrusted to a commission. In England the management of the excise and of the post office was borrowed from that of the farmers of the revenue. In republics the revenues of the state are generally managed by commission. The contrary practice was a great defect in the Roman government. In despotic governments the people are infinitely happier where this management is established, witness Persia and China. The unhappiest of all are those where the prince farms out his seaports and trading cities. The history of monarchies abounds with mischiefs done by the farmers of the revenue. Incensed at the oppressive extortions of the publicans, Nero formed a magnanimous but impracticable scheme of abolishing all kinds of imposts. He did not think of managing the revenues by commissioners, but he made 4 edicts, that the laws enacted against publicans, which had hitherto been kept secret, should be promulgated, that they should exact no claims for above a year backward, that there should be a praetor established to determine their pretensions without any formality, and that the merchants should pay no duty for their vessels. These were the halcyon days of that emperor. 20. Of the farmers of the revenues. When the lucrative profession of a farmer of the revenue becomes likewise a post of honor, the state is ruined. It may do well enough in despotic governments, where this employment is oftentimes exercised by the governors themselves. But it is by no means proper in a republic, since a custom of the like nature destroyed that of Rome. Nor is it better in monarchies, nothing being more opposite to the spirit of this government. All the other orders of the state are dissatisfied, honor loses its whole value, the gradual and natural means of distinction are no longer respected, and the very principle of the government is subverted. It is true indeed that scandalous fortunes were raised in former times, but this was one of the calamities of the 50 Years' War. These riches were then considered as ridiculous, now we admire them. Every profession has its particular lot. That of the tax-gatherers is wealth. And wealth is its own reward. Glory and honor fall to the share of that nobility who are sensible of no other happiness. Respect and esteem are for those ministers and magistrates whose whole life is a continued series of labor, and who watch day and night over the welfare of the empire. Book 14. Of Laws in Relation to the Nature of the Climate. 1. General Idea. If it be true that the temper of the mind and the passions of the heart are extremely different in different climates, the laws ought to be in relation both to the variety of those passions and to the variety of those tempers. 2. Of the difference of men in different climates. Cold air constrings the extremities of the external fibers of the body, this increases their elasticity, and favors the return of the blood from the extreme parts to the heart. It contracts those very fibers, consequently it increases also their force. On the contrary, warm air relaxes and lengthens the extreme soft fibers, of course it diminishes their force and elasticity. People are therefore more vigorous in cold climates. Here the action of the heart and the reaction of the extremities of the fibers are better performed, the temperature oft humors is greater, the blood moves more freely towards the heart, and reciprocally the heart has more power. This superiority of strength must produce various effects, for instance, a greater boldness, that is, more courage, a greater sense of superiority, that is, less desire of revenge, a greater opinion of security, that is, more frankness, less suspicion, policy, and cunning. In short, this must be productive of very different tempers. Put a man into a close, warm place, and for the reasons above given he will feel a great faintness. If under this circumstance you propose a bold enterprise to him, I believe you will find him very little disposed towards it, his present weakness will throw him into despondency, he will be afraid of everything, being in a state of total incapacity. The inhabitants of warm countries are, like old men, timorous, the people in cold countries are, like young men, brave. If we reflect on the late wars, which are more recent in our memory, and in which we can better distinguish some particular effects that escape us at a greater distance of time, we shall find that the northern people, transplanted into southern regions, did not perform such exploits as their countrymen who, fighting in their own climate, possessed their full vigor and courage. This strength of the fibers in northern nations is the cause that the coarser juices are extracted from their aliments. Hence two things result: 1. That the parts of the chyle or lymph are more proper, by reason of their large surface, to be applied to and to nourish the fibers; the other, that they are less proper, from their coarseness, to give a certain subtlety to the nervous juice. Those people have therefore large bodies and but little vivacity. The nerves that terminate from all parts in the cutis form each a nervous bundle. Generally speaking, the whole nerve is not moved, but a very minute part. In warm climates, where the cutis is relaxed, the ends of the nerves are expanded and laid open to the weakest action of the smallest objects. In cold countries the cutis is constricted and the papillae compressed, the miliary glands are in some measure paralytic, and the sensation does not reach the brain, except when it is very strong and proceeds from the whole nerve at once. Now, imagination, taste, sensibility, and vivacity depend on an infinite number of small sensations. I have observed the outermost part of a sheep's tongue, where, to the naked eye, it seems covered with papillae. On these papillae I have discerned through a microscope small hairs, or a kind of down; between the papillae were pyramids shaped towards the ends like pincers. Very likely these pyramids are the principal organ of taste. I caused the half of this tongue to be frozen, and, observing it with the naked eye, I found the papillae considerably diminished, even some rows of them were sunk into their sheath. The outermost part I examined with the microscope, and perceived no pyramids. In proportion as the frost went off, the papillae seemed to the naked eye to rise, and with the microscope the miliary glands began to appear. This observation confirms what I have been saying, that in cold countries the nervous glands are less expanded, they sink deeper into their sheaths, or they are sheltered from the action of external objects, consequently they have not such lively sensations. In cold countries they have very little sensibility toward pleasure, in temperate countries, they have more, in warm countries, their sensibility is exquisite. As climates are distinguished by degrees of latitude, we might distinguish them also in some measure by those of sensibility. I have been at the opera in England and in Italy, where I have seen the same pieces and the same performers, and yet the same music produces such different effects on the two nations, one is so cold and phlegmatic, and the other so lively and enraptured, that it seems almost inconceivable. It is the same with regard to pain, which is excited by the laceration of some fiber of the body. The author of nature has made it an established rule that this pain should be more acute in proportion as the laceration is greater. Now it is evident that the large bodies and coarse fibers of the people of the north are less capable of laceration than the delicate fibers of the inhabitants of warm countries, consequently the soul is there less sensible of pain. You must flay a Muscovite alive to make him feel. From this delicacy of organs peculiar to warm climates it follows that the soul is most sensibly moved by whatever relates to the union of the two sexes. Here everything leads to this object. In northern climates scarcely has the animal part of love a power of making itself felt. In temperate climates, love, attended by 1,000 appendages, endeavors to please by things that have at first the appearance though not reality, of this passion. In warmer climates it is liked for its own sake, it is the only cause of happiness, it is life itself. In southern countries a machine of a delicate frame but strong sensibility resigns itself either to a love which rises and is incessantly laid in a seraglio, or to a passion which leaves women in a greater independence, and is consequently exposed to 1,000 inquietudes. In northern regions a machine robust and heavy finds pleasure in whatever is apt to throw the spirits into motion, such as hunting, traveling, war, and wine. If we travel towards the north, we meet with people who have few vices, many virtues, and a great share of frankness and sincerity. If we draw near the south, we fancy ourselves entirely removed from the verge of morality. Here the strongest passions are productive of all manner of crimes, each man endeavoring, let the means be what they will, to indulge his inordinate desires. In temperate climates we find the inhabitants inconstant in their manners, as well as in their vices and virtues. The climate has not a quality determinate enough to fix them. The heat of the climate may be so excessive as to deprive the body of all vigor and strength. Then the faintness is communicated to the mind, there is no curiosity, no enterprise, no generosity of sentiment, the inclinations are all passive, indolence constitutes the utmost happiness. Scarcely any punishment is so severe as mental employment, and slavery is more supportable than the force and vigor of mind necessary for human conduct. 3. Contradiction in the tempers of some southern nations. The Indians are naturally a pusillanimous people, even the children of Europeans born in India lose the courage peculiar to their own climate. But how shall we reconcile this with their customs and penances so full of barbarity? The men voluntarily undergo the greatest hardships, and the women burn themselves. Here we find a very odd compound of fortitude and weakness. Nature, having framed those people of a texture so weak as to fill them with timidity, has formed them at the same time of an imagination so lively that every object makes the strongest impression upon them. That delicacy of organs which renders them apprehensive of death contributes likewise to make them dread 1,000 things more than death. The very same sensibility induces them to fly and dare all dangers. As a good education is more necessary to children than to such as have arrived at maturity of understanding, so the inhabitants of those countries have much greater need than the European nations of a wiser legislator. The greater their sensibility, the more it behoves them to receive proper impressions, to imbibe no prejudices, and to let themselves be directed by reason. At the time of the Romans, the inhabitants of the north of Europe were destitute of arts, education, and almost of laws, and yet the good sense annexed to the gross fibers of those climates enabled them to make an admirable stand against the power of Rome, till the memorable period in which they quitted their woods to subvert that great empire. 4. Cause of the immutability of religion, manners, customs, and laws in the eastern countries. If to that delicacy of organs which renders the eastern nations so susceptible of every impression you add likewise a sort of indolence of mind, naturally connected with that of the body, by means of which they grow incapable of any exertion or effort, it is easy to comprehend that when once the soul has received an impression it cannot change it. This is the reason that the laws, manners, and customs, even those which seem quite indifferent, such as their mode of dress, are the same to this very day in eastern countries as they were 1,000 years ago. 5. That those are bad legislators who favor the vices of the climate, and good legislators who oppose those vices. The Indians believe that repose and non-existence are the foundation of all things, and the end in which they terminate. Hence they consider entire inaction as the most perfect of all states, and the object of their desires. To the Supreme Being they give the title of immovable. The inhabitants of Siam believe that their utmost happiness consists in not being obliged to animate a machine, or to give motion to a body. In those countries where the excess of heat enervates and exhausts the body, rest is so delicious, and motion so painful, that this system of metaphysics seems natural, and Foe, the legislator of the Indies, was directed by his own sensations when he placed mankind in a state extremely passive, but his doctrine arising from the laziness of the climate favored it also in its turn, which has been the source of an infinite deal of mischief. The legislators of China were more rational when, considering men not in the peaceful state which they are to enjoy hereafter, but in the situation proper for discharging the several duties of life, they made their religion, philosophy, and laws all practical. The more the physical causes incline mankind to inaction, the more the moral causes should estrange them from it. 6. Of agriculture in warm climates. Agriculture is the principal labor of man. The more the climate inclines him to shun this labor, the more the religion and laws of the country ought to incite him to it. Thus the Indian laws, which give the lands to the prince, and destroy the spirit of property among the subjects, increase the bad effects oft climate, that is, their natural indolence. 7. Of monarchy. The very same mischiefs result from monarchy. It had its rise in the warm countries of the East, where they are less inclined to action than to speculation. In Asia the number of dervishes or monks seems to increase together with the warmth of the climate. The Indies, where the heat is excessive, are full of them, and the same difference is found in Europe. In order to surmount the laziness of the climate, the laws ought to endeavor to remove all means of subsisting without labor, but in the southern parts of Europe they act quite the reverse. To those who want to live in a state of indolence, they afford retreats the most proper for a speculative life, and endow them with immense revenues. These men, who live in the midst of plenty which they know not how to enjoy, are in the right to give their superfluities away to the common people. The poor are bereft of property, and these men indemnify them by supporting them in idleness, so as to make them even grow fond of their misery. 8. An excellent custom of China. The historical relations of China mention a ceremony of opening the ground which the emperor performs every year. The design of this public and solemn act is to excite the people to tillage. Further, the emperor is every year informed of the husbandman who has distinguished himself most in his profession, and he makes him a mandarin of the 8th order. Among the ancient Persians the kings quitted their grandeur and pomp on the 8th day of the month, called Khorramraz, to eat with the husbandman. These institutions were admirably calculated for the encouragement of agriculture. 9. Means of encouraging industry. We shall show, in the 19th book, that lazy nations are generally proud. Now the effect might well be turned against the cause, and laziness be destroyed by pride. In the south of Europe, where people have such a high notion of the point of honor, it would be right to give prizes to husbandmen who had excelled in agriculture, or to artists who had made the greatest improvements in their several professions. This practice has succeeded in our Days in Ireland, where it has established one of the most considerable linen manufactures in Europe. 10. Of the laws in relation to the sobriety of the people. In warm countries the aqueous part of the blood loses itself greatly by perspiration, it must therefore be supplied by a like liquid. Water is there of admirable use, strong liquors would congeal the globules of blood that remain after the transuding of the aqueous humour. In cold countries the aqueous part of the blood is very little evacuated by perspiration. They may therefore make use of spirituous liquors, without which the blood would congeal. They are full of humours, consequently strong liquors, which give a motion to the blood, are proper for those countries. The law of Mahomet, which prohibits the drinking of wine, is therefore fitted to the climate of Arabia, and indeed, before Mahomet's time, water was the common drink of Arabs. The law which forbade the Carthaginians to drink wine was a law of the climate, and, indeed, the climate of those two countries is pretty nearly the same. Such a law would be improper for cold countries, where the climate seems to force them to a kind of national intemperance, very different from personal ebriety. Drunkenness predominates throughout the world, in proportion to the coldness and humidity of climate. Go from the equator to the North Pole, and you will find this vice increasing together with the degree of latitude. Go from the equator again to the South Pole, and you will find the same vice traveling south exactly in the same proportion. It is very natural that where wine is contrary to the climate, and consequently to health, the excess of it should be more severely punished than in countries where intoxication produces very few bad effects to the person, fewer to the society, and where it does not make people frantic and wild, but only stupid and heavy. Hence those laws which inflicted a double punishment for crimes committed in drunkenness were applicable only to a personal, and not to a national, ebriety. A German drinks through custom, and a Spaniard by choice. In warm countries the relaxing oft fibers produces a great evacuation oft liquids, but the solid parts are less transpired. The fibers, which act but faintly, and have very little elasticity, are not much impaired, and a small quantity of nutritious juice is sufficient to repair them, for which reason they eat very little. It is the variety of wants in different climates that first occasioned a difference in the manner of living, and this gave rise to a variety of laws. Where people are very communicative there must be particular laws, and others where there is but little communication. 11. Of the laws in relation to the distempers of the climate. Herodotus informs us that the Jewish laws concerning the leprosy were borrowed from the practice of the Egyptians. And, indeed, the same distemper required the same remedies. The Greeks and the primitive Romans were strangers to these laws, as well as to the disease. The climate of Egypt and Palestine rendered them necessary, and the facility with which this disease is spread is sufficient to make us sensible of the wisdom and sagacity of those laws. Even we ourselves have felt the effects of them. The Crusades brought the leprosy amongst us, but wise regulations made at that time hindered it from infecting the mass of the people. We find by the law of the Lombards that this disease was spread in Italy before the Crusades, and merited the attention of the legislature. Rotharius ordained that a leper should be expelled from his house, banished to a particular place, and rendered incapable of disposing of his property, because from the very moment he had been turned out of his house he was reckoned dead in the eye of the law. In order to prevent all communication with lepers, they were rendered incapable of civil acts. I am apt to think that this disease was brought into Italy by the conquests of the Greek emperors, in whose armies there might be some soldiers from Palestine or Egypt. Be that as it may, the progress of it was stopped till the time of the Crusades. It is related that Pompey's soldiers returning from Syria brought a distemper home with them not unlike the leprosy. We have no account of any regulation made at that time, but it is highly probable that some such step was taken, since the distemper was checked till the time of the Lombards. It is now 2 centuries since a disease unknown to our ancestors was first transplanted from the New World to ours, and came to attack human nature even in the very source of life and pleasure. Most of the principal families in the south of Europe were seen to perish by a distemper that had grown too common to be ignominious, and was considered in no other light than in that of its being fatal. It was the thirst of gold that propagated this disease, the Europeans went continually to America, and always brought back a new leaven of it. Reasons drawn from religion seemed to require that this punishment of guilt should be permitted to continue, but the infection had reached the bosom of matrimony, and given the vicious taint even to guiltless infants. As it is the business of legislators to watch over the health of the citizens, it would have been a wise part in them to have stopped this communication by laws made on the plan of those of Moses. The plague is a disease whose infectious progress is much more rapid. Egypt is its principal seat, whence it spreads over the whole globe. Most countries in Europe have made exceedingly good regulations to prevent this infection, and in our times an admirable method has been contrived to stop it. This is by forming a line of troops round the infected country, which cuts off all manner of communication. The Turks, who have no such regulations, see the Christians escape this infection in the same town, and none but themselves perish. They buy the clothes of the infected, wear them, and proceed in their old way, as if nothing had happened. The doctrine of a rigid fate, which directs their whole conduct, renders the magistrate a quiet spectator. He thinks that everything comes from the hand of God, and that man has nothing more to do than to submit. 12. Of the laws against suicides. We do not find in history that the Romans ever killed themselves without a cause, but the English are apt to commit suicide most unaccountably. They destroy themselves even in the bosom of happiness. This action among the Romans was the effect of education, being connected with their principles and customs. Among the English it is the consequence of a distemper, being connected with the physical state of the machine, and independent of every other cause. In all probability it is a defect of the filtration of the nervous juice. The machine, whose motive faculties are often unexerted, is weary of itself. The soul feels no pain, but a certain uneasiness in existing. Pain is a local sensation, which leads us to the desire of seeing an end of it. The burden of life, which prompts us to the desire of ceasing to exist, is an evil confined to no particular part. It is evident that the civil laws of some countries may have reasons for branding suicide with infamy, but in England it cannot be punished without punishing the effects of madness. 13. Effects arising from the climate of England. In a nation so distempered by the climate as to have a disrelish of everything, nay, even of life, it is plain that the government most suitable to the inhabitants is that in which they cannot lay their uneasiness to any single person's charge, and in which, being under the direction rather of the laws than of the prince, it is impossible for them to change the government without subverting the laws themselves. And if this nation has likewise derived from the climate a certain impatience of temper, which renders them incapable of bearing the same train of things for any long continuance, it is obvious that the government above mentioned is the fittest for them. This impatience of temper is not very considerable of itself, but it may become so when joined with courage. It is quite a different thing from levity, which makes people undertake or drop a project without cause. It borders more upon obstinacy, because it proceeds from so lively a sense of misery that it is not weakened even by the habit of suffering. This temper in a free nation is extremely proper for disconcerting the projects of tyranny, which is always slow and feeble in its commencement, as in the end it is active and lively, which at first only stretches out a hand to assist, and exerts afterwards a multitude of arms to oppress. Slavery is ever preceded by sleep. But a people who find no rest in any situation, who continually explore every part, and feel nothing but pain, can hardly be lulled to sleep. Politics is a smooth file, which cuts gradually, and attains its end by a slow progression. Now the people of whom we have been speaking are incapable of bearing the delays, the details, and the coolness of negotiations. In these they are more unlikely to succeed than any other nation, hence they are apt to lose by treaties what they obtain by their arms. 14. Other effects of the climate. Our ancestors, the ancient Germans, lived in a climate where the passions were extremely calm. Their laws decided only in such cases where the injury was visible to the eye, and went no further. And as they judged of the outrages done to men from the greatness of the wound, they acted with no other delicacy in respect to the injuries done to women. The law of the Alemans on this subject is very extraordinary. If a person uncovers a woman's head, he pays a fine of 50 sous. If he uncovers her leg up to the knee, he pays the same. and double from the knee upwards. One would think that the law measured the insults offered to women as we measure a figure in geometry. It did not punish the crime of the imagination, but that of the eye. But upon the migration of a German nation into Spain, the climate soon found a necessity for different laws. The law of the Visigoths inhibited the surgeons to bleed a free woman, except either her father, mother, brother, son, or uncle was present. As the imagination of the people grew warm, so did that of the legislators. The law suspected everything when the people had become suspicious. These laws had, therefore, a particular regard for the two sexes. But in their punishments they seem rather to humor the revengeful temper of private persons than to administer public justice. Thus, in most cases, they reduced both the criminals to be slaves to the offended relatives or to the injured husband. A free-born woman who had yielded to the embraces of a married man was delivered up to his wife to dispose of her as she pleased. They obliged the slaves, if they found their master's wife in adultery, to bind her and carry her to her husband. They even permitted her children to be her accusers, and her slaves to be tortured in order to convict her. Thus their laws were far better adapted to refine, even to excess, a certain point of honor than to form a good civil administration. We must not, therefore, be surprised if Count Julian was of opinion that an affront of that kind ought to be expiated by the ruin of his king and country. We must not be surprised if the Moors, with such a conformity of manners, found it so easy to settle and to maintain themselves in Spain, and to retard the fall of their empire. 15. Of the different confidence which the laws have in the people according to the difference of climates. The people of Japan are of so stubborn and perverse a temper that neither their legislators nor magistrates can put any confidence in them. They set nothing before their eyes but judgments, menaces, and chastisements. Every step they take is subject to the inquisition of the civil magistrate. Those laws which out of 5 heads of families establish one as a magistrate over the other 4, those laws which punish a family or a whole ward for a single crime, those laws, in fine, which find nobody innocent where one may happen to be guilty, are made with a design to implant in the people a mutual distrust, and to make every man the inspector, witness, and judge of his neighbor's conduct. On the contrary, the people of India are mild, tender, and compassionate. Hence their legislators repose great confidence in them. They have established very few punishments. These are not severe, nor are they rigorously executed. They have subjected nephews to their uncles, and orphans to their guardians, as in other countries they are subjected to their fathers. They have regulated the succession by the acknowledged merit of the successor. They seem to think that every individual ought to place entire confidence in the good nature of his fellow subjects. They enfranchise their slaves without difficulty, they marry them, they treat them as their children. Happy climate which gives birth to innocence, and produces a lenity in the laws. Book 15. In what manner the laws of civil slavery relate to the nature of the climate. 1. Of civil slavery. Slavery, properly so called, is the establishment of a right which gives to one man such a power over another as renders him absolute master of his life and fortune. The state of slavery is in its own nature bad. It is neither useful to the master nor to the slave, not to the slave, because he can do nothing through a motive of virtue, nor to the master, because by having an unlimited authority over his slaves he insensibly accustoms himself to the want of all moral virtues, and thence becomes fierce, hasty, severe, choleric, voluptuous, and cruel. In despotic countries, where they are already in a state of political servitude, civil slavery is more tolerable than in other governments. Every one ought to be satisfied in those countries with necessaries in life. Hence the condition of a slave is hardly more burdensome than that of a subject. But in a monarchical government, where it is of the utmost importance that human nature should not be debased or dispirited, there ought to be no slavery. In democracies, where they are all upon equality, and in aristocracies, where the laws ought to use their utmost endeavors to procure as great an equality as the nature of the government will permit, slavery is contrary to the spirit of the Constitution. It only contributes to give a power and luxury to the citizens which they ought not to have. 2. Origin of the right of slavery among the Roman civilians. One would never have imagined that slavery should owe its birth to pity, and that this should have been excited in 3 different ways. The law of nations to prevent prisoners from being put to death has allowed them to be made slaves. The civil law of the Romans empowered debtors, who were subject to be ill-used by their creditors, to sell themselves. And the law of nature requires that children whom a father in a state of servitude is no longer able to maintain should be reduced to the same state as the father. These reasons of the civilians are all false. It is false that killing in war is lawful, unless in a case of absolute necessity, but when a man has made another his slave, he cannot be said to have been under a necessity of taking away his life, since he actually did not take it away. War gives no other right over prisoners than to disable them from doing any further harm by securing their persons. All nations concur in detesting the murdering of prisoners in cold blood. Neither is it true that a freeman can sell himself. Sale implies a price. Now when a person sells himself, his whole substance immediately devolves to his master. The master therefore, in that case, gives nothing, and the slave receives nothing. You will say he has a peculium. But this peculium goes along with his person. If it is not lawful for a man to kill himself because he robs his country of his person, for the same reason he is not allowed to barter his freedom. The freedom of every citizen constitutes a part of the public liberty, and in a democratic state is even a part of the sovereignty. To sell one's freedom is so repugnant to all reason as can scarcely be supposed in any man. If liberty may be rated with respect to the buyer, it is beyond all price to the seller. The civil law, which authorizes a division of goods among men, cannot be thought to rank among such goods a part of the men who were to make this division. The same law annuls all iniquitous contracts, surely then it affords redress in a contract where the grievance is most enormous. The third way is birth, which falls with the 2 former, for if a man could not sell himself, much less could he sell an unborn infant. If a prisoner of war is not to be reduced to slavery, much less are his children. The lawfulness of putting a malefactor to death arises from this circumstance. The law by which he is punished was made for his security. A murderer, for instance, has enjoyed the benefit of the very law which condemns him. It has been a continual protection to him, he cannot, therefore, object to it. But it is not so with the slave. The law of slavery can never be beneficial to him, it is in all cases against him, without ever being for his advantage, and therefore this law is contrary to the fundamental principle of all societies. If it be pretended that it has been beneficial to him, as his master has provided for his subsistence, slavery, at this rate, should be limited to those who are incapable of earning their livelihood. But who will take up with such slaves? As to infants, nature, who has supplied their mothers with milk, had provided for their sustenance, and the remainder of their childhood approaches so near the age in which they are most capable of being of service that he who supports them cannot be said to give them an equivalent which can entitle him to be their master. Nor is slavery less opposed to the civil law than to that of nature. What civil law can restrain a slave from running away, since he is not a member of society, and consequently has no interest in any civil institutions? He can be retained only by a family law, that is, by the master's authority. 3. Another origin of the right of slavery. I would as soon say that the right of slavery proceeds from the contempt of one nation for another, founded on a difference in customs. Lopez de Gama relates that the Spaniards found near St. Martha several baskets full of crabs, snails, grasshoppers, and locusts, which proved to be the ordinary provision of the natives. This the conquerors turned to a heavy charge against the conquered. The author owns that this, with their smoking and trimming their beards in a different manner, gave rise to the law by which the Americans became slaves to the Spaniards. Knowledge humanizes mankind, and reason inclines to mildness, but prejudices eradicate every tender disposition. 4. Another origin of the right of slavery. I would as soon say that religion gives its professors a right to enslave those who dissent from it, in order to render its propagation more easy. This was the notion that encouraged the ravagers of America in their iniquity. Under the influence of this idea they founded their right of enslaving so many nations, for these robbers, who would absolutely be both robbers and Christians, were superlatively devout. Louis XII was extremely uneasy at a law by which all the Negroes of his colonies were to be made slaves, but it being strongly urged to him as the readiest means for their conversion, he acquiesced without further scruple. 5. Of the slavery of the Negroes. Were I to vindicate our right to make slaves of the Negroes, these should be my arguments. The Europeans, having extirpated the Americans, were obliged to make slaves of the Africans, for clearing such vast tracts of land. Sugar would be too dear if the plants which produce it were cultivated by any other than slaves. These creatures are all over black, and with such a flat nose that they can scarcely be pitied. It is hardly to be believed that God, who is a wise being, should place a soul, especially a good soul, in such a black ugly body. It is so natural to look upon color as the criterion of human nature, that the Asiatics, among whom eunuchs are employed, always deprive the blacks of their resemblance to us by a more opprobrious distinction. The color of the skin may be determined by that of the hair, which, among the Egyptians, the best philosophers in the world, was of such importance that they put to death all the red-haired men who fell into their hands. The Negroes prefer a glass necklace to that gold which polite nations so highly value. Can there be a greater proof of their wanting common sense? It is impossible for us to suppose these creatures to be men, because, allowing them to be men, a suspicion would follow that we ourselves are not Christians. Weak minds exaggerate too much the wrong done to the Africans. For were the case as they state it, would the European powers, who make so many needless conventions among themselves, have failed to enter into a general one, in behalf of humanity and compassion? 6. The true origin of the right of slavery. It is time to inquire into the true origin of the right of slavery. It ought to be founded on the nature of things. Let us see if there be any cases where it can be derived thence. In all despotic governments people make no difficulty in selling themselves. The political slavery in some measure annihilates the civil liberty. According to Mr. Perry, the Muscovites sell themselves very readily. Their reason for it is evident: their liberty is not worth keeping. At Hm every one is for selling himself. Some oft chief lords have not less than 1,000 slaves, all principal merchants, who have a great number of slaves themselves, and these also are not without their slaves. Their masters are their heirs, and put them into trade. In those states, the freemen being overpowered by the government, have no better resource than that of making themselves slaves to the tyrants in office. This is the true and rational origin of that mild law of slavery which obtains in some countries, and mild it ought to be, as founded on the free choice a man makes of a master, for his own benefit, which forms a mutual convention between the two parties. 7. Another origin of the right of slavery. There is another origin of the right of slavery, and even of the most cruel slavery which is to be seen among men. There are countries where the excess of heat enervates the body, and renders men so slothful and dispirited that nothing but the fear of chastisement can oblige them to perform any laborious duty. Slavery is there more reconcilable to reason, and the master being as lazy with respect to his sovereign as his slave is with regard to him, this adds a political to a civil slavery. Aristotle endeavors to prove that there are natural slaves, but what he says is far from proving it. If there be any such, I believe they are those of whom I have been speaking. But as all men are born equal, slavery must be accounted unnatural, though in some countries it be founded on natural reason, and a wide difference ought to be made between such countries, and those in which even natural reason rejects it, as in Europe, where it has been so happily abolished. Plutarch, in the Life of Numa, says that in Saturn's time there was neither slave nor master. Christianity has restored that age in our climates. 8. Inutility of slavery among us. Natural slavery, then, is to be limited to some particular parts of the world. In all other countries, even the most servile drudgeries may be performed by freemen. Experience verifies my assertion. Before Christianity had abolished civil slavery in Europe, working in the mines was judged too toilsome for any but slaves or malefactors. At present there are men employed in them who are known to live comfortably. The magistrates have, by some small privileges, encouraged this profession to an increase of labor, they have joined an increase of gain, and have gone so far as to make those people better pleased with their condition than with any other which they could have embraced. No labor is so heavy but it may be brought to a level with the workman's strength, when regulated by equity, and not by avarice. The violent fatigues which slaves are made to undergo in other parts may be supplied by a skillful use of ingenious machines. The Turkish mines in the Banat of Thames Weir, though richer than those of Hungary, did not yield so much, because the working of them depended entirely on the strength of their slaves. I know not whether this article be dictated by my understanding or by my heart. Possibly there is not that climate upon earth where the most laborious services might not with proper encouragement be performed by freemen. Bad laws having made lazy men, they have been reduced to slavery because of their laziness. 9. Several kinds of slavery. Slavery is of two kinds, real and personal. The real annexes the slave to the land, which Tacitus makes the condition of slaves among the Germans. They were not employed in the family, a stated tribute of corn, cattle, or other movables, paid to their master, was the whole of their servitude. And such a servitude still continues in Hungary, Bohemia, and several parts of Lower Germany. Personal slavery consists in domestic services, and relates more to the master's person. The worst degree of slavery is when it is at once both real and personal, as that of the Helots among the Lacedaemonians. They underwent the fatigues of the field, and suffered all manner of insults at home. This Helotism is contrary to the nature of things. Real slavery is to be found only among nations remarkable for their simplicity of life, all family business being done by the wives and children. Personal slavery is peculiar to voluptuous nations, luxury requiring the service of slaves in the house. But Helotism joins in the same person the slavery established by voluptuous nations and that of the most simple. 10. Regulations necessary in respect to slavery. But of whatsoever kind the slavery be, the civil laws should endeavor on the one hand to abolish the abuses of it, and on the other to guard against its dangers. 11. Abuses of slavery. In Mahometan states, not only the life and goods of female slaves, but also what is called their virtue or honor, are at their master's disposal. One of the misfortunes of those countries is that the greatest part of the nation are born only to be subservient to the pleasures of the other. This servitude is alleviated by the laziness in which such slaves spend their days, which is an additional disadvantage to the state. It is this indolence which renders the eastern seraglios so delightful to those very persons whom they were made to confine. People who dread nothing but labor may imagine themselves happy in those places of indolence and ease. But this shows how contrary they are to the very intent of the institution of slavery. Reason requires that the master's power should not extend to what does not appertain to his service. Slavery should be calculated for utility, and not for pleasure. The laws of chastity arise from those of nature, and ought in all nations to be respected. If a law which preserves the chastity of slaves be good in those states where an arbitrary power bears down all before it, how much more will it be so in monarchies, and how much more still in republics? The law of the Lombards has a regulation which ought to be adopted by all governments. If a master debauches his slave's wife, the slave and his wife shall be restored to their freedom. An admirable expedient, which, without severity, lays a powerful restraint on the incontinence of masters. The Romans seem to have erred on this head. They allowed an unlimited scope to the master's lusts, and, in some measure, denied their slaves the privilege of marrying. It is true, they were the lowest part of the nation, yet there should have been some care taken of their morals, especially as in prohibiting their marriage they corrupted the morals of the citizens. 12. Danger from the multitude of slaves. The multitude of slaves has different effects in different governments. It is no grievance in a despotic state, where the political servitude of the whole body takes away the sense of civil slavery. Those who are called freedmen in reality are little more so than they who do not come within that class, and as the latter, in quality of eunuchs, freedmen, or slaves, have generally the management of all affairs, the condition of a freedman and that of a slave are very nearly allied. This makes it therefore almost a matter of indifference whether in such states the slaves be few or numerous. But in moderate governments it is a point of the highest importance that there should not be a great number of slaves. The political liberty of those states adds to the value of civil liberty, and he who is deprived of the latter is also bereft of the former. He sees the happiness of a society, of which he is not so much as a member, he sees the security of others fenced by laws, himself without any protection. He perceives that his master has a soul, capable of enlarging itself, while his own labors under a continual depression. Nothing more assimilates a man to a beast than living among freedmen, himself a slave. Such people as these are natural enemies of society, and their number must be dangerous. It is not therefore to be wondered at that moderate governments have been so frequently disturbed by the revolts of slaves, and that this so seldom happens in despotic states. 13. Of armed slaves. The danger of arming slaves is not so great in monarchies as in republics. In the former, a warlike people and a body of nobility are a sufficient check upon these armed slaves, whereas the pacific members of a republic would have a hard task to quell a set of men who, having offensive weapons in their hands, would find themselves a match for the citizens. The Goths, who conquered Spain, spread themselves over the country, and soon became very weak. They made 3 important regulations. They abolished an ancient custom which prohibited intermarriages with the Romans, they enacted that all the freedmen belonging to the fiscus should serve in war, under penalty of being reduced to slavery, and they ordained that each Goth should arm and bring into the field the 10th part of his slaves. This was but a small proportion. Besides, these slaves thus carried to the field did not form a separate body, they were in the army, and might be said to continue in the family. 14. The same subject continued. When a whole nation is of a martial temper, the slaves in arms are less to be feared. By a law of the Alemans, a slave who had committed a clandestine theft was liable to the same punishment as a freedman in the like case, but if he was found guilty of an open robbery, he was only bound to restore the things so taken. Among the Alemans, courage and intrepidity extenuated the guilt of an action. They employed their slaves in their wars. Most republics have been attentive to dispirit their slaves, but the Alemans, relying on themselves and being always armed, were so far from fearing theirs that they were rather for augmenting their courage. They were the instruments either of their depredations or of their glory. 15. Precautions to be used in moderate governments. Lenity and humane treatment may prevent the dangers to be apprehended from the multitude of slaves in a moderate government. Men grow reconciled to everything, and even to servitude, if not aggravated by the severity of the master. The Athenians treated their slaves with great lenity, and this secured that state from the commotions raised by the slaves among the austere Lacedaemonians. It does not appear that the primitive Romans met with any trouble from their slaves. Those civil broils which have been compared to the Punic Wars were the consequence of their having divested themselves of all humanity towards their slaves. A frugal and laborious people generally treat their slaves more kindly than those who are above labor. The primitive Romans used to live, work, and eat with their slaves. In short, they behaved towards them with justice and humanity. The greatest punishment they made them suffer was to make them pass before their neighbors with a forked piece of wood on their backs. Their manners were sufficient to secure the fidelity of their slaves, so that there was no necessity for laws. But when the Romans aggrandized themselves, when their slaves were no longer the companions of their labor, but the instruments of their luxury and pride, as they then wanted morals they had need of laws. It was even necessary for these laws to be of the most terrible kind, in order to establish the safety of those cruel masters who lived with their slaves as in the midst of enemies. They made the Silenian Senatus Consultum, and other laws, which decreed that when a master was murdered all the slaves under the same roof, or in any place so near the house as to be within the hearing of a man's voice, should, without distinction, be condemned to die. Those who in this case sheltered a slave, in order to save him, were punished as murderers. He whom his master ordered to kill him, and who obeyed, was reputed guilty. Even he who did not hinder him from killing himself was liable to be punished. If a master was murdered on a journey, they put to death those who were with him and those who fled. All these laws operated even against persons whose innocence was proved. The intent of them was to inspire their slaves with a prodigious respect for their master. They were not dependent on the civil government, but on a fault or imperfection of the civil government. They were not derived from the equity of civil laws, since they were contrary to the principle of those laws. They were properly founded on the principles of war, with this difference, that the enemies were in the bosom of the state. The Silenian Senatus Consultum was derived from the law of nations, which requires that a society, however imperfect, should be preserved. It is a misfortune in government when the magistrates thus find themselves under the necessity of making cruel laws. Because they have rendered obedience difficult, they are obliged to increase the penalty of disobedience, or to suspect the slave's fidelity. A prudent legislator foresees the ill consequences of rendering the legislature terrible. The slaves amongst the Romans could have no confidence in the laws, and therefore the laws could have none in them. 16. Regulations between masters and slaves. The magistrates ought to take care that the slave has his food and raiment, and this should be regulated by law. The laws ought to provide that care be taken of them in sickness and old age. Claudius decreed that slaves who in sickness had been abandoned by their masters should, in case they recovered, be emancipated. This law ensured their liberty, but should not there have been some care also taken to preserve their lives? When the law permitted a master to take away the life of his slave, he was invested with a power which he ought to exercise as judge, and not as master. It was necessary, therefore, that the law should ordain those formalities which remove the suspicion of an act of violence. When fathers, at Rome, were no longer permitted to put their children to death, the magistrates ordained the punishment which the father would have inflicted. A like custom between the master and his slaves would be highly reasonable in a country where masters have the power of life and death. The law of Moses was extremely severe. If a man struck his servant so that he died under his hand, he was to be punished, but, if he survived a day or two, no punishment ensued, because he was his money. Strange that a civil institution should thus relax the law of nature. By a law of the Greeks, a slave too severely treated by his master might insist upon being sold to another. In later times there was a law of the same nature at Rome. A master displeased with his slave, and a slave with his master, ought to be separated. When a citizen uses the slave of another ill, the latter ought to have the liberty of complaining before the judge. The laws of Plato, and of most nations, took away from slaves the right of natural defense. It was necessary then that they should give them a civil defense. At Sparta slaves could have no justice against either insults or injuries. So excessive was their misery, that they were not only the slaves of a citizen, but also of the public. They belonged to all, as well as to one. At Rome, when they considered the injury done to a slave, they had regard only to the interest of the master. In the breach of the Aquileian law they confounded a wound given to a beast and that given to a slave. They regarded only the diminution of their value. At Athens, he who had abused the slave of another was punished severely, and sometimes even with death. The law of Athens was very reasonable in not adding the loss of security to that of liberty. 17. Of enfranchisements. It is easy to perceive that many slaves in a republican government create a necessity of making many free. The evil is, if they have too great a number of slaves they cannot keep them in due bounds. If they have too many freedmen, they cannot live, and must become a burden to the republic. Besides, it may be as much in danger from the multitude of freedmen as from that of slaves. It is necessary, therefore, that the law should have an eye to these two inconveniences. The several laws and decrees of the Senate made at Rome, both for and against slaves, sometimes to limit, and at other times to facilitate, their enfranchisement, plainly show the embarrassment in which they found themselves in this respect. There were even times in which they durst not make laws. When, under Nero, they demanded of the Senate permission for the masters to reduce again to slavery the ungrateful freedmen, the emperor declared that it was their duty to decide the affairs of individuals, and to make no general decree. Much less can I determine what ought to be the regulations of a good republic in such an affair. This depends on too many circumstances. Let us, however, make some reflections. A considerable number of freedmen ought not suddenly to be made by a general law. We know that among the Volsinienses the freedmen, becoming masters oft suffrages, enacted an abominable law, which gave them the right of lying the first night with the young women married to the freeborn. There are several ways of insensibly introducing new citizens into a republic. The laws may favor the acquiring a peculium, and put slaves into a condition of buying their liberty. They may prescribe a term to servitude, like those of Moses, which limited that of the Hebrew slaves to 6 years. It is easy to enfranchise every year a certain number of those slaves who, by their age, health, or industry, are capable of getting a subsistence. The evil may be even cured in its root, as a great number of slaves are connected with the several employments which are given them. To divide among the freeborn a part of these employments, for example, commerce or navigation, is diminishing the number of slaves. When there are many freedmen, it is necessary that the civil laws should determine what they owe to their patron, or that these duties should be fixed by the contract of enfranchisement. It is certain that their condition should be more favored in the civil than in the political state, because, even in a popular government, the power ought not to fall into the hands of the vulgar. At Rome, where they had so many freedmen, the political laws with regard to them were admirable. They gave them very little, and excluded them almost from nothing. They had even a share in the legislature, but the resolutions they were capable of taking were almost of no weight. They might bear a part in the public offices, and even in the dignity of the priesthood, but this privilege was in some sort rendered useless by the disadvantages they had to encounter in the elections. They had a right to enter into the army, but they were to be registered in a certain class of the census before they could be soldiers. Nothing hindered the freedmen from being united by marriage with the families oft freeborn, but they were not permitted to mix with those of the senator. In short, their children were freeborn, though they were not so themselves. 18. Of freedmen and eunuchs. Thus in a republican government it is frequently of advantage that the situation of the freedmen be but little below that of the freeborn, and that the laws be calculated to remove a dislike of their condition. But in a despotic government, where luxury and arbitrary power prevail, they have nothing to do in this respect, the freedmen generally finding themselves above the freeborn. They rule in the court of the prince, and in the palaces of the great, and as they study the foibles and not the virtues of their master, they lead him entirely by the former, not by the latter. Such were the freedmen of Rome in the times of the emperors. When the principal slaves are eunuchs, let never so many privileges be granted them, they can hardly be regarded as freedmen. For as they are incapable of having a family of their own, they are naturally attached to that of another, and it is only by a kind of fiction that they are considered as citizens. And yet there are countries where the magistracy is entirely in their hands. In Tonquin, says Dampier, all the mandarins, civil and military, are eunuchs. They have no families, and though they are naturally avaricious, the master or the prince benefits in the end by this very passion. Dampier tells us, too, that in this country the eunuchs cannot live without women, and therefore marry. The law which permits their marriage may be founded partly on their respect for these eunuchs, and partly on their contempt of the fair sex. Thus they are trusted with the magistracy, because they have no family, and permitted to marry, because they are magistrates. Then it is that the sense which remains would fain supply that which they have lost, and the enterprises of despair become a kind of enjoyment. So, in Milton, that spirit who has nothing left but desires, enraged at his degradation, would make use of his impotency itself. We see in the history of China a great number of laws to deprive eunuchs of all civil and military employments, but they always return to them again. It seems as if the eunuchs of the East were a necessary evil. Book 16. How the laws of domestic slavery bear a relation to the nature of the climate. 1. Of domestic servitude. Slaves are established for the family, but they are not a part of it. Thus I distinguish their servitude from that which the women in some countries suffer, and which I shall properly call domestic servitude. 2. That in the countries of the South there is a natural inequality between the two sexes. Women, in hot climates, are marriageable at 8, 9, or 10 years of age. Thus, in those countries, infancy and marriage generally go together. They are old at 20, their reason therefore never accompanies their beauty. When beauty demands the empire, the want of reason forbids the claim. When reason is obtained, beauty is no more. These women ought then to be in a state of dependence, for reason cannot procure in old age that empire which even youth and beauty could not give. It is therefore extremely natural that in these places a man, when no law opposes it, should leave one wife to take another, and that polygamy should be introduced. In temperate climates, where the charms of women are best preserved, where they arrive later at maturity, and have children at a more advanced season of life, the old age of their husbands in some degree follows theirs, and as they have more reason and knowledge at the time of marriage, if it be only on account of their having continued longer in life, it must naturally introduce a kind of equality between the two sexes, and, in consequence of this, the law of having only one wife. In cold countries the almost necessary custom of drinking strong liquors establishes intemperance amongst men. Women, who in this respect have a natural restraint, because they are always on the defensive, have therefore the advantage of reason over them. Nature, which has distinguished men by their reason and bodily strength, has set no other bounds to their power than those of this strength and reason. It has given charms to women, and ordained that their ascendancy over man shall end with these charms, but in hot countries, these are found only at the beginning, and never in the progress of life. Thus the law which permits only one wife is physically conformable to the climate of Europe, and not to that of Asia. This is the reason why Mahometanism was so easily established in Asia, and with such difficulty extended in Europe, why Christianity is maintained in Europe, and has been destroyed in Asia, and, in fine, why the Mahometans have made such progress in China, and the Christians so little. Human reasons, however, are subordinate to that supreme cause who does whatever he pleases, and renders everything subservient to his will. Some particular reasons induced Valentinian to permit polygamy in the empire. That law, so improper for our climates, was abrogated by Theodosius, Arcadius, and Honorius. 3. That a plurality of wives greatly depends on the means of supporting them. Though in countries where polygamy is once established the number of wives is principally determined by the opulence of the husband, yet it cannot be said that opulence established polygamy in those states, since poverty may produce the same effect, as I shall prove when I come to speak of the savages. Polygamy, in powerful nations, is less a luxury in itself than the occasion of great luxury. In hot climates they have few wants, and it costs little to maintain a wife and children, they may therefore have a great number of wives. 4. That the law of polygamy is an affair that depends on calculation. According to the calculations made in several parts of Europe, there are here born more boys than girls. On the contrary, by the accounts we have of Asia there are there born more girls than boys. The law which in Europe allows only one wife, and that in Asia which permits many, have therefore a certain relation to the climate. In the cold climates of Asia there are born, as in Europe, more males than females, and hence, say the Lamas, is derived the reason of that law which amongst them permits a woman to have many husbands. But it is difficult for me to believe that there are many countries where the disproportion can be great enough for any exigency to justify the introducing either the law in favor of many wives or that of many husbands. This would only imply that a majority of women, or even a majority of men, is more conformable to nature in certain countries than in others. I confess that if what history tells us be true, that at Bantam there are 10 women to 1 man, this must be a case particularly favorable to polygamy. In all this I only give their reasons, but do not justify their customs. 5. The reason of a law of Malabar. In the tribe of the Nares, on the coast of Malabar, the men can have only one wife, while a woman, on the contrary, may have many husbands. The origin of this custom is not, I believe, difficult to discover. The Nares are the tribe of nobles, who are the soldiers of all those nations. In Europe soldiers are forbidden to marry. In Malabar, where the climate requires greater indulgence, they are satisfied with rendering marriage as little burdensome to them as possible. They give one wife amongst many men, which consequently diminishes the attachment to a family, and the cares of housekeeping, and leaves them in the free possession of a military spirit. 6. Of polygamy considered in itself. With regard to polygamy in general, independently of the circumstances which may render it tolerable, it is not of the least service to mankind, nor to either of two sexes, whether it be that which abuses or that which is abused. Neither is it of service to the children, for one of its greatest inconveniences is, that the father and mother cannot have the same affection for their offspring. A father cannot love 20 children with the same tenderness as a mother can love 2. It is much worse when a wife has many husbands, for then paternal love only is held by this opinion, that a father may believe, if he will, or that others may believe, that certain children belong to him. They say that the Emperor of Morocco has women of all colors, white, black, and tawny, in his seraglio. But the wretch has scarcely need of a single color. Besides, the possession of so many wives does not always prevent their entertaining desires for those of others. It is with lust as with avarice, whose thirst increases by the acquisition of treasure. In the reign of Justinian, many philosophers, displeased with the constraint of Christianity, retired into Persia. What struck them the most, says Agathias, was that polygamy was permitted amongst men who did not even abstain from adultery. May I not say that a plurality of wives leads to that passion which nature disallows? For one deprivation always draws on another. I remember that in the revolution which happened at Constantinople, when Sultan Achmet was deposed, history says that the people, having plundered the Khaja's house, found not a single woman. They tell us that at Algiers, in the greatest part of their seraglios, they have none at all. 7. Of an equality of treatment in case of many wives. From the law which permitted a plurality of wives followed that of an equal behavior to each. Mahomet, who allowed of 4, would have everything, as provisions, dress, and conjugal duty, equally divided between them. This law is also in force in the Maldivian Isles, where they are at liberty to marry 3 wives. The law of Moses even declares that if anyone has married his son to a slave, and this son should afterwards espouse a free woman, her food, her raiment, and her duty of marriage shall he not diminish. They might give more to the new wife, but the first was not to have less than she had before. 8. Of the separation of women from men. The prodigious number of wives possessed by those who live in rich and voluptuous countries is a consequence of the law of polygamy. Their separation from men, and their close confinement, naturally follow from the greatness of this number. Domestic order renders this necessary, thus an insolvent debtor seeks to conceal himself from the pursuit of his creditors. There are climates where the impulses of nature have such force that morality has almost none. If a man be left with a woman, the temptation and the fall will be the same thing, the attack certain, the resistance none. In these countries, instead of precepts, they have recourse to bolts and bars. One of the Chinese classic authors considers the man as a prodigy of virtue who, finding a woman alone in a distant apartment, can forbear making use of force. 9. Of the connection between domestic and political government. In a republic the condition of citizens is moderate, equal, mild, and agreeable. Everything partakes of the benefit of public liberty. An empire over the women cannot, among them, be so well exerted, and where the climate demands this empire, it is most agreeable to a monarchical government. This is one of the reasons why it has ever been difficult to establish a popular government in the East. On the contrary, the slavery of women is perfectly conformable to the genius of a despotic government, which delights in treating all with severity. Thus at all times have we seen in Asia domestic slavery and despotic government walk hand in hand with an equal pace. In a government which requires, above all things, that a particular regard be paid to its tranquility, and where the extreme subordination calls for peace, it is absolutely necessary to shut up the women, for their intrigues would prove fatal to their husbands. A government which has not time to examine into the conduct of its subjects views them with a suspicious eye, only because they appear and suffer themselves to be known. Let us only suppose that the levity of mind, the indiscretions, the tastes and caprices of our women, attended by their passions of a higher and a lower kind, with all their active fire, and in that full liberty with which they appear amongst us, were conveyed into an Eastern government, where would be the father of a family who could enjoy a moment's repose. The men would be everywhere suspected, everywhere enemies, the state would be overturned, and the kingdom overflowed with rivers of blood. 10. The principle on which the morals of the East are founded. In the case of a multiplicity of wives, the more a family ceases to be united, the more ought the laws to reunite its detached parts in a common center, and the greater the diversity of interests, the more necessary is it for the laws to bring them back to a common interest. This is more particularly done by confinement. The women should not only be separated from the men by the walls of the house, but they ought also to be separated in the same enclosure, in such a manner that each may have a distinct household in the same family. Hence each derives all that relates to the practice of morality, modesty, chastity, reserve, silence, peace, dependence, respect, and love, and, in short, a general direction of her thoughts to that which, in its own nature, is a thing of the greatest importance, a single and entire attachment to her family. Women have naturally so many duties to fulfill, duties which are peculiarly theirs, that they cannot be sufficiently excluded from everything capable of inspiring other ideas, from everything that goes by the name of amusements, and from everything which we call business. We find the manners more pure in the several parts of the East, in proportion as the confinement of women is more strictly observed. In great kingdoms there are necessarily great lords. The greater their wealth, the more enlarged is their ability of keeping their wives in an exact confinement, and of preventing them from entering again into society. Hence it proceeds that in the empires of Turkey, Persia, of the Mughal, China, and Japan, the manners of their wives are admirable. But the case is not the same in India, where a multitude of islands and the situation of the land have divided the country into an infinite number of petty states, which from causes that we have not here room to mention are rendered despotic. There are none there but wretches, some pillaging and others pillaged. Their grandees have very moderate fortunes, and those whom they call rich have only a bare subsistence. The confinement of their women cannot therefore be very strict, nor can they make use of any great precautions to keep them within due bounds, hence it proceeds that the corruption of their manners is scarcely to be conceived. We may there see to what an extreme the vices of a climate indulged in full liberty will carry licentiousness. It is there that nature has a force and modesty a weakness, which exceeds all comprehension. At patten the wanton desires of the women are so outrageous, that the men are obliged to make use of a certain apparel to shelter them from their designs. According to Mr. Smith, things are not better conducted in the petty kingdoms of Guinea. In these countries the two sexes lose even those laws which properly belong to each. 11. Of domestic slavery independently of polygamy. It is not only a plurality of wives which in certain places of the East requires their confinement, but also the climate itself. Those who consider the horrible crimes, the treachery, the dark villainies, the poisonings, the assassinations, which the liberty of women has occasioned at Goa and in the Portuguese settlements in the Indies, where religion permits only one wife, and who compare them with the innocence and purity of manners of the women of Turkey, Persia, Hindostan, China, and Japan, will clearly see that it is frequently as necessary to separate them from the men, when they have but one, as when they have many. These are things which ought to be decided by the climate. What purpose would it answer to shut up women in our northern countries, where their manners are naturally good, where all their passions are calm, and where love rules over the heart with so regular and gentle an empire that the least degree of prudence is sufficient to conduct it? It is a happiness to live in those climates which permit such freedom of converse, where that sex which has most charm seems to embellish society, and where wives, reserving themselves for the pleasures of one, contribute to the amusement of all. 12. Of natural modesty. All nations are equally agreed in fixing contempt and ignominy on the incontinence of women. Nature has dictated this to all. She has established the attack, and she has established too the resistance, and having implanted desires in both, she has given to the one boldness, and to the other shame. To individuals she has granted a long succession of years to attend to their preservation, but to continue the species, she has granted only a moment. It is then far from being true that to be incontinent is to follow the laws of nature. On the contrary, it is a violation of these laws, which can be observed only by behaving with modesty and discretion. Besides, it is natural for intelligent beings to feel their imperfections. Nature has, therefore, fixed shame in our minds, a shame of our imperfections. When, therefore, the physical power of certain climates violates the natural law of the two sexes, and that of intelligent beings, it belongs to the legislature to make civil laws, with a view to opposing the nature of the climate and re-establishing the primitive laws. 13. Of jealousy. With respect to nations, we ought to distinguish between the passion of jealousy and a jealousy arising from customs, manners, and laws. The one is a hot raging fever, the other, cold, but sometimes terrible, may be joined with indifference and contempt. The one, an abuse of love, derives its source from love itself. The other depends only on manners, on the customs of a nation, on the laws of the country, and sometimes even on religion. It is generally the effect of the physical power of the climate, and, at the same time, the remedy of this physical power. 14. Of the Eastern manner of domestic government. Wives are changed so often in the East that they cannot have the power of domestic government. This care is, therefore, committed to the eunuchs, whom they entrust with their keys and the management of their families. In Persia, says Sir John Chardin, married women are furnished with clothes as they want them, after the manner of children. Thus that care which seems so well to become them, that care which everywhere else is the first of their concern, does not at all regard them. 15. Of divorce and repudiation. There is this difference between a divorce and a repudiation, that the former is made by mutual consent, arising from a mutual antipathy, while the latter is formed by the will, and for the advantage of one of the two parties, independently of the will and advantage of the other. The necessity there is sometimes for women to repudiate, and the difficulty there always is in doing it, render that law very tyrannical which gives this right to men without granting it to women. A husband is the master of the house, he has 1,000 ways of confining his wife to her duty, or of bringing her back to it, so that in his hands it seems as if repudiation could be only a fresh abuse of power. But a wife who repudiates only makes use of a dreadful kind of remedy. It is always a great misfortune for her to go in search of a second husband, when she has lost the most part of her attractions with another. One of the advantages attending the charms of youth in the female sex is that in an advanced age the husband is led to complacency and love by the remembrance of past pleasures. It is then a general rule that in all countries where the laws have given to men the power of repudiating, they ought also to grant it to women. Nay, in climates where women live in domestic slavery, one would think that the law ought to favor women with the right of repudiation, and husbands only with that of divorce. When wives are confined in a seraglio, the husband ought not to repudiate on account of an opposition of manners, it is the husband's fault if their manners are incompatible. Repudiation on account of the barrenness of the woman ought never to take place except where there is only one wife. When there are many, this is of no importance to the husband. A law of the Maldivians permitted them to take again a wife whom they had repudiated. A law of Mexico forbade their being reunited under pain of death. The law of Mexico was more rational than that of the Maldivians. At the time even of dissolution, it attended to the perpetuity of marriage. Instead of these, the law of the Maldivians seemed equally to sport with marriage and repudiation. The law of Mexico admitted only of divorce. This was a particular reason for their not permitting those who were voluntarily separated to be ever reunited. Repudiation seems chiefly to proceed from a hastiness of temper, and from the dictates of passion, while divorce appears to be an affair of deliberation. Divorces are frequently of great political use, but as to the civil utility, they are established only for the advantage of the husband and wife, and are not always favorable to their children. 16. Of repudiation and divorce amongst the Romans. Romulus permitted a husband to repudiate his wife, if she had committed adultery, prepared poison, or procured false keys. He did not grant to women the right of repudiating their husbands. Plutarch calls this a law extremely severe. As the Athenian law gave the power of repudiation to the wife as well as to the husband, and as this right was obtained by the women among the primitive Romans, notwithstanding the law of Romulus, it is evident that this institution was one of those which the deputies of Rome brought from Athens, and which were inserted in the laws of the 12 tables. Cicero says that the reasons of repudiation sprang from the law of the 12 tables. We cannot then doubt but that this law increased the number of the reasons for repudiation established by Romulus. The power of divorce was also an appointment, or at least a consequence, of the law of the 12 tables. For from the moment that the wife or the husband had separately the right of repudiation, there was a much stronger reason for their having the power of quitting each other by mutual consent. The law did not require that they should lay open the causes of divorce. In the nature of the thing, the reasons for repudiation should be given, while those for a divorce are unnecessary, because, whatever causes the law may admit as sufficient to break a marriage, a mutual antipathy must be stronger than them all. The following fact, mentioned by Dionysius Halicarnassus, Valerius Maximus, and Aulus Gellius, does not appear to me to have the least degree of probability, though they had at Rome, say they, the power of repudiating a wife, yet they had so much respect for the auspices that nobody for the space of 520 years ever made use of this right, till Carvilius Ruga repudiated his, because of her sterility. We need only be sensible of the nature of the human mind to perceive how very extraordinary it must be for a law to grant such right to a whole nation, and yet for nobody to make use of it. Coriolanus, setting out on his exile, advised his wife to marry a man more happy than himself. We have just been seeing that the law of the 12 tables and the manners of the Romans greatly extended the law of Romulus. But to what purpose were these extensions if they never made use of a power to repudiate? Besides, if the citizens had such a respect for the auspices that they would never repudiate, how came the legislators of Rome to have less than they? And how came the laws incessantly to corrupt their manners? All that is surprising in the fact in question will soon disappear, only by comparing two passages in Plutarch. The regal law permitted a husband to repudiate in the 3 cases already mentioned, and it enjoined, says Plutarch, that he who repudiated in any other case should be obliged to give the half of his substance to his wife, and that the other half should be consecrated to Ceres. They might then repudiate in all cases, if they were but willing to submit to the penalty. Nobody had done this before Carvilius Ruga, who, as Plutarch says in another place, put away his wife for her sterility 230 years after Romulus. That is, she was repudiated 71 years before the law of the 12 tables, which extended both the power and causes of repudiation. The authors I have cited say that Carvilius Ruga loved his wife, but that the censors made him take an oath to put her away, because of her barrenness, to the end that he might give children to the Republic, and that this rendered him odious to the people. We must know the genius and temper of the Romans before we can discover the true cause of the hatred they had conceived against Carvilius. He did not fall into disgrace with the people for repudiating his wife, this was an affair that did not at all concern them. But Carvilius had taken an oath to the censors, that by reason of the sterility of his wife he would repudiate her to give children to the Republic. This was a yoke which the people saw the censors were going to put upon them. I shall discover, in the prosecution of this work, the repugnance which they always felt to regulations of the like kind. But whence can such a contradiction between those authors arise? It is because Plutarch examined into a fact, and the others have recounted a prodigy. Book 17. How the laws of political servitude bear a relation to the nature of the climate. 1. Of political servitude. Political servitude does not less depend on the nature of the climate than that which is civil and domestic, and this we shall now demonstrate. 2. The difference between nations in point of courage. We have already observed that great heat enervates the strength and courage of men, and that in cold climates they have a certain vigor of body and mind, which renders them patient and intrepid, and qualifies them for arduous enterprises. This remark holds good, not only between different nations, but even in the different parts of the same country. In the north of China people are more courageous than those in the south, and those in the south of Korea have less bravery than those in the north. We ought not, then, to be astonished that the effeminacy of the people in hot climates has almost always rendered them slaves, and that the bravery of those in cold climates has enabled them to maintain their liberties. This is an effect which springs from a natural cause. This has also been found true in America. The despotic empires of Mexico and Peru were near the line, and almost all the little free nations were, and are still, near the poles. 3. Of the climate of Asia. The relations of travelers inform us that the vast continent of the north of Asia, which extends from 40 degrees or thereabouts to the pole, and from the frontiers of Muscovy even to the Eastern Ocean, is in an extremely cold climate, that this immense tract of land is divided by a chain of mountains which run from west to east, leaving Siberia on the north, and Great Tartary on the south, that the climate of Siberia is so cold that, excepting a few places, it is unsusceptible of cultivation, and that though the Russians have settlements all along the Irtis, they cultivate nothing, that this country produces only some little furs and shrubs, that the natives of the country are divided into wretched hordes or tribes, like those of Canada, that the reason of this cold proceeds, on the one hand, from the height of the land, and on the other from the mountains, which, in proportion as they run from south to north, are levelled in such a manner that the north wind everywhere blows without opposition. That this wind, which renders Nova Zembia uninhabitable, blowing in Siberia makes it a barren waste, that in Europe, on the contrary, the mountains of Norway and Lapland are admirable bulwarks, which cover the northern countries from the wind, so that at Stockholm, which is about 59 degrees latitude, the earth produces plants, fruits, and corn, and that about Abio, which is 61 degrees, and even to 63 and 64, there are mines of silver, and the land is fruitful enough. We see also in these relations that Great Tartary, situated to the south of Siberia, is also exceedingly cold, that the country will not admit of cultivation, that nothing can be found but pasturage for flocks and herds, that trees will not grow there, but only brambles, as in Iceland, that there are, near China and India, some countries where there grows a kind of millet, but that neither corn nor rice will ripen, that there is scarcely a place in Chinese Tartary at 43, 44, and 45 degrees where it does not freeze 7 or 8 months in the year, so that it is as cold as Iceland, though it might be imagined, from its situation, to be as hot as the south of France, that there are no cities, except 4 or 5 towards the Eastern Ocean, and some which the Chinese, for political reasons, have built near China, that in the rest of Great Tartary there are only a few situated in Bucher, Turkestan, and Cathay, that the reason of this extreme cold proceeds from the nature of the nitrous earth, full of saltpetre and sand, and more particularly from the height of the land. Father Verbiest found that a certain place, 80 leagues north of the Great Wall, towards the source of Kavam Huron, exceeded the height of the sea near Peking 3,000 geometrical paces, that this height is the cause that though almost all the great rivers of Asia have their source in this country, there is, however, so great a want of water that it can be inhabited only near the rivers and lakes. These facts being laid down, I reason thus: Asia has properly no temperate zone, as the places situated in a very cold climate immediately touch upon those which are exceedingly hot, that is, Turkey, Persia, India, China, Korea, and Japan. In Europe, on the contrary, the temperate zone is very extensive, though situated in climates widely different from each other, there being no affinity between the climates of Spain and Italy and those of Norway and Sweden. But as the climate grows insensibly cold upon our advancing from south to north, nearly in proportion to the latitude of each country, it thence follows that each resembles the country joining it, that there is no very extraordinary difference between them, and that, as I have just said, the temperate zone is very extensive. Hence it comes that in Asia, the strong nations are opposed to the weak, the warlike, brave, and active people touch immediately upon those who are indolent, effeminate, and timorous, the one must, therefore, conquer, and the other be conquered. In Europe, on the contrary, strong nations are opposed to the strong, and those who join each other have nearly the same courage. This is the grand reason of the weakness of Asia, and of the strength of Europe, of the liberty of Europe, and of the slavery of Asia, a cause that I do not recollect ever to have seen remarked. Hence it proceeds that liberty in Asia never increases, whilst in Europe it is enlarged or diminished, according to particular circumstances. The Russian nobility have indeed been reduced to slavery by the ambition of one of their princes, but they have always discovered those marks of impatience and discontent which are never to be seen in the southern climates. Have they not been able for a short time to establish an aristocratic government? Another of the northern kingdoms has lost its laws, but we may trust to the climate that they are not lost in such a manner as never to be recovered. 4. The consequences resulting from this. What we have now said is perfectly conformable to history. Asia has been subdued 13 times, 11 by the northern nations, and twice by those of the south. In the early ages it was conquered 3 times by the Scythians. Afterwards it was subdued once by the Medes, and once by the Persians, again by the Greeks, the Arabs, the Mughals, the Turks, the Tartars, the Persians, and the Afghans. I mention only the Upper Asia, and say nothing of the invasions made in the rest of the south of that part of the world which has most frequently suffered prodigious revolutions. In Europe, on the contrary, since the establishment of the Greek and Phoenician colonies, we know but of 4 great changes, the first caused by the conquest of the Romans, the second by the inundation of barbarians, who destroyed those very Romans, the third by the victories of Charlemagne, and the last by the invasions of the Normans. And if this be rightly examined, we shall find, even in these changes, a general strength diffused through all the parts of Europe. We know the difficulty which the Romans met with in conquering Europe, and the ease and facility with which they invaded Asia. We are sensible of the difficulties the northern nations had to encounter in overturning the Roman Empire, of the wars and labors of Charlemagne, and of the several enterprises of the Normans. The destroyers were incessantly destroyed. 5. That when the people in the north of Asia and those of the north of Europe made conquests, the effects of the conquest were not the same. The nations in the north of Europe conquered as freemen, the people in the north of Asia conquered as slaves, and subdued as others only to gratify the ambition of a master. The reason is that the people of Tartary, the natural conquerors of Asia, are themselves enslaved. They are incessantly making conquests in the south of Asia, where they form empires, but that part of the nation which continues in the country finds that it is subject to a great master, who, being despotic in the south, will likewise be so in the north, and exercising an arbitrary power over the vanquished subjects, pretends to the same over the conquerors. This is at present most conspicuous in that vast country called Chinese Tartary, which is governed by the emperor, with a power almost as despotic as that of China itself, and which he every day extends by his conquests. We may likewise see in the history of China that the emperors sent Chinese colonies into Tartary. These Chinese have become Tartars, and the mortal enemies of China, but this does not prevent their carrying into Tartary the spirit of the Chinese government. A part of the Tartars who were conquerors have very often been themselves expelled, when they have carried into their deserts that servile spirit which they had acquired in the climate of slavery. The history of China furnishes us with strong proofs of this assertion, as does also our ancient history. Hence it follows that the genius of the Getic or Tartarian nation has always resembled that of the empires of Asia. The people in these are governed by the cudgel, the inhabitants of Tartary by whips. The spirit of Europe has ever been contrary to these manners, and in all ages, what the people of Asia have called punishment those of Europe have deemed the most outrageous abuse. The Tartars who destroyed the Grecian Empire established in the conquered countries slavery and despotic power. The Goths, after subduing the Roman Empire, founded monarchy and liberty. I do not know whether the famous Rudbeck, who in his Atlantica has bestowed such praises on Scandinavia, has made mention of that great prerogative which ought to set this people above all the nations upon earth, namely, this country's having been the source of the liberties of Europe, that is, of almost all the freedom which at present subsists amongst mankind. Jornandes the Goth called the north of Europe the forge of the human race. I should rather call it the forge where those weapons were framed which broke the chains of southern nations. In the north were formed those valiant people who sallied forth and deserted their countries to destroy tyrants and slaves, and to teach men that, nature having made them equal, reason could not render them dependent, except where it was necessary to their happiness. 6. A new physical cause of the slavery of Asia, and of the liberty of Europe. In Asia they have always had great empires, in Europe these could never subsist. Asia has larger plains, it is cut out into much more extensive divisions by mountains and seas, and as it lies more to the south, its springs are more easily dried up, the mountains are less covered with snow, and the rivers, being not so large, form more contracted barriers. Power in Asia ought, then, to be always despotic, for if their slavery was not severe they would soon make a division inconsistent with the nature of the country. In Europe the natural division forms many nations of a moderate extent, in which the ruling by laws is not incompatible with the maintenance of the state. On the contrary, it is so favorable to it, that without this the state would fall into decay, and become a prey to its neighbors. It is this which has formed a genius for liberty that renders every part extremely difficult to be subdued and subjected to a foreign power, otherwise than by the laws and the advantage of commerce. On the contrary, there reigns in Asia a servile spirit, which they have never been able to shake off, and it is impossible to find in all the histories of that country a single passage which discovers a freedom of spirit. We shall never see anything there but the excess of slavery. 7. Of Africa and America. This is what I had to say of Asia and Europe. Africa is in a climate like that of the south of Asia, and is in the same servitude. America, being lately destroyed and repeopled by the nations of Europe and Africa, can now scarcely display its genuine spirit, but what we know of its ancient history is very conformable to our principles. 8. Of the capital of the empire. One of the consequences of what we have been mentioning is, that it is of the utmost importance to a great prince to make a proper choice of the seat of his empire. He who places it to the southward will be in danger of losing the north, but he who fixes it on the north may easily preserve the south. I do not speak of particular cases. In mechanics there are frictions by which the effects of the theory are frequently changed or retarded, and policy has also its frictions. Book 18. Of laws in the relation they bear to the nature of the soil. 1. How the nature of the soil has an influence on the laws. The goodness of the land, in any country, naturally establishes subjection and dependence. The husbandmen, who compose the principal part of the people, are not very jealous of their liberty, they are too busy and too intent on their own private affairs. A country which overflows with wealth is afraid of pillage, afraid of an army. Who is there that forms this goodly party, said Cicero to Atticus, are they the men of commerce and husbandry? Let us not imagine that these are averse to monarchy, these to whom all governments are equal, as soon as they bestow tranquility. Thus monarchy is more frequently found in fruitful countries, and a republican government in those which are not so, and this is sometimes a sufficient compensation for the inconveniences they suffer by the sterility of the land. The barrenness of the Attic soil established there a democracy, and the fertility of that of Lacedaemonia an aristocratic constitution. For in those times Greece was averse to the government of a single person, and aristocracy bore the nearest resemblance to that government. Plutarch says that the Cylonian sedition having been appeased at Athens, the city fell into its ancient dissensions, and was divided into as many parties as there were kinds of land in Attica. The men who inhabited the eminences would, by all means, have a popular government. Those of the flat, open country demanded a government composed of the chiefs, and they who were near the sea desired a mixture of both. 2. The same subject continued. These fertile provinces are always of a level surface, where the inhabitants are unable to dispute against a stronger power, they are then obliged to submit, and when they have once submitted, the spirit of liberty cannot return, the wealth of the country is a pledge of their fidelity. But in mountainous districts, as they have but little, they may preserve what they have. The liberty they enjoy, or, in other words the government they are under, is the only blessing worthy of their defense. It reigns, therefore, more in mountainous and rugged countries than in those which nature seems to have most favored. The mountaineers preserve a more moderate government, because they are not so liable to be conquered. They defend themselves easily, and are attacked with difficulty. Ammunition and provisions are collected and carried against them with great expense, for the country furnishes none. It is, then, a more arduous, a more dangerous, enterprise to make war against them, and all the laws that can be enacted for the safety of the people are there of least use. 3. What countries are best cultivated? Countries are not cultivated in proportion to their fertility, but owe their liberty, and if we make an imaginary division of the earth, we shall be astonished to see in most ages deserts in the most fruitful parts, and great nations in those where nature seems to refuse everything. It is natural for a people to leave a bad soil to seek a better, and not to leave a good soil to go in search of worse. Most invasions have, therefore, been made in countries which nature seems to have formed for happiness, and as nothing is more nearly allied than desolation and invasion, the best provinces are most frequently depopulated, while the frightful countries of the north continue always inhabited, from their being almost uninhabitable. We find by what historians tell us of the passage of the people of Scandinavia along the banks of the Danube that this was not a conquest, but only a migration into desert countries. These happy climates must therefore have been depopulated by other migrations, though we know not the tragic scenes that happened. It appears by many monuments of antiquity, says Aristotle, that the Sardinians were a Grecian colony. They were formerly very rich, and Aristeus, so famed for his love of agriculture, was their lawgiver. But they have since fallen to decay, for the Carthaginians, becoming their masters, destroyed everything proper toward the nourishment of man, and forbade the cultivation of the lands on pain of death. Sardinia was not recovered in the time of Aristotle, nor is it to this day. The most temperate parts of Persia, Turkey, Muscovy, and Poland have not been able to recover perfectly from the devastations of the Tartars. 4. New effects of the fertility and barrenness of countries. The barrenness of the earth renders men industrious, sober, inured to hardship, courageous, and fit for war. They are obliged to procure by labor what the earth refuses to bestow spontaneously. The fertility of a country gives ease, effeminacy, and a certain fondness for the preservation of life. It has been remarked that German troops raised in those places where the peasants are rich, as, for instance, in Saxony, are not so good as the others. Military laws may provide against this inconvenience by a more severe discipline. 5. Of the inhabitants of islands. The inhabitants of islands have a higher relish for liberty than those of the continent. Islands are commonly of small extent, one part of the people cannot be so easily employed to oppress the other, the sea separates them from great empires, tyranny cannot so well support itself within a small compass, conquerors are stopped by the sea, and the Icelanders, being without the reach of their arms, more easily preserve their own laws. 6. Of countries raised by the industry of man. Those countries which the industry of man has rendered habitable, and which stand in need of the same industry to provide for their subsistence, require a mild and moderate government. There are principally 3 of this species, the 2 fine provinces of Qiangnan and Zhejiang in China, Egypt, and Holland. The ancient emperors of China were not conquerors. The first thing they did to aggrandize themselves was what gave the highest proof of their wisdom. They raised from beneath the waters 2 of the finest provinces of the empire. These owe their existence to the labor of man. And it is the inexpressible fertility of these 2 provinces which has given Europe such ideas of the felicity of that vast country. But a continual and necessary care to preserve from destruction so considerable a part of the empire demanded rather the manners of a wise than of a voluptuous nation, rather the lawful authority of a monarch than the tyrannic sway of a despotic prince. Power was, therefore, necessarily moderated in that country, as it was formerly in Egypt, and as it is now in Holland, which nature has made to attend to herself, and not to be abandoned to negligence or caprice. Thus, in spite of the climate of China, where they are naturally led to a servile obedience, in spite of the apprehensions which follow too great an extent of empire, the first legislators of this country were obliged to make excellent laws, and the government was frequently obliged to follow them. 7. Of human industry. Mankind by their industry, and by the influence of good laws, have rendered the earth more proper for their abode. We see rivers flow where there have been lakes and marshes. This is a benefit which nature has not bestowed, but it is a benefit maintained and supplied by nature. When the Persians were masters of Asia, they permitted those who conveyed a spring to any place which had not been watered before to enjoy the benefit for 5 generations, and as a number of rivulets flowed from Mount Taurus, they spared no expense in directing the course of their streams. At this day, without knowing how they came thither, they are found in the fields and gardens. Thus, as destructive nations produce evils more durable than themselves, the actions of an industrious people are the source of blessings which last when they are no more. 8. The general relation of laws. The laws have a very great relation to the manner in which the several nations procure their subsistence. There should be a code of laws of a much larger extent for a nation attached to trade and navigation than for people who are content with cultivating the earth. There should be a much greater for the latter than for those who subsist by their flocks and herds. There must be a still greater for these than for such as live by hunting. 9. Of the soil of America. The cause of there being such a number of savage nations in America is the fertility of the earth, which spontaneously produces many fruits capable of affording them nourishment. If the women cultivate a spot of land around their cottages, the maize grows up presently, and hunting and fishing put the men in a state of complete abundance. Besides, black cattle, as cows, buffaloes, and thrive there better than carnivorous beasts. The latter have always reigned in Africa. We should not, I believe, have all these advantages in Europe if the land was left uncultivated. It would scarcely produce anything besides forests of oaks and other barren trees. 10. Of population in the relation it bears to the manner of procuring subsistence. Let us see in what proportion countries are peopled where the inhabitants do not cultivate the earth. As the produce of uncultivated land is to that of land improved by culture, so the number of savages in one country is to that of husbandmen in another, and when the people who cultivate the land cultivate also the arts, this is also in such proportions as would require a minute detail. They can scarcely form a great nation. If they are herdsmen and shepherds, they have need of an extensive country to furnish subsistence for a small number. If they live by hunting, their number must be still less, and in order to find the means of life they must constitute a very small nation. Their country commonly abounds with forests, which, as the inhabitants have not the art of draining off the waters, are filled with bogs. Here each troop canton themselves, and form a petty nation. 11. Of savage and barbarous nations. There is this difference between savage and barbarous nations: the former are dispersed clans, which for some particular reason cannot be joined in a body, and the latter are commonly small nations, capable of being united. The savages are generally hunters, the barbarians are herdsmen and shepherds. This appears plain in the north of Asia. The people of Siberia cannot live in bodies, because they are unable to find subsistence. The Tartars may live in bodies for some time, because their herds and flocks may for a time be reassembled. All the clans may then be reunited, and this is effected when one chief has subdued many others, after which they may do two things: either separate, or set out with a design to make a great conquest in some southern empire. 12. Of the law of nations among people who do not cultivate the earth. As these people do not live in circumscribed territories, many causes of strife arise between them. They quarrel about waste land as we about inheritances. Thus they find frequent occasions for war, in disputes in relation either to their hunting, their fishing, the pasture for their cattle, or the violent seizing of their slaves, and as they are not possessed of landed property, they have many things to regulate by the law of nations, and but few to decide by the civil law. 13. Of the civil laws of those nations who do not cultivate the earth. The division of lands is what principally increases the civil code. Among nations where they have not made this division there are very few civil laws. The institutions of these people may be called manners rather than laws. Among such nations as these the old men, who remember things past, have great authority. They cannot there be distinguished by wealth, but by wisdom and valor. These people wander and disperse themselves in pasture grounds or in forests. Marriage cannot there have the security which it has among us, where it is fixed by the habitation, and where the wife continues in one house. They may then more easily change their wives, possess many, and sometimes mix indifferently like brutes. Nations of herdsmen and shepherds cannot leave their cattle, which are their subsistence, neither can they separate themselves from their wives, who look after them. All this ought, then, to go together, especially as living generally in a flat open country, where there are few places of considerable strength, their wives, their children, their flocks, may become the prey of their enemies. The laws regulate the division of plunder, and give, like our Salic laws, a particular attention to theft. 14. Of the political state of the people who do not cultivate the land. These people enjoy great liberty, for as they do not cultivate the earth, they are not fixed, they are wanderers and vagabonds, and if a chief should deprive them of their liberty, they would immediately go and seek it under another, or retire into the woods, and there live with their families. The liberty of the man is so great among these people that it necessarily draws after it that of the citizen. 15. Of people who know the use of money. Aristippus, being cast away, swam and got safely to the next shore, where, beholding geometrical figures traced in the sand, he was seized with a transport of joy, judging that he was among Greeks, and not in a nation of barbarians. Should you ever happen to be cast by some adventure among an unknown people, upon seeing a piece of money you may be assured that you have arrived in a civilized country. The culture of lands requires the use of money. This culture supposes many inventions and many degrees of knowledge, and we always see ingenuity, the arts, and a sense of want making their progress with an equal pace. All this conduces to the establishment of a sign of value. Torrents and eruptions have made the discovery that metals are contained in the bowels of the earth. When once they have been separated, they have easily been applied to their proper use. 16. Of civil laws among people who know not the use of money. When a people have not the use of money, they are seldom acquainted with any other injustice than that which arises from violence, and the weak, by uniting, defend themselves from its effects. They have nothing there but political regulations. But where money is established, they are subject to that injustice which proceeds from craft and injustice that may be exercised in 1,000 ways. Hence they are forced to have good civil laws, which spring up with the new practices of iniquity. In countries where they have no specie, the robber takes only bare movables, which have no mutual resemblance. But where they make use of money, the robber takes the signs, and these always resemble each other. In the former nothing can be concealed, because the robber takes along with him the proofs of his conviction, but in the latter it is quite the contrary. 17. Of political laws among nations who have not the use of money. The greatest security of the liberties of a people who do not cultivate the earth is their not knowing the use of money. What is gained by hunting, fishing, or keeping herds of cattle cannot be assembled in such great quantity, nor be sufficiently preserved, for one man to find himself in a condition to corrupt many others, but when, instead of this, a man has a sign of riches, he may obtain a large quantity of these signs, and distribute them as he pleases. The people who have no money have but few wants, and these are supplied with ease, and in an equal manner. Equality is then unavoidable, and hence it proceeds that their chiefs are not despotic. If what travelers tell us be true, the constitution of a nation of Louisiana, called the Natchez, is an exception to this. Their chief disposes of the goods of all his subjects, and obliges them to work and toil, according to his pleasure. He has a power like that of the Grand Seignior, and they cannot even refuse him their heads. When the presumptive heir enters the world, they devote all the sucking children to his service during his life. One would imagine that this is the great Sesostris. He is treated in his cottage with as much ceremony as an emperor of Japan or China. 18. Of the power of superstition. The prejudices of superstition are superior to all others, and have the strongest influence on the human mind. Thus, though the savage nations have naturally no knowledge of despotic tyranny, still they feel the weight of it. They adore the sun, and if their chief had not imagined that he was the brother of this glorious luminary, they would have thought him a wretch like themselves. 19. Of the liberty of the Arabs and the servitude of the Tartars. The Arabs and Tartars are nations of herdsmen and shepherds. The Arabs find themselves in that situation of which we have been speaking, and are therefore free, whilst the Tartars, the most singular people on earth, are involved in a political slavery. I have already given reasons for this and shall now assign some others. They have no towns, no forests, and but few marshes, their rivers are generally frozen, and they dwell in a level country of an immense extent. They have pasture for their herds and flocks, and consequently property, but they have no kind of retreat, or place of safety. A Khan is no sooner overcome than they cut off his head, his children are treated in the same manner, and all his subjects belong to the conqueror. These are not condemned to a civil slavery, for in that case they would be a burden to a simple people, who have no lands to cultivate, and no need of any domestic service. They therefore add to the bulk of the nation, but instead of civil servitude, a political slavery must naturally be introduced among them. It is apparent that in a country where the several clans make continual war, and are perpetually conquering each other, in a country where, by the death of the chief, the body politic of the vanquished clan is always destroyed, the nation in general can enjoy but little freedom, for there is not a single party that must not have been often subdued. A conquered people may preserve some degree of liberty when, by the strength of their situation, they are in a state that will admit of capitulating after their defeat. But the Tartars, always defenseless, being once overcome, can never be able to obtain conditions. I have said, in Chapter 2, that the inhabitants of cultivated plains are seldom free. Circumstances have occurred to Puthi Tartars, who dwell in uncultivated plains, in the same situation. 20. Of the law of nations as practiced by the Tartars. The Tartars appear to be mild and humane among themselves, and yet they are most cruel conquerors. When they take cities they put the inhabitants to the sword, and imagine that they act humanely if they only sell the people, or distribute them among their soldiers. They have destroyed Asia, from India even to the Mediterranean, and all the country which forms the east of Persia they have rendered a desert. The law of nations is owing, I think, to the following cause. These people having no towns, all their wars are carried on with eagerness and impetuosity. They fight whenever they hope to conquer, and when they have no such hope, they join the stronger army. With such customs, it is contrary to the law of nations that a city incapable of repelling their attack should stop their progress. They regard not cities as an association of inhabitants, but as places made to bid defiance to their power. They besiege them without military skill, and expose themselves greatly in the attack, and therefore revenge themselves on all those who have spilled their blood. 21. The civil law of the Tartars. Father Du Halde says that amongst the Tartars the youngest of the males is always the heir, by reason that as soon as the elder brothers are capable of leading a pastoral life they leave the house with a certain number of cattle, given them by their father, and build a new habitation. The last of the males, who continues at home with the father, is then his natural heir. I have heard that a like custom was also observed in some small districts of England, and we find it still in Brittany, in the Duchy of Rohan, where it obtains with regard to ignoble tenures. This is doubtless a pastoral law conveyed thither by some of the people of Britain, or established by some German nation. By Caesar and Tacitus we are informed that the latter cultivated but little land. 22. Of a civil law of the German nations. I shall here explain how that particular passage of the Salic law which is commonly distinguished by the term the Salic law relates to the institutions of a people who do not cultivate the earth, or at least who cultivate it but very little. The Salic law ordains that, when a man has left children behind him, the males shall succeed to the Salic land in preference to the females. To understand the nature of those Salic lands, there needs no more than to search into the usages or customs of Franks with regard to lands before they left Germany. Mr. Eckhard has very plainly proved that the word Salic is derived from Sala, which signifies a house, and therefore that the Salic land was the land belonging to the house. I shall proceed further, and examine into the nature of the house, and of the land belonging to the house, among the Germans. They dwell not in towns, says Tacitus, nor can they bear to have their habitations contiguous to those of others. Every one leaves a space or small piece of ground about his house, which is enclosed. Tacitus is very exact in this account, for many laws of the barbarian codes have different decrees against those who threw down this enclosure, as well as against such as broke into the house. We learn from Tacitus and Caesar that the lands cultivated by the Germans were given them only for the space of a year, after which they again became public. They had no other patrimony but the house and a piece of land within the enclosure that surrounded it. It was this particular patrimony which belonged to the males. And, indeed, how could it belong to the daughters? They were to pass into another habitation. The Salic land was then within that enclosure which belonged to a German house. This was the only property they had. The Franks, after their conquests, acquired new possessions, and continued to call them Salic lands. When the Franks lived in Germany, their wealth consisted of slaves, flocks, horses, arms, and sea. The habitation and the small portion of land adjoining it were naturally given to the male children who were to dwell there. But afterwards, when the Franks had by conquest acquired large tracts of land, they thought it hard that the daughters and their children should be incapable of enjoying any part of them. Hence it was that they introduced a custom of permitting the father to settle the estate after his death upon his daughter, and her children. They silenced the law, and it appears that these settlements were frequent, since they were entered in the formularies. Among these formularies I find one of a singular nature. A grandfather ordained by will that his grandchildren should share his inheritance with his sons and daughters. What then became of the Salic law? In those times either it would not be observed, or the continual use of nominating the daughters to an inheritance had made them consider their ability to succeed as a case authorized by custom. The Salic law had not in view a preference of one sex to the other, much less had it a regard to the perpetuity of a family, a name, or the transmission of land. These things did not enter into the heads of the Germans. It was purely an economical law, which made the house and the land dependent thereon to the males who should dwell in it, and to whom it consequently was of most service. We need here only transcribe the title of the allodial lands of the Salic law, that famous text of which so many have talked, and which so few have read. 1. If a man dies without issue, his father or mother shall succeed him. 2. If he has neither father nor mother, his brother or sister shall succeed him. 3. If he has neither brother nor sister, the sister of his mother shall succeed him. 4. If his mother has no sister, the sister of his father shall succeed him. 5. If his father has no sister, the nearest relative by the male side shall succeed. 6. Not any part of the Salic land shall pass to the females, but it shall belong to the males, that is, the male children shall succeed their father. It is plain that the first 5 articles relate to the inheritance of a man who dies without issue, and the 6th to the succession of him who has children. When a man dies without children, the law ordains that neither of the two sexes shall have the preference to the other, except in certain cases. In the first 2 degrees of succession, the advantages of the males and females were the same. In the 3rd and 4th, the females had the preference, and the males in the 5th. Tacitus points out the source of these extravagances. The sisters' children, says he, are as dear to their uncle as to their own father. There are men who regard this degree of kindred as more strict, and even more holy. They prefer it when they receive hostages. Hence it proceeds that our earliest historians speak in such strong terms of the love of the kings of the Franks for their sisters and their sisters' children. And, indeed, if the children of the sister were considered in her brother's house as his own children, it was natural for these to regard their aunt as their mother. The sister of the mother was preferred to the father's sister. This is explained by other texts of the Salic law. When a woman became a widow, she fell under the guardianship of her husband's relatives. The law preferred to this guardianship the relatives by the females before those by the males. Indeed, a woman who entered into a family joining herself with those of her own sex, became more united to her relatives by the female than by the male. Moreover, when a man killed another, and had not wherewithal to pay the pecuniary penalty, the law permitted him to deliver up his substance, and his relatives were to supply the deficiency. After the father, mother, and brother, the sister of the mother was to pay, as if this tie had something in it most tender. Now the degree of kindred which imposes the burdens ought also to confer the advantages. The Salic law enjoins that after the father's sister, the succession should be held by the nearest relative male, but if this relative was beyond the 5th degree, he should not inherit. Thus a female of the 5th degree might inherit to the prejudice of a male of the 6th, and this may be seen in the law of the Ripuarian Franks, a faithful interpreter of the Salic law, under the title of Allodial lands, where it closely adheres to the Salic law on the same subject. If the father left issue, the Salic law would have the daughters excluded from the inheritance of the Salic land, and determined that it should belong to the male children. It would be easy for me to prove that the Salic law did not absolutely exclude the daughters from the possession of the Salic land, but only in the case where they were debarred by their brothers. This appears from the letter of the Salic law, which, after having said that the women shall possess none of the Salic land, but only the males, interprets and restrains itself by adding, that is, the son shall succeed to the inheritance of the father. 2. The text of the Salic law is cleared up by the law of the Ripuarian Franks, which has also a title on allodial lands very conformable to that of the Salic law. 3. The laws of these barbarous nations who all sprang from Germany interpret each other, more particularly as they all have nearly the same spirit. The Saxon law enjoined the father and mother to leave their inheritance to their son, and not to their daughter, but if there were none but daughters, they were to have the whole inheritance. 4. We have 2 ancient formularies that state the case in which, according to the Salic law, the daughters were excluded by the males, that is, when they stood in competition with their brother. 5. Another formulary proves that the daughter succeeded to the prejudice of the grandson, she was therefore excluded only by the son. 6. If daughters had been generally debarred by the Salic law from the inheritance of land, it would be impossible to explain the histories, formularies, and charters which are continually mentioning the lands and possessions of the females under the first race. People have been wrong in asserting that the Salic lands were fiefs. 1. This head is distinguished by the title of allodial lands. 2. Fiefs at first were not hereditary. 3. If the Salic lands had been fiefs, how could Marculfus treat that custom as impious which excluded the women from inheriting, when the males themselves did not succeed to fiefs? 4. The charters which have been cited to prove that the Salic lands were fiefs only show that they were freeholds. 5. Fiefs were not established till after the conquest, and the Salic customs existed long before the Franks left Germany. 6. It was not the Salic law that formed the establishment of fiefs, by setting bounds to the succession of females, but it was the establishment of fiefs that prescribed limits to the succession of females, and to the regulations of the Salic law. After what has been said, one would not imagine that the perpetual succession of males to the crown of France should have taken its rise from the Salic law. And yet this is a point indubitably certain. I prove it from the several codes of the barbarous nations. The Salic law, and the law of the Burgundians, debarred the daughters from the right of succeeding to the land in conjunction with their brothers, neither did they succeed to the crown. The law of the Visigoths, on the contrary, permitted the daughters to inherit the land with the brothers, and the women were capable of inheriting the crown. Among these people the regulations of the civil law had an effect on the political. This was not the only case in which the political law of the Franks gave way to the civil. By the Salic law, all the brothers succeeded equally to the land, and this was also decreed by a law of the Burgundians. Thus, in the kingdom of the Franks, and in that oft Burgundians, all brothers succeeded to the crown, if we except a few murders and usurpations which took place amongst the Burgundians. 23. Of the regal ornaments among the Franks. A people who do not cultivate the land have no idea of luxury. We may see, in Tacitus, the admirable simplicity of the German nations. They had no artificial elegances of dress, their ornaments were derived from nature. If the family of their chief was to be distinguished by any sign, it was no other than that which nature bestowed. The kings of the Franks, of the Burgundians, and the Visigoths wore their long hair for a diadem. 24. Of the marriages of the kings of the Franks. I have already mentioned that with people who do not cultivate the earth, marriages are less fixed than with others, and that they generally take many wives. Of all the barbarous nations, the Germans were almost the only people who were satisfied with one wife, if we except, says Tacitus, some persons who, not from a dissoluteness of manners, but because of their nobility, had many. This explains the reason why the kings of the first race had so great a number of wives. These marriages were less a proof of incontinence than a consequence of dignity, and it would have wounded them in a tender point to have deprived them of such a prerogative. This also explains the reason why the example of the kings was not followed by the subjects. 25. Childeric. The laws of matrimony amongst the Germans, says Tacitus, are strictly observed. Vice is not there a subject of ridicule. To corrupt or be corrupted is not called fashion, or the custom of the age. There are few examples in this populous nation of the violation of conjugal faith. This was the reason of the expulsion of Childeric. He shocked their rigid virtue, which conquest had not had time to corrupt. 26. Of the time when the kings of the Franks became of age. Barbarians who do not cultivate the earth have, strictly speaking, no jurisdiction, and are, as we have already remembered, rather governed by the law of nations than by civil institutions. They are, therefore, always armed. Thus Tacitus tells us that the Germans undertook no affairs either of a public or private nature unarmed. They gave their vote by the sound of their arms. As soon as they could carry them, they were presented to the assembly, they put a javelin into their hands, and from that moment they were out of their minority. They had been a part of the family, now they became a part of the republic. The eagles, said the king of the Ostrogoths, cease to feed their young ones as soon as their wings and talons are formed. The latter have no need of assistance when they are able themselves to seize their prey. It would be a disgrace if the young people in our armies were thought to be of an age unfit for managing their estates or regulating the conduct of their lives. It is virtue that constitutes full age among the Goths. Childebert too was 15 years old when Gontram, his uncle, declared that he was of age, and capable of governing by himself. We find in the Ripuarian laws that the age of 15, the ability of bearing arms, and majority, went together. It is there said that if a Ripuarian dies, or is killed, and leaves a son behind him, that son can neither prosecute, nor be prosecuted, till he has completely attained the age of 15, and then he may either answer for himself or choose a champion. It was necessary that his mind should be sufficiently formed to be able to defend himself in court, and that his body should have all the strength that was proper for his defense in single combat. Among the Burgundians, who also made use of this combat in their judiciary proceedings, they were of age at 15. Agathias tells us that the arms of the Franks were light, they might, therefore, be of age at 15. In succeeding times the arms they made use of were heavy, and they were already greatly so in the time of Charlemagne, as appears by our capitularies and romances. Those who had fiefs, and were consequently obliged to do military service, were not then of age till they were 21 years old. 27. The same subject continued. We have seen that the Germans did not appear in their assemblies before they were of age. They were a part of the family, but not of the republic. This was the reason that the children of Clodomir, king of Orleans, and conqueror of Burgundy, were not proclaimed kings, because they were of too tender an age to be present at the assembly. They were not yet kings, but they had a right to the regal dignity as soon as they were able to bear arms, and in the meantime, Clotildis, their grandmother, governed the state. But their uncles Clotarius and Childebert assassinated them, and divided their kingdom. This was the cause that in the following ages princes in their minority were proclaimed kings immediately after the death of their fathers. Thus Duke Gondevault saved Childebert II from the cruelty of Chilperic, and caused him to be proclaimed king when he was only 5 years old. But even in this change they followed the original spirit of the nation, for the public acts did not pass in the name of the young monarch. So that the Franks had a double administration, the one which concerned the person of the infant king, and the other which regarded the kingdom, and in the fiefs there was a difference between the guardianship and the civil administration. 28. Of adoption among the Germans. As the Germans became of age by the wielding of arms, so they were adopted by the same sign. Thus Gontram, willing to declare his nephew Childebert of age and to adopt him for his son, made use of these words, "I have put this javelin into thy hands as a token that I have given thee all my kingdom." Then turning towards the assembly, he added, "You see that my son Childebert is grown a man, obey him." Theodoric, king of the Ostrogoths, intending to adopt the king of the Heruli, wrote to him thus, "It is a noble custom of ours to be adopted by arms, for men of courage alone deserve to be our children. Such is the efficacy of this act, that whoever is the object of it had rather die than submit to anything ignominious. Therefore, in compliance with the national usage, and because you are a man of courage, we adopt you for our son by these bucklers, these swords, these horses, which we send you as a present." 29. Of the sanguinary temper of the kings of the Franks. Clovis was not the only prince amongst the Franks who had invaded Gaul. Many of his relatives had penetrated into this country with particular tribes, but as he had met with much greater success, and could grant considerable settlements to such as followed him, the Franks flocked to him from all parts, so that the other chiefs found themselves too weak to resist him. He formed a design of exterminating his whole race, and he succeeded. He feared, says Gregory of Tours, lest the Franks should choose another chief. His children and successors followed this practice to the utmost of their power. Thus the brother, the uncle, the nephew, and, what is still worse, the father or the son, were perpetually conspiring against their whole family. The law continually divided the monarchy, while fear, ambition, and cruelty wanted to reunite it. 30. Of the national assemblies of the Franks. It has been remarked above that nations who do not cultivate the land enjoy great liberty. This was the case of the Germans. Tacitus says that they gave their kings, or chiefs, a very moderate degree of power, and Caesar adds further that in times of peace they had no common magistrates, but their princes administered justice in each village. Thus, as Gregory of Tours sufficiently proves, the Franks in Germany had no king. The princes, says Tacitus, deliberate on matters of no great concern, while affairs of importance are submitted to the whole nation, but in such a manner that these very affairs which are under the cognizance of the people are at the same time laid before the princes. This custom was observed by them after their conquests, as may be seen in all their records. Tacitus says that capital crimes might be carried before the assembly. It was the same after the conquest, when the great vassals were tried before that body. 31. Of the authority of the clergy under the first race. The priests of barbarous nations are commonly invested with power, because they have both that authority which is due to them from their religious character, and that influence which among such a people is the offspring of superstition. Thus we see in Tacitus that priests were held in great veneration by the Germans, and that they presided in the assemblies of the people. They alone were permitted to chastise, to bind, to smite, which they did, not by order of the prince, or as his ministers of justice, but as by an inspiration of that deity ever supposed to be present with those who made war. We ought not therefore to be astonished when, from the very beginning oft first race, we meet with bishops the dispensers of justice, when we see them appear in the assemblies of the nation, when they have such a prodigious influence on the minds of sovereigns, and when they acquire so large a share of property. Book 19. Of laws in relation to the principles which from the general spirit, morals, and customs of a nation. 1. Of the subject of this book. This subject is very extensive. In that crowd of ideas which presents itself to my mind, I shall be more attentive to the order of things than to the things themselves. I shall be obliged to wander to the right and to the left, that I may investigate and discover the truth. 2. That it is necessary people's minds should be prepared for the reception of the best laws. Nothing could appear more insupportable to the Germans than the tribunal of Varus. That which Justinian erected amongst the lazy, to proceed against the murderers of their king, appeared to them as an affair most horrid and barbarous. Mithridates, haranguing against the Romans, reproached them more particularly for their law proceedings. The Parthians could not bear with one of their kings who, having been educated at Rome, rendered himself affable and easy of access to all. Liberty itself has appeared intolerable to those nations who have not been accustomed to enjoy it. Thus pure air is sometimes disagreeable to such as have lived in a fenny country. Baby, a Venetian, being at Pegu, was introduced to the king. When the monarch was informed that they had no king at Venice, he burst into such a fit of laughter that he was seized with a cough, and with difficulty could speak to his courtiers. What legislator could propose a popular government to a people like this? 3. Of tyranny. There are two sorts of tyranny, one real, which arises from oppression, the other is seated in opinion, and is sure to be felt whenever those who govern establish things shocking to the existing ideas of a nation. Dio tells us that Augustus was desirous of being called Romulus, but having been informed that the people feared that he would cause himself to be crowned king, he changed his design. The old Romans were averse to a king, because they could not suffer any man to enjoy such power. These would not have a king, because they could not bear his manners. For though Caesar, the triumvirs, and Augustus were really invested with regal power, they had preserved all the outward appearance of equality, while their private lives were a kind of contrast to the pomp and luxury of foreign monarchs, so that when the Romans were resolved to have no king, this only signified that they would preserve their customs, and not imitate those of the African and Eastern nations. The same writer informs us that the Romans were exasperated against Augustus for making certain laws which were too severe, but as soon as he had recalled Pilotes the comedian, whom the jarring of different factions had driven out of the city, the discontent ceased. A people of this stamp have a more lively sense of tyranny when a player is banished than when they are deprived of their laws. 4. Of the general spirit of mankind. Mankind are influenced by various causes, by the climate, by the religion, by the laws, by the maxims of government, by precedents, morals, and customs, whence is formed a general spirit of nations. In proportion as, in every country, any one of these causes acts with more force, the others in the same degree are weakened. Nature and the climate rule almost alone over the savages, customs govern the Chinese, the laws tyrannize in Japan, morals had formerly all their influence at Sparta, maxims of government, and the ancient simplicity of manners, once prevailed at Rome. 5. How far we should be attentive lest the general spirit of a nation be changed. Should there happen to be a country whose inhabitants were of a social temper, open-hearted, cheerful, endowed with taste and a facility in communicating their thoughts, who were sprightly and agreeable, sometimes imprudent, often indiscreet, and besides had courage, generosity, frankness, and a certain notion of honor, no one ought to endeavor to restrain their manners by laws, unless he would lay a constraint on their virtues. If in general the character be good, the little foibles that may be found in it are of small importance. They might lay a restraint upon women, enact laws to reform their manners and to reduce their luxury, but who knows but that by these means they might lose that peculiar taste which would be the source of the wealth of the nation, and that politeness which would render the country frequented by strangers? It is the business of the legislature to follow the spirit of the nation, when it is not contrary to the principles of government, for we do nothing so well as when we act with freedom, and follow the bent of our natural genius. If an air of pedantry be given to a nation that is naturally gay, the state will gain no advantage from it, either at home or abroad. Leave it to do frivolous things in the most serious manner, and with gaiety the things most serious. 6. That everything ought not to be corrected. Let them but leave us as we are, said a gentleman of a nation which had a very great resemblance to that we have been describing, and nature will repair whatever is amiss. She has given us a vivacity capable of offending, and hurrying us beyond the bounds of respect. This same vivacity is corrected by the politeness it procures, inspiring us with a taste of the world, and, above all, for the conversation of the fair sex. Let them leave us as we are. Our indiscretions joined to our good nature would make the laws which should constrain our sociability not at all proper for us. 7. Of the Athenians and Lacedaemonians. The Athenians, this gentleman adds, were a nation that had some relation to ours. They mingled gaiety with business, a stroke of raillery was as agreeable in the Senate as in the theatre. This vivacity, which discovered itself in their councils, went along with them in the execution of their resolves. The characteristic of the Spartans was gravity, seriousness, severity, and silence. It would have been as difficult to bring over an Athenian by teasing as it would a Spartan by diverting him. 8. Effects of a sociable temper. The more communicative a people are, the more easily they change their habits, because each is in a greater degree a spectacle to the other and the singularities of individuals are better observed. The climate which influences one nation to take pleasure in being communicative, makes it also delight in change, and that which makes it delight in change forms its taste. The society of the fair sex spoils the manners and forms the taste. The desire of giving greater pleasure than others establishes the embellishments of dress, and the desire of pleasing others more than ourselves gives rise to fashions. Thus fashion is a subject of importance. By encouraging a trifling turn of mind, it continually increases the branches of its commerce. 9. Of the vanity and pride of nations. Vanity is as advantageous to a government as pride is dangerous. To be convinced of this we need only represent, on the one hand, the numberless benefits which result from vanity, as industry, the arts, fashions, politeness, and taste, on the other, the infinite evils which spring from the pride of certain nations, as laziness, poverty, a total neglect of everything, in fine, the destruction of the nations which have happened to fall under their government, as well as of their own. Laziness is the effect of pride, labor, a consequence of vanity. The pride of a Spaniard leads him to decline labor, the vanity of a Frenchman to work better than others. All lazy nations are grave, for those who do not labor regard themselves as the sovereigns of those who do. If we search among all nations, we shall find that for the most part gravity, pride, and indolence go hand in hand. The people of Hm are proud and lazy. Those who have no slaves, hire one, if it be only to carry a quart of rice 100 paces, they would be dishonored if they carried it themselves. In many places people let their nails grow, that all may see they do not work. Women in the Indies believe it shameful for them to learn to read. This is, they say, the business of their slaves, who sing their spiritual songs in the temples of their pagods. In one tribe they do not spin, in another they make nothing but baskets and mats, they are not even to pound rice, and in others they must not go to fetch water. These rules are established by pride, and the same passion makes them followed. There is no necessity for mentioning that the moral qualities, according as they are blended with others, are productive of different effects. Thus pride, joined to a vast ambition and notions of grandeur, produced such effects among the Romans as are known to all the world. 10. Of the character of the Spaniards and Chinese. The characters of the several nations are formed of virtues and vices, of good and bad qualities. From the happy mixture of these, great advantages result, and frequently where it would be least expected, there are others whence great evils arise, evils which one would not suspect. The Spaniards have been in all ages famous for their honesty. Justin mentions their fidelity in keeping whatever was entrusted to their care. They have frequently suffered death rather than reveal a secret. They have still the same fidelity for which they were formerly distinguished. All the nations who trade at Cadiz trust their fortunes to the Spaniards, and have never yet repented it. But this admirable quality, joined to their indolence, forms a mixture whence such effects result as to them are most pernicious. The rest of the European nations carry on in their very sight all the commerce of their monarchy. The character of the Chinese is formed of another mixture, directly opposite to that of Spaniards. The precariousness of their subsistence inspires them with a prodigious activity, and such an excessive desire of gain, that no trading nation can confide in them. This acknowledged infidelity has secured them the possession of the trade to Japan. No European merchant has ever dared to undertake it in their name, how easy soever it might be for them to do it from their maritime provinces in the north. 11. A reflection. I have said nothing here with a view to lessen that infinite distance which must ever be between virtue and vice. God forbid that I should be guilty of such an attempt. I would only make my readers comprehend that all political are not all moral vices, and that all moral are not political vices, and that those who make laws which shock the general spirit of a nation ought not to be ignorant of this. 12. Of customs and manners in a despotic state. It is a capital maxim that the manners and customs of a despotic empire ought never to be changed, for nothing would more speedily produce a revolution. The reason is that in these states there are no laws, that is, none. That can be properly called so, there are only manners and customs, and if you overturn these you overturn all. Laws are established, manners are inspired, these proceed from a general spirit, those from a particular institution. Now it is as dangerous, nay more so, to subvert the general spirit as to change a particular institution. There is less communication in a country where each, either as superior or inferior, exercises or is oppressed by arbitrary power, than there is in those where liberty reigns in every station. They do not, therefore, so often change their manners and behavior. Fixed and established customs have a near resemblance to laws. Thus it is here necessary that a prince or a legislator should less oppose the manners and customs of the people than in any other country upon earth. Their women are commonly confined, and have no influence in society. In other countries, where they have intercourse with men, their desire of pleasing, and the desire men also have of giving them pleasure, produce a continual change of customs. The two sexes spoil each other, they both lose their distinctive and essential quality. What was naturally fixed becomes quite unsettled, and their customs and behavior alter every day. 13. Of the behavior of the Chinese. But China is the place where the customs of the country can never be changed. Besides their women being absolutely separated from the men, their customs, like their morals, are taught in the schools. A man of letters may be known by his easy address. These things being once taught by precept, and inculcated by grave doctors, become fixed, like the principles of morality, and are never changed. 14. What are the natural means of changing the manners and customs of a nation? We have said that the laws were the particular and precise institutions of a legislator, and manners and customs the institutions of a nation in general. Hence it follows that when these manners and customs are to be changed, it ought not to be done by laws. This would have too much the air of tyranny. It would be better to change them by introducing other manners and other customs. Thus when a prince would make great alterations in his kingdom, he should reform by law what is established by law, and change by custom what is settled by custom, for it is very bad policy to change by law what ought to be changed by custom. The law which obliged the Muscovites to cut off their beards and to shorten their clothes, and the rigor with which Peter I made them crop, even to their knees, the long cloaks of those who entered into the cities, were instances of tyranny. There are means that may be made use of to prevent crimes, these are punishments. There are those for changing our customs, these are examples. The facility and ease with which that nation has been polished plainly shows that this prince had a worse opinion of his people than they deserved, and that they were not brutes, though he was pleased to call them so. The violent measures which he employed were needless. He would have attained his end as well by milder methods. He himself experienced the facility of bringing about these alterations. The women were shut up, and in some measure slaves. He called them to court, he sent them silks and fine stuffs, and made them dress like the German ladies. This sex immediately relished a manner of life which so greatly flattered their taste, their vanity, and their passions, and by their means it was relished by the men. What rendered the change the more easy was that their manners at that time were foreign to the climate, and had been introduced among them by conquest and by a mixture of nations. Peter I, in giving the manners and customs of Europe to a European nation, found a facility which he did not himself expect. The empire of the climate is the first, the most powerful, of all empires. He had then no occasion for laws to change the manners and customs of his country, it would have been sufficient to have introduced other manners and other customs. Nations are in general very tenacious of their customs, to take them away by violence is to render them unhappy, we should not therefore change them, but engage the people to make the change themselves. All punishment which is not derived from necessity is tyrannical. The law is not a mere act of power, things in their own nature indifferent are not within its province. 15. The influence of domestic government on the political. This alteration in the manners of women will doubtless have a great influence on the government of Muscovy. One naturally follows the other, the despotic power of the prince is connected with the servitude of women, the liberty of women with the spirit of monarchy. 16. How some legislators have confounded the principles which govern mankind. Manners and customs are those habits which are not established by legislators, either because they were not able or were not willing to establish them. There is this difference between laws and manners, that the laws are most adapted to regulate the actions of the subject, and manners to regulate the actions of the man. There is this difference between manners and customs, that the former principally relate to the interior conduct, the latter to the exterior. These things have been sometimes confounded. Lycurgus made the same code for the laws, manners, and customs, and the legislators of China have done the same. We ought not to be surprised that the legislators of China and Sparta should confound the laws, manners, and customs. The reason is, their manners represent their laws, and their customs their manners. The principal object which the legislators of China had in view was to make their subjects live in peace and tranquility. They would have people filled with a veneration for one another, that each should be every moment sensible of his dependence on society, and of the obligations he owed to his fellow citizens. They therefore gave rules of the most extensive civility. Thus the inhabitants of the villages of China practice amongst themselves the same ceremonies as those observed by persons of an exalted station, a very proper method of inspiring mild and gentle dispositions, of maintaining peace and good order, and of banishing all the vices which spring from an asperity of temper. In effect, would not the freeing them from the rules of civility be to search out a method for them to indulge their own humors? Civility is in this respect of more value than politeness. Politeness flatters the vices of others, and civility prevents ours from being brought to light. It is a barrier which men have placed within themselves to prevent the corruption of each other. Lycurgus, whose institutions were severe, had no regard to civility. In forming the external behavior he had a view to that warlike spirit with which he would fain inspire his people. A people who were in a continual state of discipline and instruction, and who were endued with equal simplicity and rigor, atoned by their virtues for their want of complaisance. 17. Of the peculiar quality of the Chinese government. The legislators of China went further. They confounded their religion, laws, manners, and customs. All these were morality, all these were virtue. The precepts relating to these 4 points were what they called rights, and it was in the exact observance of these that the Chinese government triumphed. They spent their whole youth in learning them, their whole life in the practice. They were taught by their men of letters, they were inculcated by the magistrates, and as they included all the ordinary actions of life, when they found the means of making them strictly observed, China was well governed. 2 things have contributed to the ease with which these rights are engraved on the hearts and minds of the Chinese. 1. The difficulty of writing, which during the greatest part of their lives wholly employs their attention, because it is necessary to prepare them to read and understand the books in which they are comprised. The other, that the ritual precepts having nothing in them that is spiritual, but being merely rules of common practice, are more adapted to convince and strike the mind than things merely intellectual. Those princes who, instead of ruling by these rights, governed by the force of punishments, wanted to accomplish that by punishments which it is not in their power to produce, that is, to give habits of morality. By punishments, a subject is very justly cut off from society, who, having lost the purity of his manners, violates the laws, but if all the world were to lose their moral habits, would these re-establish them? Punishments may be justly inflicted to put a stop to many of the consequences of the general evil, but they will not remove the evil itself. Thus when the principles of the Chinese government were discarded, and morality was banished, the state fell into anarchy, and revolutions succeeded. 18. A consequence drawn from the preceding chapter. Hence it follows that the laws of China are not destroyed by conquest. Their customs, manners, laws, and religion being the same thing, they cannot change all these at once, and as it will happen that either the conqueror or the conquered must change, in China it has always been the conqueror. For the manners of the conquering nation not being their customs, nor their customs their laws, nor their laws their religion, it has been more easy for them to conform by degrees to the vanquished people than the latter to them. There still follows hence a very unhappy consequence, which is that it is almost impossible for Christianity ever to be established in China. The vows of virginity, the assembling of women in churches, their necessary communication with the ministers of religion, their participation in the sacraments, auricular confession, extreme unction, the marriage of only one wife, all these overturn the manners and customs of the country, and with the same blow strike at their religion and laws. The Christian religion, by the establishment of charity, by a public worship, by a participation of the same sacraments, seems to demand that all should be united, while the rites of China seem to ordain that all should be separated. And as we have seen that this separation depends, in general, on the spirit of despotism, this will show us the reason why monarchies, and indeed all moderate governments, are more consistent with the Christian religion. 19. How this union of religion, laws, manners, and customs among the Chinese was effected. The principal object of government which the Chinese legislators had in view was the peace and tranquility of the empire, and subordination appeared to them as the most proper means to maintain it. Filled with this idea, they believed it their duty to inspire a respect for parents, and therefore exerted all their power to effect it. They established an infinite number of rites and ceremonies to do them honor when living, and after their death. It was impossible for them to pay such honors to deceased parents without being led to reverence the living. The ceremonies at the death of a father were more nearly related to religion, those for a living parent had a greater relation to the laws, manners, and customs. However, these were only parts of the same code, but this code was very extensive. A veneration for their parents was necessarily connected with a suitable respect for all who represented them, such as old men, masters, magistrates, and the sovereign. This respect for parents supposed a return of love towards children, and consequently the same return from old men to the young, from magistrates to those who were under their jurisdiction, and from the emperor to his subjects. This formed the rights, and these rights the general spirit of the nation. We shall now show the relation which things in appearance the most indifferent may bear to the fundamental constitution of China. This empire is formed on the plan of a government of a family. If you diminish the paternal authority, or even if you retrench the ceremonies which express your respect for it, you weaken the reverence due to magistrates, who are considered as fathers, nor would the magistrates have the same care of the people, whom they ought to look upon as their children, and that tender relation which subsists between the prince and his subjects would insensibly be lost. Retrench but one of these habits and you overturn the state. It is a thing in itself very indifferent whether the daughter-in-law rises every morning to pay such and such duties to her mother-in-law, but if we consider that these exterior habits incessantly revive an idea necessary to be imprinted on all minds, an idea that forms the ruling spirit of the empire, we shall see that it is necessary that such or such a particular action be performed. 20. Explanation of a paradox relating to the Chinese. It is very remarkable that the Chinese, whose lives are guided by rights, are nevertheless the greatest cheats upon earth. This appears chiefly in their trade, which, in spite of its natural tendency, has never been able to make them honest. He who buys of them ought to carry with him his own weights, every merchant having 3 sorts, the one heavy for buying, another light for selling, and another of the true standard for those who are upon their guard. It is possible, I believe, to explain this contradiction. The legislators of China had 2 objects in view. They were desirous that the people should be submissive and peaceful, and that they should also be laborious and industrious. By the nature of the soil and climate, their subsistence is very precarious, nor can it be in any other way secured than by industry and labor. When every one obeys, and every one is employed, the state is in a happy situation. It is necessity, and perhaps the nature of the climate, that has given to the Chinese an inconceivable greediness for gain, and laws have never been made to restrain it. Everything has been forbidden when acquired by acts of violence, everything permitted when obtained by artifice or labor. Let us not then compare the morals of China with those of Europe. Everyone in China is obliged to be attentive to what will be for his advantage. If the cheat has been watchful over his own interest, he who is the dupe ought to be attentive to his. At Sparta they were permitted to steal, in China they are suffered to deceive. 21. How the laws ought to have a relation to manners and customs. It is only singular institutions which thus confound laws, manners, and customs, things naturally distinct and separate, but though they are in themselves different, there is nevertheless a great relation between them. Solon being asked if the laws he had given to the Athenians were the best, he replied, I have given them the best they were able to bear, a fine expression that ought to be perfectly understood by all legislators. When divine wisdom said to the Jews, I have given you precepts which are not good, this signified that they had only a relative goodness, which is the sponge that wipes out all the difficulties in the law of Moses. 22. The same subject continued. When a people have pure and regular manners, their laws become simple and natural. Plato says that Rhadamanthus, who governed a nation extremely religious, finished every process with extraordinary dispatch, administering only the oath on each accusation. But, says the same Plato, when a people are not religious we should never have recourse to an oath, except he who swears is entirely disinterested, as in the case of a judge and a witness. 23. How the laws are founded on the manners of a people. At the time when the manners of the Romans were pure, they had no particular law against the embezzlement of the public money. When this crime began to appear, it was thought so infamous, that to be condemned to restore what they had taken was considered as a sufficient disgrace. For a proof of this, see the sentence of L. Scipio. 24. The same subject continued. The laws which gave the right of tutelage to the mother were most attentive to the preservation of infant's person, those which granted it the next heir were most attentive to the preservation of the state. When the manners of a people are corrupted, it is much better to give the tutelage to the mother. Among those whose laws confide in the manners of the subjects, the guardianship is granted either to the next heir or to the mother, and sometimes to both. If we reflect on the Roman laws, we shall find that the spirit of these was conformable to what I have advanced. At the time when the laws of the 12 tables were made, the manners of the Romans were most admirable. The guardianship was given to the nearest relative of the infant, from a consideration that he ought to have the trouble of the tutelage who might enjoy the advantage of possessing the inheritance. They did not imagine the life of the heir in danger though it was put into a person's hands who would reap a benefit by his death. But when the manners of Rome were changed, her legislators altered their conduct. If, in the pupillary substitution, say Gaius and Justinian, the testator is afraid that the substitute will lay any snares for the pupil, he may leave the vulgar substitution open, and put the pupillary into a part of the testament, which cannot be opened till after a certain time. These fears and precautions were unknown to the primitive Romans. 25. The same subject continued. The Roman law gave the liberty of making presents before marriage, after the marriage they were not allowed. This was founded on the manners of the Romans, who were led to marriage only by frugality, simplicity, and modesty, but might suffer themselves to be seduced by domestic cares, by complacency, and the constant tenor of conjugal felicity. A law of the Visigoths forbade the man giving more to the woman he was to marry than the 10th part of his substance, and his giving her anything during the first year of their marriage. This also took its rise from the manners of the country. The legislators were willing to put a stop to that Spanish ostentation which only led them to display an excessive liberality in acts of magnificence. The Romans by their laws put a stop to some of the inconveniences which arose from the most durable empire in the world, that of virtue. The Spaniards, by theirs, would prevent the bad effects of a tyranny the most frail and transitory, that of beauty. 26. The same subject continued. The law of Theodosius and Valentinian drew the causes of repudiation from the ancient manners and customs of the Romans. It placed in the number of these causes the behavior of the husband who beat his wife in a manner that disgraced the character of a free-born woman. This cause was omitted in the following laws, for their manners, in this respect, had undergone a change, the Eastern customs having banished those of Europe. The first eunuch of the Empress, wife to Justinian II, threatened, says the historian, to chastise her in the same manner as children are punished at school. Nothing but established manners, or those which they were seeking to establish, could raise even an idea of this kind. We have seen how the laws follow the manners of a people, let us now observe how the manners follow the laws. 27. How the laws contribute to form the manners, customs, and character of a nation. The customs of an enslaved people are a part of their servitude, those of a free people are a part of their liberty. I have spoken in the 11th book of a free people, and have given the principles of their constitution. Let us now see the effects which follow from this liberty, the character it is capable of forming, and the customs which naturally result from it. I do not deny that the climate may have produced a great part of the laws, manners, and customs of this nation, but I maintain that its manners and customs have a close connection with its laws. As there are in this state two visible powers, the legislative and executive, and as every citizen has a will of his own, and may at pleasure assert his independence, most men have a greater fondness for one of these powers than for the other, and the multitude have commonly neither equity nor sense enough to show an equal affection to both. And as the executive power, by disposing of all employments, may give great hopes, and no fears, every man who obtains any favor from it is ready to espouse its cause, while it is liable to be attacked by those who have nothing to hope from it. All the passions being unrestrained, hatred, envy, jealousy, and an ambitious desire of riches and honors, appears in their extent. Were it otherwise, the state would be in the condition of a man weakened by sickness, who is without passions because he is without strength. The hatred which arises between the two parties will always subsist, because it will always be impotent. These parties being composed of freemen, if the one becomes too powerful for the other, as a consequence of liberty, this other is depressed, while the citizens take the weaker side with the same readiness as the hands lend their assistance to remove the infirmities and disorders of the body. Every individual is independent, and being commonly led by caprice and humor, frequently changes parties. He abandons one where he left all his friends, to unite himself to another in which he finds all his enemies, so that in this nation it frequently happens that the people forget the laws of friendship, as well as those of hatred. The sovereign is here in the same case with a private person, and against the ordinary maxims of prudence is frequently obliged to give his confidence to those who have most offended him, and to disgrace the men who have best served him. He does that by necessity which other princes do by choice. As we are afraid of being deprived of the blessing we already enjoy, and which may be disguised and misrepresented to us, and as fear always enlarges objects, the people are uneasy under such a situation, and believe themselves in danger, even in those moments when they are most secure. As those who with the greatest warmth oppose the executive power dare not avow the self-interested motives of their opposition, so much the more do they increase the terrors of the people, who can never be certain whether they are in danger or not. But even this contributes to make them avoid the real dangers, to which they may, in the end, be exposed. But the legislative body, having the confidence of the people, and being more enlightened than they, may calm their uneasiness, and make them recover from the bad impressions they have entertained. This is the great advantage which this government has over the ancient democracies, in which the people had an immediate power, for when they were moved and agitated by the orators, these agitations always produced their effect. But when an impression of terror has no certain object, it produces only clamor and abuse. It has, however, this good effect, that it puts all the springs of government into motion, and fixes the attention of every citizen. But if it arises from a violation of the fundamental laws, it is sullen, cruel, and produces the most dreadful catastrophes. Soon we should see a frightful calm, during which every one would unite against that power which had violated the laws. If, when the uneasiness proceeds from no certain object, some foreign power should threaten the state, or put its prosperity or its glory in danger, the little interests of party would then yield to the more strong and binding, and there would be a perfect coalition in favor of the executive power. But if the disputes were occasioned by a violation of the fundamental laws, and a foreign power should appear, there would be a revolution that would neither alter the constitution nor the form of government. For a revolution formed by liberty becomes a confirmation of liberty. A free nation may have a deliverer, a nation enslaved can have only another oppressor. For whoever is able to dethrone an absolute prince has a power sufficient to become absolute himself. As the enjoyment of liberty, and even its support and preservation, consists in every man's being allowed to speak his thoughts, and to lay open his sentiments, a citizen in this state will say or write whatever the laws do not expressly forbid to be said or written. A people like this, being always in a ferment, are more easily conducted by their passions than by reason, which never produces any great effect in the mind of man. It is therefore easy for those who govern to make them undertake enterprises contrary to their true interest. This nation is passionately fond of liberty, because this liberty is real, and it is possible for it, in its defense, to sacrifice its wealth, its ease, its interest, and to support the burden oft heaviest taxes, even such as a despotic prince durst not lay upon his subjects. But as the people have a certain knowledge of the necessity of submitting to those taxes, they pay them from the well-founded hope of their discontinuance. Their burdens are heavy, but they do not feel their weight, whilst in other states the uneasiness is infinitely greater than the evil. This nation must therefore have a fixed and certain credit, because it borrows of itself and pays itself. It is possible for it to undertake things above its natural strength, and employ against its enemies immense sums of fictitious riches, which the credit and nature of the government may render real. To preserve its liberty, it borrows of its subjects, and the subjects, seeing that its credit would be lost if ever it were conquered, have a new motive to make fresh efforts in defense of its liberty. This nation, inhabiting an island, is not fond of conquering, because it would be weakened by distant conquests, especially as the soil of the island is good, for it has then no need of enriching itself by war, and as no citizen is subject to another, each sets a greater value on his own liberty than on the glory of one or any number of citizens. Military men are there regarded as belonging to a profession which may be useful but is often dangerous, and as men whose very services are burdensome to the nation. Civil qualifications are therefore more esteemed than the military. This nation, which liberty and the laws render easy, on being freed from pernicious prejudices, has become a trading people, and as it has some of those primitive materials of trade out of which are manufactured such things as from the artist's hand receive a considerable value, it has made settlements proper to procure the enjoyment of this gift of heaven in its fullest extent. As this nation is situated towards the north, and has many superfluous commodities, it must want also a great amount of merchandise which its climate will not produce. It has therefore entered into a great and necessary intercourse with the southern nations, and making choice of those states whom it is willing to favor with an advantageous commerce, it enters into such treaties with the nation it has chosen as are reciprocally useful to both. In a state where, on the one hand, the opulence is extreme, and on the other the taxes are excessive, they are hardly able to live on a small fortune without industry. Many, therefore, under a pretense of traveling, or of health, retire from among them, and go in search of plenty, even to the countries of slavery. A trading nation has a prodigious number of little particular interests, it may then injure or be injured in an infinite number of ways. Thus it becomes immoderately jealous, and is more afflicted at the prosperity of others than it rejoices at its own. And its laws, otherwise mild and easy, may be so rigid with respect to the trade and navigation carried on with it, that it may seem to trade only with enemies. If this nation sends colonies abroad, it must rather be to extend its commerce than its dominion. As men are fond of introducing into other places what they have established among themselves, they have given the people of the colonies their own form of government, and this government carrying prosperity along with it, they have raised great nations in the forests they were sent to inhabit. Having formerly subdued a neighboring nation, which by its situation, the goodness of its ports, and the nature of its products, inspires it with jealousy. Though it has given this nation its own laws, yet it holds it in great dependence, the subjects there are free and the state itself in slavery. The conquered state has an excellent civil government, booties oppressed by the law of nations. Laws are imposed by one country on the other, and these are such as render its prosperity precarious and dependent on the will of a master. The ruling nation inhabiting a large island, and being in possession of a great trade, has with extraordinary ease grown powerful at sea, and as the preservation of its liberties requires that it should have neither strongholds nor fortresses nor land forces, it has occasion for a formidable navy to defend it against invasions, a navy which must be superior to that of all other powers, who, employing their treasures in wars on land, have not sufficient for those at sea. The empire of the sea has always given those who have enjoyed it a natural pride, because thinking themselves capable of extending their insults wherever they please, they imagine that their power is as boundless as the ocean. This nation has a great influence in the affairs of its neighbors, for as its power is not employed in conquests, its friendship is more courted, and its resentment more dreaded, than could naturally be expected from the inconstancy of its government, and its domestic divisions. Thus it is the fate of the executive power to be almost always disturbed at home and respected abroad. Should this nation on some occasions become the center of the negotiations of Europe, probity and good faith would be carried to a greater height than in other places, because the ministers being frequently obliged to justify their conduct before a popular council, their negotiations could not be secret, and they would be forced to be, in this respect, a little more honest. Besides, as they would in some sort be answerable for the events which an irregular conduct might produce, the surest, the safest way for them would be to take the straightest path. If the nobles were formerly possessed of an immoderate power, and the monarch had found the means of abasing them by raising the people, the point of extreme servitude must have been that between humbling the nobility and that in which the people began to feel their power. Thus this nation, having been formerly subject to an arbitrary power, on many occasions preserves the style of it, in such a manner as to let us frequently see upon the foundation of a free government the form of an absolute monarchy. With regard to religion, as in this state every subject has a free will, and must consequently be either conducted by the light of his own mind or by the caprice of fancy, it necessarily follows that every one must either look upon all religion with indifference, by which means they are led to embrace the established religion, or they must be zealous for religion in general, by which means the number of sects is increased. It is not impossible but that in this nation there may be men of no religion, who would not, however, bear to be obliged to change that which they would choose, if they cared to choose any, for they would immediately perceive that their lives and fortunes are not more peculiarly theirs than their manner of thinking, and that whoever would deprive them of the one might even with better reason take away the other. If, among the different religions, there is one that has been attempted to be established by methods of slavery, it must there be odious, because as we judge of things by the appendages we join with them, it could never present itself to the mind in conjunction with the idea of liberty. The laws against those who profess this religion could not, however, be of the sanguinary kind, for liberty can never inflict such punishments, but they may be so rigorous as to do all the mischief that can be done in cold blood. It is possible that 1,000 circumstances might concur to give the clergy so little credit, that other citizens may have more. Therefore, instead of a separation, they have chosen rather to support the same burdens as the laity, and in this respect to make only one body with them, but as they always seek to conciliate the respect of the people, they distinguish themselves by a more retired life, a conduct more reserved, and a greater purity of manners. The clergy not being able to protect religion, nor to be protected by it, only seek to persuade, their pens therefore furnish us with excellent works in proof of a revelation and of the providence of the Supreme Being. Yet state prevents the sitting off their assemblies, and does not suffer them to correct their own abuses. It chooses thus, through a caprice of liberty, rather to leave their reformation imperfect than to suffer the clergy to be the reformers. Those dignities which make a fundamental part of the Constitution are more fixed than elsewhere, but, on the other hand, the great in this country of liberty are nearer upon a level with the people, their ranks are more separated, and their persons more confounded. As those who govern have a power which, in some measure, has need of fresh vigor every day, they have a greater regard for such as are useful to them than for those who only contribute to their amusement. We see, therefore, fewer courtiers, flatterers, and parasites, in short, fewer of all those who make their own advantage of the folly of the great. Men are less esteemed for frivolous talents and attainments than for essential qualities, and of this kind there are but two, riches and personal merit. They enjoy a solid luxury, founded, not on the refinements of vanity, but on that of real wants. They ask nothing of nature but what nature can bestow. The rich enjoy a great superfluity of fortune, and yet have no relish for frivolous amusements. Thus, many having more wealth than opportunities of expense, employ it in a fantastic manner. In this nation they have more judgment than taste. As they are always employed about their own interest, they have not that politeness which is founded on indolence, and they really have not leisure to attain it. The era of Roman politeness is the same as that of the establishment of arbitrary power. An absolute government produces indolence, and this gives birth to politeness. The more people there are in a nation who require circumspect behavior, and care not to displease, the more there is of politeness. But it is rather the politeness of morals than that of manners which ought to distinguish us from barbarous nations. In a country where every man has, in some sort, a share in the administration of the government, the women ought scarcely to live with the men. They are therefore modest, that is, timid, and this timidity constitutes their virtue, whilst the men without a taste for gallantry plunge themselves into a debauchery, which leaves them at leisure, and in the enjoyment of their full liberty. Their laws not being made for one individual more than another, each considers himself a monarch, and, indeed, the men of this nation are rather confederates than fellow subjects. As the climate has given many persons a restless spirit and extended views, in a country where the Constitution gives every man a share in its government and political interests, conversation generally turns upon politics, and we see men spend their lives in the calculation of events which, considering the nature of things and the caprices of fortune, or rather of men, can scarcely be thought subject to the rules of calculation. In a free nation it is very often a matter of indifference whether individuals reason well or ill. It is sufficient that they do reason, hence springs that liberty which is a security from the effects of these reasonings. But in a despotic government, it is equally pernicious whether they reason well or ill. Their reasoning is alone sufficient to shock the principle of that government. Many people who have no desire of pleasing abandon themselves to their own particular humor, and most oft those who have wit and ingenuity are ingenious in tormenting themselves. Filled with contempt or disgust for all things, they are unhappy amidst all the blessings that can possibly contribute to promote their felicity. As no subject fears another, the whole nation is proud, for the pride of kings is founded only on their independence. Free nations are haughty, others may more properly be called vain. But as these men who are naturally so proud live much by themselves, they are commonly bashful when they appear among strangers, and we frequently see them behave for a considerable time with an odd mixture of pride and ill-placed shame. The character of the nation is more particularly discovered in their literary performances, in which we find the men of thought and deep meditation. As society gives us a sense of the ridicule of mankind, retirement renders us more fit to reflect on the folly of vice. Their satirical writings are sharp and severe, and we find among them many juveniles, without discovering one. Horace. In monarchies extremely absolute, historians betray the truth, because they are not at liberty to speak it. In states remarkably free, they betray the truth, because of their liberty itself, which always produces divisions, every one becoming as great a slave to the prejudices of his faction as he could be in a despotic state. Their poets have more frequently an original rudeness of invention than that particular kind of delicacy which springs from taste, we there find something which approaches nearer to the bold strength of a Michelangelo than to the softer graces of a Raphael. Book 20. Of Laws in Relation to Commerce, considered in its nature and distinctions. 1. Of Commerce. The following subjects deserve to be treated in a more extensive manner than the nature of this work will permit. Fain would I glide down a gentle river, but I am carried away by a torrent. Commerce is a cure for the most destructive prejudices, for it is almost a general rule that wherever we find agreeable manners, there commerce flourishes, and that wherever there is commerce, there we meet with agreeable manners. Let us not be astonished, then, if our manners are now less savage than formerly. Commerce has everywhere diffused a knowledge of the manners of all nations, these are compared one with another, and from this comparison arise the greatest advantages. Commercial laws, it may be said, improve manners for the same reason that they destroy them. They corrupt the purest morals. This was the subject of Plato's complaints, and we every day see that they polish and refine the most barbarous. 2. Of the spirit of commerce. Peace is the natural effect of trade. Two nations who traffic with each other become reciprocally dependent, for if one has an interest in buying, the other has an interest in selling, and thus their union is founded on their mutual necessities. But if the spirit of commerce unites nations, it does not in the same manner unite individuals. We see that in countries where the people move only by the spirit of commerce, they make a traffic of all the humane, all the moral virtues, the most trifling things, those which humanity would demand, are there done, or there given, only for money. The spirit of trade produces in the mind of a man a certain sense of exact justice, opposite, on the one hand, to robbery, and on the other to those moral virtues which forbid our always adhering rigidly to the rules of private interest, and suffer us to neglect this for the advantage of others. The total privation of trade, on the contrary, produces robbery, which Aristotle ranks in the number of means of acquiring, yet it is not at all inconsistent with certain moral virtues. Hospitality, for instance, is most rare in trading countries, while it is found in the most admirable perfection among nations of vagabonds. It is a sacrilege, says Tacitus, for a German to shut his door against any man whomsoever, whether known or unknown. He who has behaved with hospitality to a stranger goes to show him another house where this hospitality is also practiced, and he is there received with the same humanity. But when the Germans had founded kingdoms, hospitality had become burdensome. This appears by two laws of the Code of the Burgundians, one of which inflicted a penalty on every barbarian who presumed to show a stranger the house of a Roman, and the other decreed that whoever received a stranger should be indemnified by the inhabitants, every one being obliged to pay his proper proportion. 3. Of the poverty of the people. There are two sorts of poor, those who are rendered such by the severity of government. These are, indeed, incapable of performing almost any great action, because their indigence is a consequence of their slavery. Others are poor, only because they either despise or know not the conveniences of life, and these are capable of accomplishing great things, because their poverty constitutes a part of their liberty. 4. Of commerce in different governments. Trade has some relation to forms of government. In a monarchy, it is generally founded on luxury, and though it be also founded on real wants, yet the principal view with which it is carried on is to procure everything that can contribute to the pride, the pleasure, and the capricious whims of the nation. In republics, it is commonly founded on economy. Their merchants, having an eye to all the nations of the earth, bring from one what is wanted by another. It is thus that the republics of Tyre, Carthage, Athens, Marseilles, Florence, Venice, and Holland engaged in commerce. This kind of traffic has a natural relation to a republican government, to monarchies it is only occasional. For as it is founded on the practice of gaining little, and even less than other nations, and of remedying this by gaining incessantly, it can hardly be carried on by a people swallowed up in luxury, who spend much, and see nothing but objects of grandeur. Cicero was of this opinion, when he so justly said, I do not like that the same people should be at once both the lords and factors of the whole earth. For this would, indeed, be to suppose that every individual in the state, and the whole state collectively, had their heads constantly filled with grand views, and at the same time with small ones, which is a contradiction. Not but that the most noble enterprises are completed also in those states which subsist by economical commerce, they have even an intrepidity not to be found in monarchies. And the reason is this: one branch of commerce leads to another, the small to the moderate to the great. Thus he who has gratified his desire of gaining a little raises himself to a situation in which he is not less desirous of gaining a great deal. Besides, the grand enterprises of merchants are always necessarily connected with the affairs of the public. But, in monarchies, these public affairs give as much distrust to the merchants as in free states they appear to give safety. Great enterprises, therefore, in commerce are not for monarchical, but for republican, governments. In short, an opinion of greater certainty, as to the possession of property in these states, makes them undertake everything. They flatter themselves with the hopes of receiving great advantages from the smiles of fortune, and thinking themselves sure of what they have already acquired, they boldly expose it in order to acquire more, risking nothing, but as the means of obtaining. I do not pretend to say that any monarchy is entirely excluded from an economical commerce, but of its own nature it has less tendency towards it. Neither do I mean that the republics with which we are acquainted are absolutely deprived of the commerce of luxury, but it is less connected with their constitution. With regard to a despotic state, there is no occasion to mention it. A general rule: a nation in slavery labors more to preserve than to acquire; a free nation, more to acquire than to preserve. 5. Of nations that have entered into an economical commerce. Marseilles, a necessary retreat in the midst of a tempestuous sea. Marseilles, a harbour which all the winds, the shelves of the sea, the disposition of the coasts, point out for a landing place, became frequented by mariners, while the sterility of the adjacent country determined the citizens to an economical commerce. It was necessary that they should be laborious to supply what nature had refused, that they should be just, in order to live among barbarous nations, from whom they were to derive their prosperity, that they should be moderate, to the end that they might always taste the sweets of a tranquil government, in fine that they should be frugal in their manners to enable them to subsist by trade, a trade the more certain as it was less advantageous. We everywhere see violence and oppression give birth to a commerce founded on economy, while men are constrained to take refuge in marshes, in isles, in the shallows of the sea, and even on rocks themselves. Thus it was that Tyre, Venice, and the cities of Holland were founded. Fugitives found there a place of safety. It was necessary that they should subsist; they drew, therefore, their subsistence from all parts of the world. 6. Some effects of an extensive navigation. It sometimes happens that a nation, when engaged in an economical commerce, having need of the merchandise of one country, which serves as a capital or stock for procuring the commodities of another, is satisfied with making very little profit, and frequently none at all, in trading with the former, in expectation of gaining greatly by the latter. Thus, when the Dutch were almost the only nation that carried on the trade from the south to the north of Europe, the French wines which they imported to the north were in some measure only a capital or stock for conducting their commerce in that part of the world. It is a known fact that there are some kinds of merchandise in Holland which, though imported from afar, sell for very little more than they cost upon the spot. They account for it thus: a captain who has occasion to ballast his ship will load it with marble; if he wants wood for stowage, he will buy it, and, provided he loses nothing by the bargain, he will think himself a gainer. Thus it is that Holland has its quarries and its forests. Further, it may happen so that not only a commerce which brings in nothing shall be useful, but even a losing trade shall be beneficial. I have heard it affirmed in Holland that the whale fishery in general does not answer the expense, but it must be observed that the persons employed in building the ships, as also those who furnish the rigging and provisions, are jointly concerned in the fishery. Should they happen to lose in the voyage, they have had a profit in fitting out the vessel. This commerce, in short, is a kind of lottery, and every one is allured with the hopes of a prize. Mankind are generally fond of gaming, and even the most prudent have no aversion to it, when the disagreeable circumstances attending it, such as dissipation, anxiety, passion, loss of time, and even of life and fortune, are concealed from their view. 7. The spirit of England with respect to commerce. The tariff or customs of England are very unsettled with respect to other nations. They are changed, in some measure, with every parliament, either by taking off particular duties, or by imposing new ones. They endeavour by these means still to preserve their independence. Supremely jealous with respect to trade, they bind themselves but little by treaties, and depend only on their own laws. Other nations have made the interests of commerce yield to those of politics. The English, on the contrary, have ever made their political interests give way to those of commerce. They know better than any other people upon earth how to value, at the same time, these three great advantages: religion, commerce, and liberty. 8. In what manner economical commerce has been sometimes restrained. In several kingdoms laws have been made extremely proper to humble the states that have entered into economical commerce. They have forbidden their importing any merchandise, except the product of their respective countries, and have permitted them to traffic only in vessels built in the kingdom to which they brought their commodities. It is necessary that the kingdom which imposes these laws should itself be able easily to engage in commerce, otherwise it will, at least, be an equal sufferer. It is much more advantageous to trade with a commercial nation, whose profits are moderate, and who are rendered in some sort dependent by the affairs of commerce, with a nation whose larger views and whose extended trade enables them to dispose of their superfluous merchandise, with a wealthy nation, who can take off many of their commodities, and make them a quicker return in specie, with a nation under a kind of necessity to be faithful, pacific from principle, and that seeks to gain, and not to conquer. It is much better, I say, to trade with such a notion than with others, their constant rivals, who will never grant such great advantages. 9. Of the prohibition of commerce. It is a true maxim that one nation should never exclude another from trading with it, except for very great reasons. The Japanese trade only with two nations, the Chinese and the Dutch. The Chinese gain 1,000% upon sugars, and sometimes as much by the goods they take in exchange. The Dutch make nearly the same profits. Every nation that acts upon Japanese principles must necessarily be deceived, for it is competition which sets a just value on merchandise, and establishes the relation between them. Much less ought a state to lay itself under an obligation of selling its manufactures only to a single nation, under a pretense of their taking all at a certain price. The Poles, in this manner, dispose of their corn to the city of Danzig, and several Indian princes have made a like contract for their spices with the Dutch. These agreements are proper only for a poor nation, whose inhabitants are satisfied to forego the hopes of enriching themselves, provided they can be secure of a certain subsistence, or for nations whose slavery consists either in renouncing the use of those things which nature has given them, or in being obliged to submit to a disadvantageous commerce. 10. An institution adapted to economical commerce. In states that carry on an economical commerce they have luckily established banks, which by their credit have formed a new species of wealth, but it would be quite wrong to introduce them into governments whose commerce is founded only on luxury. The erecting of banks in countries governed by an absolute monarch supposes money on the one side, and on the other power, that is, on the one hand the means of procuring everything, without any power, and on the other, the power, without any means of procuring at all. In a government of this kind, none but the prince ever had, or can have, a treasure, and wherever there is one, it no sooner becomes great than it becomes the treasure of the prince. For the same reason, all associations of merchants, in order to carry on a particular commerce, are seldom proper in absolute governments. The design of these companies is to give to the wealth of private persons the weight of public riches. But in those governments this weight can be found only in the prince. Nay, they are not even always proper in states engaged in economical commerce, for, if the trade be not so great as to surpass the management of particular persons, it is much better to leave it open than, by exclusive privileges, to restrain the liberty of commerce. 11. The same subject continued. A free port may be established in the dominions of states whose commerce is economical. That economy in the government which always attends the frugality of individuals is, if I may so express myself, the soul of its economical commerce. The loss it sustains with respect to customs it can repair by drawing from the wealth and industry of the republic. But in a monarchy a step of this kind must be opposite to reason, for it could have no other effect than to ease luxury of the weight of taxes. This would be depriving itself of the only advantage that luxury can procure, and of the only curb which, in a constitution like this, it is capable of receiving. 12. Of the freedom of commerce. The freedom of commerce is not a power granted to the merchants to do what they please, this would be more properly its slavery. The constraint of the merchant is not the constraint of commerce. It is in the freest countries that the merchant finds innumerable obstacles, and he is never less crossed by laws than in a country of slaves. England prohibits the exportation of her wool, coals must be brought by sea to the capital, no horses, except geldings, are allowed to be exported, and the vessels of her colonies trading to Europe must take in water in England. The English constrain the merchant, but it is in favor of commerce. 13. What it is that destroys this liberty? Wherever commerce subsists, customs are established. Commerce is the exportation and importation of merchandise, with a view to the advantage of the state. Customs are a certain right over this same exportation and importation, founded also on the advantage of the state. Hence it becomes necessary that the state should be neutral between its customs and its commerce, that neither of these two interfere with each other, and then the inhabitants enjoy a free commerce. The farming of the customs destroys commerce by its injustice and vexations, as well as by the excess of the imposts, but independent of this, it destroys it even more by the difficulties that arise from it, and by the formalities it exacts. In England, where the customs are managed by the king's officers, business is negotiated with a singular dexterity, one word of writing accomplishes the greatest affairs. The merchant needs not lose an infinite deal of time, he has no occasion for a particular commissioner, either to obviate all the difficulties of the farmers, or to submit to them. 14. The laws of commerce concerning the confiscation of merchandise. The Magna Carta of England forbids the seizing and confiscating, in case of war, the effects of foreign merchants, except by way of reprisals. It is an honor to the English nation that they have made this one of the articles of their liberty. In the late war between Spain and England, the former made a law which punished with death those who brought English merchandise into the dominions of Spain, and the same penalty on those who carried Spanish merchandise into England. An ordinance like this cannot, I believe, find a precedent in any laws but those of Japan. It equally shocks humanity, the spirit of commerce, and the harmony which ought to subsist in the proportion of penalties. It confounds all our ideas, making that a crime against the state which is only a violation of civil polity. 15. Of seizing the persons of merchants. Solon made a law that the Athenians should no longer seize the body for civil debts. This law he received from Egypt. It had been made by Bocchorus, and renewed by Sesostris. This law is extremely good with respect to the generality of civil affairs, but there is sufficient reason for its not being observed in those of commerce. For as merchants are obliged to entrust large sums, frequently for a very short time, and to pay money as well as to receive it, there is a necessity that the debtor should constantly fulfill his engagements at the time prefixed, and hence it becomes necessary to lay a constraint on his person. In affairs relating to common civil contracts, the law ought not to permit the seizure of the person, because the liberty of one citizen is of greater importance to the public than the ease or prosperity of another. But in conventions derived from commerce, the law ought to consider the public prosperity as of greater importance than the liberty of a citizen, which, however, does not hinder the restrictions and limitations that humanity and good policy demand. 16. An excellent law. Admirable is that law of Geneva which excludes from the magistracy, and even from the admittance into the Great Council, the children of those who have lived or died insolvent, except they have discharged their father's debts. It has this effect: it creates a confidence in the merchants, in the magistrates, and in the city itself. There the credit of the individual has still all the weight of public credit. 17. A law of Rhodes. The inhabitants of Rhodes went further. Sextus Empiricus observes that among those people a son could not be excused from paying his father's debts by renouncing the succession. This law of Rhodes was calculated for a republic founded on commerce. Now I am inclined to think that reasons drawn from commerce itself should make this limitation, that the debts contracted by the father since the son's entering into commerce should not affect the estate or property acquired by the latter. A merchant ought always to know his obligations, and to square his conduct by his circumstances and present fortune. 18. Of the judges of commerce. Xenophon, in his Book of Revenues, would have rewards given to those overseers of commerce who dispatched the causes brought before them with the greatest expedition. He was sensible of the need of our modern jurisdiction of a consul. The affairs of commerce are but little susceptible of formalities. They are the actions of a day, and are every day followed by others of the same nature. Hence it becomes necessary that every day they should be decided. It is otherwise with those actions of life which have a principal influence on futurity, but rarely happen. We seldom marry more than once, deeds and wills are not the work of every day, we are but once of age. Plato says that in a city where there is no maritime commerce there ought not to be above half the number of civil laws. This is very true. Commerce brings into the same country different kinds of people, it introduces also a great number of contracts and species of wealth, with various ways of acquiring it. Thus in a trading city there are fewer judges, and more laws. 19. That a prince ought not to engage himself in commerce. Theophilus, seeing a vessel laden with merchandise for his wife Theodora, ordered it to be burned. "I am emperor," said he, "and you make me the master of a galley. By what means shall these poor men gain a livelihood if we take their trade out of their hands?" He might have added, "Who shall set bounds to us if we monopolize all ourselves? Who shall oblige us to fulfill our engagements? Our courtiers will follow our example, they will be more greedy and more unjust than we, the people have some confidence in our justice, they will have none in our opulence. All these numerous duties, the cause of their wants, are certain proofs of ours." 20. The same subject continued. When the Portuguese and Castilians bore sway in the East Indies, commerce had such opulent branches that their princes did not fail to seize them. This ruined their settlements in those parts of the world. The Viceroy of Goa granted exclusive privileges to particular persons. The people had no confidence in these men, and the commerce declined. By the perpetual change of those to whom it was entrusted, nobody took care to improve it, or to leave it entire to his successor. In short, the profit centered in a few hands, and was not sufficiently extended. 21. Of the commerce of the nobility in a monarchy. In a monarchical government, it is contrary to the spirit of commerce that any of the nobility should be merchants. This, said the emperors Honorius and Theodosius, would be pernicious to cities, and would remove the facility of buying and selling between the merchants and the plebeians. It is contrary to the spirit of monarchy to admit the nobility into commerce. The custom of suffering the nobility of England to trade is one of those things which has there mostly contributed to weaken the monarchical government. 22. A singular reflection. Persons struck with the practice of some states imagine that in France they ought to make laws to engage the nobility to enter into commerce. But these laws would be the means of destroying the nobility, without being of any advantage to trade. The practice of this country is extremely wise. Merchants are not nobles, though they may become so. They have the hopes of obtaining a degree of nobility, unattended with its actual inconveniences. There is no surer way of being advanced above their profession than to manage it well, or with success, the consequence of which is generally an affluent fortune. Laws which oblige every one to continue in his profession, and to devolve it upon his children, neither are nor can be of use in any but despotic kingdoms, where nobody either can or ought to have emulation. Let none say that every one will succeed better in his profession when he cannot change it for another. I say that a person will succeed best when those who have excelled hope to rise to another. The possibility of purchasing honor with gold encourages many merchants to put themselves in circumstances by which they may attain it. I do not take it upon me to examine the justice oft has bartering for money the price of virtue. There are governments where this may be very useful. In France the dignity oft long robe, which places those who wear it between the great nobility and the people, and without having such shining honors as the former, has all their privileges, a dignity which, while this body, the depositary of the laws, is encircled with glory, leaves the private members in a mediocrity of fortune, a dignity in which there are no other means of distinction but by a superior capacity and virtue, yet which still leaves in view one much more illustrious, they warlike nobility, likewise, who conceive that, whatever degree of wealth they are possessed of, they may still increase their fortunes, who are ashamed of augmenting, if they begin not with dissipating, their estates, who always serve their prince with their whole capital stock, and when that is sunk make room for others, who follow their example, who take the field that they may never be reproached with not having been there, who, when they can no longer hope for riches, live in expectation of honors. And when they have not obtained the latter, enjoy the consolation of having acquired glory. All these things together have necessarily contributed to augment the grandeur of this kingdom, and if for 2 or 3 centuries it has been incessantly increasing in power, this must be attributed not to fortune, who was never famed for constancy, but to the goodness of its laws. 23. To what nations commerce is prejudicial? Riches consist either in lands or in movable effects. The soil of every country is commonly possessed by the natives. The laws of most states render foreigners unwilling to purchase their lands, and nothing but the presence of the owner improves them. This kind of riches, therefore, belongs to every state in particular, but movable effects, as money, notes, bills of exchange, stocks in companies, vessels, and, in fine, all merchandise, belong to the whole world in general. In this respect, it is composed of but one single state, of which all the societies upon earth are members. The people who possess more of these movable effects than any other on the globe are the most opulent. Some states have an immense quantity acquired by their commodities, by the labor of their mechanics, by their industry, by their discoveries, and even by chance. The avarice of nations makes them quarrel for the movables of the whole universe. If we could find a state so unhappy as to be deprived of the effects of other countries, and at the same time of almost all its own, the proprietors of the lands would be only planters to foreigners. This state, wanting all, could acquire nothing. Therefore, it would be much better for the inhabitants not to have the least commerce with any nation upon earth, for commerce in these circumstances must necessarily lead them to poverty. A country that constantly exports fewer manufactures or commodities than it receives will soon find the balance sinking. It will receive less and less, until, falling into extreme poverty, it will receive nothing at all. In trading countries the specie, which suddenly vanishes, quickly returns, because those nations that have received it are its debtors. But it never returns into those states of which we have just been speaking, because those who have received it owe them nothing. Poland will serve us for an example. It has scarcely any of those things which we call the movable effects of the universe, except corn, the produce of its lands. Some of the lords possess entire provinces. They oppress the husbandmen, in order to have greater quantities of corn, which they send to strangers, to procure the superfluous demands of luxury. If Poland had no foreign trade, its inhabitants would be happier. The grandees, who would have only their corn, would give it to their peasants for subsistence. As their too extensive estates would become burdensome, they would divide them among their peasants. Every one would find skins or wool in their herds or flocks, so that they would no longer be at an immense expense in providing clothes. The great, who are ever fond of luxury, not being able to find it but in their own country, would encourage the labor of the poor. This nation, I affirm, would then become more flourishing, at least if it did not become barbarous, and this the laws might easily prevent. Let us next consider Japan. The vast quantity of what they receive is the cause of the vast quantity of merchandise they send abroad. Things are thus in as nice an equilibrium as if the importation and exportation were but small. Besides, this kind of exuberance in the state is productive of 1,000 advantages. There is a greater consumption, a greater quantity of those things on which the arts are exercised, more men employed, and more numerous means of acquiring power. Exigencies may also happen that require a speedy assistance, which so opulent a state can better afford than any other. It is difficult for a country to avoid having superfluities, but it is the nature of commerce to render the superfluous useful, and the useful necessary. The state will be, therefore, able to afford necessaries to a much greater number of subjects. Let us say, then, that it is not those nations who have need of nothing that must lose by trade, it is those who have need of everything. It is not such people as have a sufficiency within themselves, but those who are most in want, that will find an advantage in putting a stop to all commercial intercourse.